Okay. Good afternoon, everyone. Hope you all had a wonderful Valentine's Day. And now we're going to get down to some real business. Today is February 15th. Welcome to Judiciary. We're going to have our first bill hearing, which will be, we'll start with Delegate Phillips, and he will introduce House Bill 458. Delegate Phillips, whenever you're ready.
Madam Vice Chair, how are you? To my colleagues, this is actually my first hearing of 2024.
We'll go easy.
Thank you. All right. Well, this is House Bill 458, and I am Delegate N. Scott Phillips from the 10th Legislative District. We're coming back to this body in the same posture as House Bill 1023 from last year. That bill was passed by this committee unanimously. It then went to the House floor and was passed by the House unanimously. Unfortunately, it didn't get the same treatment in the Senate. This year, we've positioned it differently. Once again, it's the same posture, but it had been a cross-file by Senator Charles Sidnor. For the members who are new, I will provide a brief summary of what this bill does. This bill would make the redaction of names of a minor who are victims in a criminal case or juvenile delinquency matter required. Let me say that again. It would require the redaction. Today, the redaction occurs upon request of the state's attorney or another party. In the abundance of caution, we want to protect our children. Parties who need to know the name of the child, like the defendants and others, who have a need to know, will have access. I'm going to stop there because I have a panel of witnesses that will share testimony illustrating why we need this change in our court procedure. And I should note that this then becomes consistent with federal court procedure. So I will start, if I could, I'm going to start with you, Mr. Perdomo.
Thanks very much. Madam Vice Chairman, members of the committee, thanks for the opportunity to speak today in favor of HB 458. My name is Michael Padone. I'm a Maryland attorney. The views I express today are solely my own, not those of my firm or any of its clients. First, I want to thank Delegate Phillips for his leadership sponsoring this bill again this session, and for his work last year on HB 1032 to secure a favorable recommendation from this committee and a unanimous approval in the House. And unanimous because when people understand the problem that this bill tries to solve, everyone agrees that this is a reasonable and easy way to solve it. And that problem is that there is nothing in Maryland law that requires the redaction of the names of minors who are victims of crime in court filings. Even worse, under the most egregious circumstances, when a child is a victim of a sex crime, Maryland law requires the inclusion of their name in the indictment. I refer you to Criminal Law 3317. So I was involved in a case where a 15-year-old girl was repeatedly raped by a 34-year-old man, her manager at her first part-time job. That girl said to me, "I don't want everyone at school knowing about this. I'm not pressing charges if people can find out who I am." She did press charges, and when the indictment was returned in that case, her name was all over it. She was shocked. Using common sense, she reasoned that the law couldn't possibly allow the name of a child rape victim to be plastered all over publicly available documents. And had the case been in federal court, she would have been right. So at the risk of stating the obvious, our kids are growing up today in a world where information is more readily accessible and spreads more rapidly than it ever has before. Kids today, they know how to use case search, and they know where the MDEC public kiosks are. As a result, when a kid is a victim of crime, they run a very real risk of being outed and shamed, and that's a deterrent to kids reporting crimes, and that is something that we can and should easily fix. I therefore urge the committee to issue a favorable report on HB 458. I'm happy to take any questions.
Before the next person starts, Delegate Phillips, is Vanessa Clarks Brooks here?
No, that's actually my chief of staff. I think she put my information in.
I understand. Thank you, Ms. Feinstein, I think you were getting started.
Thank you. Good afternoon, Vice Chair Bartlett, members of the committee, Debbie Feinstein. I'm with the Montgomery County State's Attorney's Office. I'm Chief of the Special Victims Division. I have just a few things to say with respect to this bill. What Mr. Padone said is exactly right. We often have to go into the charging documents and other things that are publicly facing documents and file motions to shield to keep those names out of the public's eye. In our special victims cases, our detectives have become versed in using initials, which has been satisfactory to the court rather than using the full name, but that doesn't really solve it for a child abuse victim when it's a family member, because it's easily connected back to that family member. Also, the other issue is that detectives that are not typically doing special victims cases and know to use initials, we have minor victims in all sorts of different kinds of cases, and their names are put into the charging documents routinely. And then the state has to file motions to shield, but their names are already out there. And that's really the concern of the state. Their names shouldn't be out there in public facing documents. This is a very straightforward bill, and I would urge your support.
Good afternoon, Madam Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 458. I don't want to repeat anything that's already been said other than to observe that this really is critical for survivors of sexual violence. But consider this. This bill is nowhere near as strong as the federal rule. The federal rule is stronger. In fact, I debated whether we should suggest amendments to make it as strong as the federal rule, but this is a great first step. Maryland appellate courts already omit names. So they're already doing this at the appellate level. I also just wanted to share that, like, I've handled these cases. So I worked with a case involving minors in federal court, and this is not a difficult thing. We had a whole bunch of students. They were all young kids. They had disabilities, and we'd file the document and then have a sealed attachment. I've also had a similar case in Maryland Circuit Court where we had a survivor of child sexual abuse, and we filed just 2 sets of documents. One was sealed and had the child's name, and the other had initials, and we filed it with a motion. It's really very easy to do this. So this is not a burden on the courts. It's not a burden on litigants. It is a very modest step, and it is the least we can do to help protect survivors of sexual violence. For those reasons and the reasons already stated by the other witnesses, the Maryland Coalition Against Sexual Assault asks for a favorable report, again, on House Bill 458.
Thank you for your testimony, and great job, Delegate Phillips.
Thank you very much, man.
Do we have any questions? Delegate Boucher.
Thank you, Madam Vice Chairman. I think it's a wonderful bill as well, but I'm shocked to see the Maryland Judicial Conference is against it, saying it's unnecessary and that it would be impossible for the court to determine whether or not the information could reasonably be expected to identify a minor victim without the necessary information. If you've read that, could you address that for us? Because I'm a little bit confused that the federal government does this. Why is their judiciary saying they can't? That is extremely confusing to me.
I think Ms. Jordan said it well. This is not a huge imposition on the court, but would you like to expound?
Yeah, no, thank you for the question, Delegate. I respect the judiciary, of course, and they often really want to have control over things, and they want to decide these motions, and this is taking that control away from them and saying, no, automatically we are going to protect kids. That's what the policy should be. There's really never a reason that we should be exposing kids to this sort of, public ridicule or discrimination. And if there's an unusual case where the name should be disclosed, the bill has a process for that. So the court can weigh in if they need to, and something should be disclosed. But I respect those judges. They have a lot of talents, they have a lot of skill, and I think they can figure this out.
Thanks, Delegate. So I would also add that the judiciary's opposition suggests that there's already a procedure by which this can be done. And I've tried to use that procedure, and it is complicated. It is buried in the Maryland rules. And I feel very confident saying that the average Marylander whose child might have been a victim of a crime is going to have a very difficult time figuring out what documents need to be filed and ultimately ruled on by a judge to get the outcome that this bill requires automatically.
Thank you. Delegate Embry.
Thank you, and I love this bill, but just to follow up and clarify, the judiciary's concern was they wouldn't know it was a minor, but the person filing the documents, it would be their responsibility to identify these as documents needing redaction. Is that fair to say?
That is
As in the
correct.
federal system? Great, thank you.
Thank you. That concludes the testimony for House Bill 458. Now we will hear House Bill 542, Delegate Vogel. And if you, Delegate Vogel, if you want to bring, do you have anyone you want to bring up with you? I'll start calling some names. Delora Sanchez, Robert Shear, and Erica Lamont.
Thank you, Madam Chair, and hello to the esteemed Judiciary Committee. My name is, for the record, my name is Delegate Joe Vogel. I am here with a fantastic panel in support of House Bill 542. House Bill 542 would prohibit that any child in the foster care system in the state of Maryland receive a trash bag to carry their belongings. We continue to see instances of this in the state of Maryland, and many of the folks on the sponsor testimony on the sponsor panel here today will be able to share their stories and the work they are doing to address this problem. I believe this to be a important bill, but also a very simple bill that would promote the dignity and humanity of every child in our foster care system. I know you all are working on the issue of foster care and recognize that there are many challenges facing this system. And I believe that this is a simple solution, an important solution, once again, to promote the dignity and humanity of every child in the foster care system. With that, I urge a favorable report, and we'll turn it over to Rob Shear.
Thank you. Good afternoon, everyone, and thank you for this amazing opportunity.
Mr. Shear, hold on once. There we go. Don't push the button, please. Okay, you're good now. Thank you.
Perfect. Thank you. Well, good afternoon, and thank you, everyone, for this amazing opportunity to testify for what I know is a very important bill. See, for kids in our state entering foster care and for those who are moving from placement to placement, I am actually a father of 5 kids. I'm actually the founder of an international nonprofit that for the last 11 years has tried to eliminate trash bags from kids in foster care in all 50 states, DC and Puerto Rico. I know for a fact that when my children arrived in my home, they arrived just like I arrived in foster care, carrying a trash bag. In 2019, my husband and I decided to adopt our 5th child here in the state of Maryland. And even though we have given many opportunities for agencies to use our comfort cases and our duffel bags, my son still arrived in our home carrying a trash bag. I know that people will say that this is not happening, but I know for a fact that every county in this beautiful state have received our duffels and have received our comfort cases for kids in the system. As we all gather here today, we are actually on our way to deliver 200 cases to Baltimore City today for children who have entered our foster care system. The statistics for children in our foster care system is very sad. It's heartbreaking for most, but I know that they have hope when they're not defined by the trash bag that is handed them, but by the dignity we give them when we hand them a new duffel. As of today, the state of Maryland has spent over $45 million a year in stipends, and I know that we can invest to make sure that a child is receiving hope and some dignity. I would assume that very few of you have actually even been in the foster care system, much less had to carry a trash bag. And I will also assume that every single one of you that are parents, you would never allow your child to carry a trash bag to a sleepover. Please don't pass this bill. Thank you.
Thank you. And whoever is ready to go next, if you just put the mic in front of you. Thank you.
Good afternoon, Vice Chair Bartlett and members of the Judiciary Committee. My name is Erica Lamont. I am the Advocacy Director for Children's Rights for Maryland Legal Aid. Thank you for this bill, Delegate Vogel, which serves to recognize the importance of standing up for some of our most vulnerable children in Maryland. This can improve the lives of the children that we serve. Legal aid represents thousands of children in foster care. And these children, by no fault of their own, have either been abused, neglected, or have serious mental illnesses. These children are often overlooked and take a back seat to many people, including the people, the parents that have abused or neglected them. Passing this bill contributes to letting them know that they matter, that they are important. So let's talk about my client that we'll call Javier for privacy reasons. He came from the Honduras where he watched his father be executed. And he was also targeted and needed to escape. When he was being transferred from one placement to the other, he's had several, including a failed placement with his mother. His items were transported and stuffed in trash bags, and we provided a photo of that with our written testimony for your consideration. I also have another client, let's call her Michelle. She stated to me how demoralizing it was to have her items placed in contractor trash bags when she was placed in a new placement. Most of us have dropped our kids off at college, and we would never drop them off, even in college, with trash bags, for their very important, cherished items. We would never take them on trips in trash bags. And so we would like for Maryland to treat our foster children like we would treat our own children, with dignity and respect. And therefore, Maryland Legal Aid urges for a favorable report and urges its ultimate passage. I'm sorry. And we also have a picture here for you to see. I don't know if we can zoom in on that, but this was our client's items in his very personal and items. And this tells you, kind of what you think of him.
Okay, thank you, Ms. Lamont. Ms. Effikalche? Yeah, okay, thank you so much, and I apologize for
That's
not
okay.
bringing in that in your last name when I mentioned. I'm used
That's
to
quite all right.
I'm used to Sanchez still, but
I know.
congratulations.
That's quite all right. Good afternoon, Madam Chair and members of the committee. My name is Delora Sanchez Effikalche, and I do know quite a few of you through my work down here as a lobbyist, but today I'm here in my personal capacity as a former foster care youth. I aged out of the foster care system at 18, but was placed in the foster care system when my parents passed in my adolescence. I will tell you that I did have my belongings placed in a trash bag going from home to home over 25 years ago. That has been, it was happening then. I watched my foster sisters carry their belongings in trash bags. And we always knew when a new foster child was coming to the home because there would be a set of garbage bags at the door with their belongings in it. It is something that has been occurring for quite a while, and it continues to occur. So for those of you who may say this can't be a thing, we don't need this bill, we absolutely need this bill. For young people, luggage may seem like a very trivial detail, but for a young person facing the upheaval of being removed from their home, it represents dignity, stability, and a sense of belonging. When a child must pack their belongings in a trash bag, it sends a message that they are disposable and that they are not worthy of basic respect. I remember the embarrassment and shame I felt every time I walked to a new home with nothing but my garbage bag. It reinforced the feelings of worthlessness and invisibility that many foster children experience. By supporting this legislation, you have the power to make a meaningful difference in the lives of countless foster children. You have the opportunity to send a message of compassion and dignity, showing these vulnerable young people that they are valued and deserving of respect. So thank you for considering this critical issue, and I urge a favorable report.
Thank you. Any questions? Delegate Robinson and then Delegate Kaufman.
Thank you, Madam Chair, and thank you, Delegate Vogel, for this bill. It's near and dear to my heart, to a husband that's married to a former foster child who aged out as well. I'm appreciative of this. One thing I did actually initially before running for office or during that time period was actually to do a drive of luggage and suitcases. And I think fellow Delegate Taylor, who actually helped in that effort, to raise the awareness and partnering with individuals. So I'm appreciative of this bill and do definitely understand the need for this. One question for you is, I see that the Department of Human Services raised some concern around the tracking of the luggage, which I think is a minor concern, considering the benefit it is to our youth in the system. I don't know if you've looked at that and thought of ways that we might be able to address that as far as record keeping when it comes to the luggage, as they lay out their concerns around that. Definitely want to be helpful in any way that we can in addressing those issues.
Well, thank you, Delegate. And I would look forward to working with the subcommittee and the committee to address some of those concerns. I know the fiscal note mentions using the MD Think platform for that tracking. But hope to use your expertise and the expertise of the committee to work out those challenges.
Delegate Kaufman.
Yes, and I'm sorry to call you this, but I don't remember your last name. So this question is for the newlywed. My question is, what's your name, by the way?
Ificalche.
Oh, thank you very much.
It's Sanchez Ificalche. I will answer to Sanchez because that's what everybody.
Oh,
knows.
okay. So my question is, if you look at the DHS letter that Delegate Roberson referenced, they say
Thank you.
it's a burden and it's and expensive, and it's something that they already have in place. But you've just testified that you had that experience, and the gentleman from Comfort Care said it happens all the time.
Mhm.
So where is the disconnect where the bureaucrats think they're doing this already, but on the ground it's not occurring? Where's the disconnect happening?
Right. I do think that is a question for them, but I can tell you from my own personal experience and young people that I continue to mentor in foster care, that is not the case. They are carrying their only worldly belongings in garbage bags. And it's been my experience that in instances where either myself or their foster mother or foster father has been able to get luggage for them, they don't soon let it go. So I don't know how much of a burden that might be to track these pieces of luggage or the young people that they provide it for, but I would just emphasize that these young people are wards of the state. Many times they are our young people. So I think if it is the will of this committee to pass this legislation, I think it's a worthwhile cause, and it's worth a little bit extra effort and elbow grease to ensure that these young people have luggage.
My second, and it's just a 30-second comment, but I do want to state it for the record. I wish the department was here in person. Thank you, Madam Vice Chair.
Thank you. Delegate Thomason and then Delegate Taylor.
Thank you, Madam Vice Chair. My question is for I forgot your name. Was it Rob?
Rob Shear.
Yeah. So you had talked a little, you talked a little bit about your personal story. So you said not only your children, but you as well came with sorry, I'm having trouble. Words are, as Delegate Stewart once said, Vaughn Stewart or Stewart Vaughn, words are hard. Are you, so this is, I'm not familiar with this issue. So this is something that's been going on for, generations.
So it has. I actually entered foster care in 1979 and was handed a trash bag. In 1984, I became 18 years old and I was handed another trash bag when I aged out of foster care. And I actually became a homeless kid living on the streets. I lived on the streets my entire senior year of high school. I joined the United States Navy. I made sure that the statistics that we see in children was not going to be a statistic that I was going to be in. 11 years ago, I realized that we are not doing anything for kids in our foster care system. So I gathered some very important people and I told my story, the story of the young boy who was handed a trash bag. And then I went to the agencies and I heard exactly what the gentleman said. We have no storage. We have no way to track it. So what I did was I went to the most leading luggage brand, Briggs & Riley, and I told them my story. And we were able to design what we call a Comfort XL. It is a 32-inch duffel bag that folds up to the size of a book. So do not tell me you do not have storage. What I did was make sure that the price point for this $149 bag that is a designer bag cost I have delivered over 120,000 of these throughout our country. So I personally know what this feels like by myself and our 5 children, but I also have seen the joy when a child is receiving one of these.
Delegate Taylor?
Thank you, Madam Chair. I have actually volunteered with you. I've also volunteered with Delegate Roberson to provide luggage for social services. The Willow Oak chapter of the Links and Delegate Tolles and I have volunteered to collect luggage and have delivered them to social services. I'm shocked that this is still going on. And with all the community partners that there seems to be out there, why are these kids still having to use trash bags to transport their personal items? Is that why you've asked us to track?
So I will have to tell you that this is not the first time that I've sat in front of a committee. I have had this bill passed in the state of Oregon. I've had this bill passed in the state of Texas. And I have had in the last quarter of 2023, the state of Georgia is mandated that every single child who enters our foster care system will receive one of these duffel bags and one of our comfort cases. And I will tell you the burden of tracking, our volunteers do it. We have thousands and thousands of volunteers within this beautiful state of Maryland that come to our national center, and we track all of the cases that are given out. We track by age, we track by gender, and we provide this information to the state agencies on a monthly basis. So there is no work for them to do. The only work that they must do is when a child enters foster care, they no longer open their desk drawer and pull this out, which they keep rolls of them in their desk drawer, that they actually go into their closet and they pull a comfort case XL out and they hand them that with a backpack with all the essentials for their very first night within foster care. I will add very quickly that each and every one of us must understand that children enter foster care because of a choice that someone else made. Remember that, a choice that someone else made. And it is very, very important as we put them in houses of strangers that we must understand their mindset. They need their own towel, their own lotion, their own shampoo, their own bar of soap. And at Comfort Cases, we are determined, whether you stand behind this bill or not, that I will make sure that my 5 children know that their fathers made sure that this does happen, as we have already seen it happen in other states.
Madam Chair, are there other companies like yours that do the same thing? And that's part one. And part two is, do you have different colors? Do you have maybe some with wheels? I'm kind of thinking about 10 years from now, we adopt this, right? I don't want that comfort case to signify, oh, here comes a foster child, right?
So first of all, I want to say what a great question. And there is another organization that does similar what we do on the West Coast. They only do it for children up to the age of 12. We actually provide cases from birth up to the age of 21. None of our cases are actually, we have no monograms on our cases. We do not brand anything. We have all different colors. We have all different styles. All of our pajamas are different. All of our toiletries are different. And just to let you know, we also give things in our cases such as deodorant for kids over the age of 10. And ladies, I hope you all understand, and as a father, as a beautiful daughter who I've raised her to be the queen that she will be one day, I could not imagine her being in a stranger's home at the age of 12 when she started her period. So we make sure that in our cases, we actually have feminine products as well for our young girls.
Delegate, Madam Chair, can I just briefly respond as well? Delegate, part of the reason justification for that reporting is that if you look at the testimony from the Department of Human Services, their argument is that this is already the practice. And I think I've showed this picture already, and this was from January, right? So if this is already the practice, what I would like to know, and the reason that we're requesting this reporting is, when we come back next year, the year after, to understand whether this is actually now going to be in practice statewide. Thank you.
Thank you. That concludes the testimony for House Bill. Delegate Tolles, you have a question?
Yes, I just want to say thank you for this bill. Isn't that so?
Thank you, Delegate.
You're welcome. So that now concludes the testimony for House Bill 542. We're gonna go out of order, members, and we're going to hear Delegate Ivey's bill, House Bill 656. And Delegate Ivey, whenever you're ready,
Yes.
is
Madam.
Lori Ruth here, or do you want to just go ahead and start and then?
Well, there's the hearing for the cross files taking place right now in the Senate.
Okay, so, Lori Ruth, Melanie Shapiro, Louisa, Kaizo, all these folks are probably over there. I just wanted to call the names in case they were
Please
here.
do call the names. Yeah, I think
Jean Yeager, Winetta McCraw, Fawn Vasquez, or Amanda Rodriguez. Okay, Delegate Ivey, it's on you. Carry it and introduce it to us and tell us all about it.
Thank you, Madam Vice Chair, members of the committee. It's truly a pleasure to be here today, speaking with you about House Bill 656. The bill establishes the Victims of Domestic Violence Program Grant Fund, a special fund administered by GOCPP, Governor's Office of Crime Prevention and Policy, which was just recently renamed, to provide grants to public or private nonprofit comprehensive domestic violence programs certified by the federally recognized State Domestic Violence Coalition. This legislation enables the governor to include $5 million as an annual appropriation to the fund. Currently, there are 19 comprehensive domestic violence programs eligible for this fund that provide statutorily required services across the state of Maryland. To qualify, a service provider must provide a 24-hour hotline, emergency shelter services for victims of domestic violence and their children, counseling services for a victim of domestic violence, counseling services for an abuser, and additional referrals to other community resources if needed. Today, I'm joined by, or many individuals are here in support of this legislation, including Prince George's County Community Crisis Services, Midshore Council on Family Violence for Caroline, Dorchester, Kent, Queen Anne's, Talbot counties, Turnaround for Baltimore County specifically. I'd like to thank these advocates that are here supporting the legislation. I don't have to tell this committee the significance of domestic violence that has been plaguing our society for far too long now. We have been putting funds towards some of these services. This would make it so that that limit is increased. And I hope that we can come to a favorable report on this legislation. You all know far better than most how important this is and how critical this funding is. So thank you, Madam Vice Chair, for allowing me to speak today.
Sure. Thank you, Delegate Ivey. Are there any questions? Seeing none, Godspeed.
Thank you so much. I really appreciate your time. Okay. Yeah.
Oh, no, it's okay.
All right. Thank you all. I really appreciate it. Thank you.
Okay, we're going to move on to House Bill 690. And this is Charles County. Okay, we have Delegate Deborah Davis representing Charles County. Welcome back.
Thank you. Thank you, Madam Chair, members of Judiciary. My name is Delegate Deborah Davis from District 28. I am also Chair of the Charles County Delegation, and I'm proud to bring this very short delegation bill. There's only one witness. This is a Charles County bill. We'd like to change the membership of the Adult Protective Services Review Board. There are 11 members. We're having difficulty finding a psychiatrist to hold the position, so we're asking to change that. And Two other jurisdictions have already done it already. We have full support of the delegation and of the Charles County Commissioners, and we ask for a favorable report. And there is one person online, I believe, virtually. Is there,
Yes.
Linda Stansberry?
Yes, Linda
Thank you.
Stansberry. Ms. Stansberry?
Ma'am, can you hear me?
Yes, we can hear you. You can begin.
Okay. Thank you
You have
very
2
much.
minutes.
Thank you, Delegate Davis, members of the Judiciary Committee. Good afternoon. My name is Linda Stansberry, and I am the chair of the Charles County Adult Public Guardianship Review Board. And I respectfully request your favorable report of Bill H.R. 690. In 2012, the Charles County Adult Public Guardianship Review Board was established under Maryland Family Law Code Section 14401 et seq. The purpose of this board is to review case management of citizens who have been placed under guardianship of the person. The board meets twice a year to review the care of citizens under guardianship. The membership of the board is specified in Section 14402, and it is that section that the board wishes to address. When it was established, the code delineated specific requirements for membership, such as a professional representative of a local department, a representative of local commission on aging, a lawyer, to name a few of the positions. The member description we are here to address is the requirement for a psychiatrist. A little background for the record before we address our specific proposal. Currently, there are 23 citizens in Charles County who are under guardianship of the person. Of those 23 citizens, 19 are adults under the age of 60 and 4 are seniors. More than 50% of them receive some type of psychiatric care or take some form of medication for a mental health issue. In the case of senior citizens, that percentage increases to 75%. The citizens under guardianship by the board have either no family or no family involved in their care, and the board works as their advocate for their health and care. These are some of our most vulnerable citizens in Charles County, and for the most part, all of Southern Maryland. There are few psychiatrists to serve an ever-growing population of people who need psychiatric care. Those psychiatrists have an overwhelming patient base, and getting an appointment can be daunting. The board has not. Yes.
Can you finish up, because your time is up, and I want to give you a chance to finish that thought.
Oh, I'm sorry. I didn't realize I had a time limit.
Yes,
The board-
unfortunately, we only allow 2 minutes per witness.
Okay, well, the board has not had a psychiatrist as a member for over 5 years, and we would like to change the language as noted in my written testimony.
Thank you very much.
Thank you.
Thank you. Are there any questions? Delegate Embry?
Good to see you, Delegate. The department said that they would prefer to see this resolved through their Senate bill that seems to be moving through that would apply similar language. I don't know if it's all there.
This is a delegation bill. I don't know that there's not a Senate bill.
So the DHS, they have an administration, they have a bill that seems to be similar, but it would be applicable to all counties. If you haven't seen it, then
I would ask for local courtesy.
Okay. Thank you.
And Delegate Davis, will you be able to provide a letter from the delegation?
We have a letter of delegation.
On its
Yes,
way?
I will.
Okay, great. Thank you so much.
Thank you.
That concludes the testimony for House Bill 690. We're going to move on to House Bill 553 with Delegate Miller. And Delegate Miller, do you have a panel?
Yes.
Okay, so I have Kit Hart and Lisa Garrity, Susie Scott, and Ismail Royer. Also is Carrie Gillespie. Okay, so when you begin, obviously, other than Delegate Miller, if you could please give us your name, and then after this favorable testimony, we'll move favorable oral, because I'm virtual, because we do have a few virtual people testifying virtually as well. Okay, Delegate Miller.
Thank you. Good afternoon, Madam Chair and my esteemed colleagues on Judiciary. Thank you for the opportunity to present this bill. My name is Delegate April Miller, and I am here today to ask for your favorable report on House Bill 553. This bill will codify into state law what the U.S. Supreme Court and the Maryland Court of Appeals have already established and recognized, that parents have a fundamental right to direct the upbringing, education, care, and welfare of their child without interference from the state, unless the parent has been proven to be unfit or there is an exceptional, narrowly tailored circumstance. In Troxel versus Granville in 2000, the Supreme Court, including both Justice O'Connor and Justice Ginsburg, found that the 14th Amendment's due process clause applies and has a component to provide heightened protection against government interference with certain fundamental rights and liberty interests, and that it is reasonable to presume that fit parents will act in the best interest of their children, and that the state should not interfere in that role or take that role away from them. Washington versus Glucksberg and Stanley versus Illinois are also other cases affirming parental rights. I want to take a moment to address what this bill does not do. It clearly says that it does not authorize parents to engage in conduct that is unlawful or to ever abuse or neglect their child, period. I have read and understand some of the legal concerns, so I have drafted an amendment that will maintain the legal standard of best interest of the child. I also want to clearly state on the record my intention with this bill, and please give me grace for a moment. I'm going to get personal. When I was pregnant with my first child, I had a serious heart problem. A complete block of the heart's electrical systems, where the top and the bottom of my heart were beating out of sync. I needed to have a pacemaker put in right away. However, they could not do the surgery at that point in my pregnancy. I had to wait. I told my husband that if anything were to happen to me, he was to put the life of my baby girl ahead of me. Every decision that was to be made should put her life over mine. Everything to be done in her best interest. And since that moment, when I became a mom, every decision that I have made, my children are my priority. I even became a politician to fight for them when I ran for Board of Education. I will continue to fight against the steady erosion of parents' rights that I have seen over the last 2 decades. I firmly believe that parents are the best advocate for and know their child best, as do many of the individuals here alongside me. Any attempt to assign or impugn motives by others, either in their written or oral testimony, is categorically false, hurtful, and very offensive. In just this last week, we have heard calls for amending our health framework to remove any provision of parents being able to opt their child out of family life or health topics down to any grade or any age, as Montgomery County did last year. And in Ways and Means this week, a parent was gavelled down to watch their language while testifying that when they were directly quoting a book that is currently available to young children in our public schools. The state's allowing 12-year-olds to make mental health care decisions without parent knowledge or consent, 16-year-olds to receive medications, and we're just getting ready to pass a school telehealth bill that does not ensure student privacy from school staff or others. Parents matter. We are spending billions of dollars to improve Maryland education and improve the lives and welfare of our students. By every metric involved, healthy parents are the biggest indicators of success for children, academically, socially, emotionally, and in avoiding unhealthy and risky behaviors. Please protect Maryland's parental rights. Our future depends on it. And I thank you for your grace in letting me finish.
Chair Bartlett and members of the committee, thank you for the opportunity to speak to you in favor of House Bill 553. My name is Ismail Royer, and I represent the Religious Freedom Institute, a nonprofit based in Washington, D.C. I direct the Islam section, where I serve as Muslim voice for religious freedom for everyone. This bill provides a parent has the fundamental right to direct the upbringing, education, care, and welfare of the parent's child. This proposition is true without a doubt. In 1925, the Supreme Court said in Pierce v. Society of Sisters, the fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with a high duty, to recognize and prepare him for additional obligations. 50 years later, Chief Justice Warren Burger wrote, Pierce stands as a charter of the rights of parents, adding, The history and culture of Western civilization reflect a strong tradition of parental concern for the nurture and upbringing of their children. This primary role of the parents in the upbringing of their children is now established beyond debate as an enduring American tradition. Is this right found in the Constitution? Yes, in a meaningful sense. The Ninth Amendment reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." And in the 14th Amendment, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." So the people had rights before our government existed. The Declaration of Independence affirms that all human beings, quote, "are created equal, and they are endowed by their creator with certain unalienable rights." That is, rights the government cannot grant or take away. This bill recognizes a right due to every person because he or she is human, and it gives the people a way of vindicating that right. I urge a favorable report on House Bill 553. Thank you.
I'll go. Good afternoon, Chairman Clippinger, Vice Chair Bartlett, and members of Judiciary. My name is Susie Scott. I'm the Chair of Moms for Liberty Maryland Legislative Committee. Thank you for the opportunity to speak. The family is the bedrock of society, and as the family goes, so goes society. So why is it that with over a century of case law handed down from the Supreme Court defending parents' rights, do we find ourselves having to pass this bill on fundamental parents' rights? In April of 2023, President Biden said, quote, "Our nation's children are all our children," unquote. The president is gravely mistaken to suggest that children are products or property of the government. Echoing the president's fallacious idea, the Secretary of Education tweeted out on May 19th, 2023, quote, "Teachers know what is best for their kids because they are with them every day. We must trust teachers," unquote. Do schools play an important role in children's development? Unquestionably, of course they do. But a child's relationship to his or her parents is primary. Teachers cannot replace parents. Despite these flawed pronouncements by our federal government officials, it's patently false to suggest that children belong to the government, and the government is more concerned with their well-being than parents. What this bill says is that parents should be their children's ultimate and primary caregivers. Polling from many sources shows unequivocally that parents believe that they are the principal decision makers for their children. This belief transcends politics, race, and income. So the parents of Maryland now look to you, ladies and gentlemen of the Judiciary and the General Assembly. It is your duty and your obligation to protect the rights of the citizens of this state. Show parents that you stand with them and their fundamental rights by giving a favorable report to House Bill 553. Thank you.
I have to go this way. Good afternoon. My name is Lisa Garrity. As a chapter chair of Moms for Liberty, and more importantly, a parent, I am asking you to defend my parental right to direct my child's upbringing, free of interference from the government and public school system by supporting this bill. Over the last 4 years, I have experienced a school system whose primary focus is to push social justice ideologies. And the one that affected my daughter and me the most is gender ideology. We got to the point where if this had not stopped, my daughter could have ended up ruining her life by taking hormones and undergoing surgery. For the last 5 years, my daughter has been suffering from depression and anxiety. We recently discovered she is autistic. School lockdowns for COVID exacerbated her symptoms. After 5th grade, she missed 2 years and then entered 8th grade. This was a difficult transition and further worsened her symptoms. While home alone and isolated during COVID, she was depressed, did not do her schoolwork, and spent most of her time in bed and on the internet. She was exposed to everything under the sun. She fell into the trans cult and soon decided she was a trans boy. The school fully supported this dysphoria. In the fall of 2022, I took Natalie out of the school system because she was failing and not attending her classes. Shortly after that, she sold her binders, which is used to flatten breasts, and decided with the help of a therapist that her gender dysphoria was a result of coping with trauma. I thought we were out of the woods. Sadly, the isolation was killing her. She did not do her schoolwork, and I had no funds to send her to private school. My only choice was to send her back to public. Upon entering school last fall, she immediately fell back into her dysphoria and she bought a new binder. This occurred after interacting with her science teacher, who invited her to join the Gender Sexuality Alliance Club. Her history teacher told her, "I know who your mother is. I'm here if you need to talk." The teacher, staff, and administration used her pronouns and the male name she made up. All of this against my wishes. I'm not done, but I'm here to say my story shows that the school system is a danger to children, and please support this bill.
Thank you. Anyone else?
Good afternoon. My name is Carrie Gillespie. I'm an Anne Arundel County resident and serve as the chair of Maryland Alliance for Parents and Students. However, the role I cherish the most and I am proudest of is being the mother of my 4 amazing children. I'm here today in support of HB 553, the Parental Bill of Rights. I would like to begin by thanking all of the delegates who have lent their support to this vital legislation, and especially to Delegate Miller for its introduction. I also commend Delegate Alston for her bipartisanship, which embodies the essence of my message today. Parenting and the unconditional love parents have for our children is not a partisan issue. Regardless of party affiliation, it is parents who solely know and understand what is in the best interest of our children, because only we know our children the best. A parent's kisses magically heal skinned knees after our children fall. Our snuggles and off-key bedtime songs soothe our children back to sleep after they awaken from having a nightmare. This innate understanding and bond between parents and our children are universal and apolitical and should be enshrined in Maryland law. Parents fundamentally have the right to direct the upbringing of our children. The former Supreme Court Justice Ruth Bader Ginsburg recognized this when she said, "Depriving a parent of parental status is as devastating as a criminal conviction." The politicization of this basic principle in 2024 is alarming to me as a mother. It makes this bill vital for all Maryland parents. The unwavering bond that I share with my 4 children as their mother is indescribable and profound, as is the bond that each parent on this committee holds with your own children. The United States Supreme Court has long recognized and upheld this fundamental parental right in landmark cases dating back nearly a century, notably in Pierce versus Society of Sisters. As we approach the 100th anniversary of this precedent-setting decision next year, as a matter of fact, it is high time that this General Assembly enshrines this fundamental right into law in Maryland. In conclusion, I urge this committee to support HB 553, affirming the rights of all Maryland parents and honoring the timeless and unparalleled bond between parents and our children. Thank you all.
I'm going to need you to switch seats so that you can be on the camera.
Thank you for that. Good afternoon, Chairman Clippinger and esteemed members of the Judiciary Committee. My name is Kit Hart. I'm a mother of 5 children aged 4 to 13 and live in Carroll County. I'd like to begin by sharing a story by author and Holocaust survivor Corrie ten Boom. She says in part, "Seated next to my father in the train compartment, I suddenly asked, 'What is sex?' He turned to me, but to my surprise, he said nothing. At last, he stood up, lifted his traveling case, and set it on the floor. 'Will you carry it off the train, Corrie?' He said. I stood up and tugged at it. 'It is too heavy,' I said. 'Yes,' he replied, 'and it would be a pretty poor father who would ask his little girl to carry such a load.' It is that same way, Corrie, with knowledge. Some knowledge is too heavy for children. When you are older and stronger, you can bear it, but for now, you must trust me to bear it. As parents, we carry many burdens for our children that are too heavy for them. Understanding the individual needs and maturity levels of our children, we hand each burden off to them according to what we, the parents, believe they can handle. It is not the role of the government or the school system to decide when our impressionable children should be introduced to concepts that may fall well outside of a family's value system. Unfortunately, we have seen too many times recently when the government has superseded the fundamental rights of parents to direct the moral and educational upbringing of their children. Personally, my husband and I made the decision to pull our children out of public schools in order to run interference. We are far from alone in this decision. In the year 2000, there were just 17,000 students in the state of Maryland who were homeschooled. Just a couple of decades later, that number has almost tripled to 45,000 students. Despite inflation making it next to impossible to raise a family on one income, parents will sacrifice much to ensure that they are the ones who to support and raise their children. Please support parents and families by submitting a favorable report for House Bill 553. Thank you.
That's it?
That's it.
That's it.
All right. Are there questions for this panel? Delegate Erica?
Thank you, Mr. Chair. Thank you guys all very much for being here today. My question is actually for the delegate. So you mentioned an amendment and I don't see it here. Could you just walk me through what the amendment specifically does and
Yes, it should have been emailed. Yeah, it just recently, like I just got it to the amendment office this morning. They just got it back right before the hearing. It said that the subtitle may not be interpreted to affect a court's application of the best interest of the child standard or any other family law actions relating to child custody, visitation, adoption, child welfare, child support, marriage, divorce, or alimony, or aggregate the state's parents' patry doctrine. Did I say it right? No, it's a yeah, exactly. My Latin's a little off, sorry. So yeah, so that is what it's basically, so that we take any of the judiciary decisions and keeping the best interest of the child standard in place. That was some of the concerns that were submitted.
Yeah, it seems like everything here in the judiciary's letter is going to be addressed by your amendment. So that's what I was looking to see. So thank you very much.
Thank you.
Thank you, Mr. Chairman. Thank you, delegate and panel, for coming in to testify. Do you agree with the concept that a juvenile can waive their rights after they have been Mirandized without a parent's authorization?
That's not what this bill addresses, though, but thank you.
Well, it all depends on how you interpret the words, I guess, that you used in the bill, what it covered. But okay, I'll accept that. Thank you.
Yeah, thank you.
I'll send you a letter.
That would be good. I would appreciate a discussion on that. Thank you.
Delegate Miller, thank you for coming. It's good to see you, my friend, and
Happy birthday.
Thank you, my friend. And when the General Assembly is not in session, you're an optometrist, so I was wondering if you could help me see something. I'm having trouble seeing something about. The chair loves my.
It might be out of my scope here. Hold on. I have scope of practice.
My question is, despite the chairman's love of my dad jokes, I do have a question, and that is, and it's something that I spoke to you about last year.
You did.
And that is that in my own life, people have told me, as a person with cerebral palsy, that I am, possessed by the devil, that if I could only, if I was only Christian and went to Christian revivals, I could walk, that if I drank 6 glasses of milk, and different things like that I could walk, and all sorts of malarkey. So my question to you is, what one of your witnesses, one of your proponents talked about how her daughter is autistic or son is autistic, I can't remember. And so, but what if somebody is believing some of the malarkey that I've been told, and as such, they have the parental rights for health under this bill and different things like that. And so what if they're in denial and don't get their children care is my question.
For this one, I would say with the legislation, the bill proposal is very, very clear as far as if it would come to the terms of health, neglect, abuse, anything along those lines that would adversely impact you, then that is when judiciary would be able to step in if there are any circumstances like that were coming. Thank you.
Further questions for this panel? Delegate Tomlinson.
Thank you, Mr. Chairman. I'm scrolling through the folks who signed up for favorable or unfavorable testimony. Did any, I see Religious Freedom Institute. Yeah, did you hear? Yeah, I was looking also for, maybe, a lot of times different people submit testimony from different Jewish coalitions, associations, Islamic associations. Have you talked to any groups like that? Do they have any opinion on this? I was just curious.
Sir, I am Muslim and I represent, I work for the Religious Freedom Institute, which is a multi-faith organization. But I am the director of the Islam and Religious Freedom section. So in that capacity, I do represent a Muslim voice for religious freedom. And I can tell you that I work very closely with Muslim communities around the country. And I have heard so many concerns about this. We just recently had a situation in Minneapolis, Minnesota, a suburb of Minneapolis, where a school attempted to do what Montgomery County Board of Education is doing and requiring students to learn a curriculum that attempts to change moral norms about what is, for example, what is the nature of marriage? Can people of the same sex get married? And it's not simply describing that as a phenomenon, but as saying that this is the only to accept that is the only moral way to go. That's the aim of the curriculum. And so the school board there, to avoid a lawsuit, changed their policy and said that parents have the right. They're still teaching it, which is fine, but the parents have the right to pull their children out if they have a bona fide religious objection to that. And we were, involved in Montgomery County. I am involved directly in Montgomery County Board of Education, and the same issue is coming up. So yes, and I will tell you that this is not just a sort of it's often painted as though this is a Christian nationalist type of thing. Yes, Christians do have the right to do that, but also Muslims, Jews. We have a multi-faith coalition in Montgomery County that's working on this. So it is a serious concern for anyone that has traditional religious beliefs. And the Supreme Court said in Obergefell that, you may, that it is the people who have this traditional view have it for honorable reasons, even though the rest of society may disagree.
Thank you, Mr. Chairman. I hope I can ask a question this time that can be answered. The gentleman that last spoke, in reference to, you were talking about Islamic traditions.
Yes, sir.
Isn't it specific to Islam that same-sex marriage is forbidden between men?
Yes.
Based on the Quran?
Yes, sir, that's correct. In the Quran, it says, we created you as men and women. So very similar to the...
I'm fully aware of what it says.
Yes,
I've read it.
Yes, sir.
Thank you.
Yes, sir, that's correct. Thank you for that question.
No further questions for this panel. Thank you very much. There are 3 people signed up virtually: Samira Munshi, Wael Elko Shahiri, and Tom Newmark. Okay. We'll hear from them next. You're all free to go. We'll hear from these 2 witnesses. We'll start with Mr. Newmark, please, for 2 minutes.
All right. Can you hear me?
Elko, yes. 2 minutes.
Great. My name is,
if you have us on a speaker there, you're going to need to mute that.
all right.
We'll hear from them next. You're all free to go. We'll hear from these 2 witnesses. We'll start with Mr. Newmark. Mr. Elko Shahiri, you're going to need to take the audio off.
Okay. Can you hear me now?
I can hear you, Mr. Newmark. Go ahead for 2 minutes.
Thank you. My name is Tom Newmark, and I'm a member of the Killarney Group, the world's leading think tank on sex and gender. I'm speaking today as an individual, not as their representative. There are 2 reasons to approve this bill, a legal one and a practical one. Legally, the Supreme Court's Troxel decision affirmed parental rights, but also left ambiguity as to what standard states should apply when deciding cases. This bill resolves that ambiguity by stating that Maryland should apply the same standard the Supreme Court has had for the last 100 years. Practically, this bill addresses public schools' overreach. The Frederick County Public Schools adopted a policy that allows them to conduct secret gender transitions of children without parental notification or consent. When dozens of parents sent in legal notices to Frederick County schools asserting their right to be notified and to consent, the schools issued guidance to principals to respond to parents by citing their existing policy. In other words, our schools believe they have the right to engage in youth gender transitions, a powerful psychosocial intervention, without parents' permission. Schools should remain neutral on the issue of gender transitions and let parents decide, but they aren't. We asked our schools, what if loving parents and the child's doctor and psychologist all agree that the child should not transition, and parents send in documentation proving that? Will you honor parents' wishes then? Our schools actually refused to answer despite us asking several times. This bill would provide that answer. Right now, it seems many Maryland schools fear lawsuits if they allow parents to make gender-related medical decisions. This bill would give schools the legal guidance they need to honor parents' wishes and medical professionals' recommendations. If you don't pass this bill, I need to ask you, what else will you do to ensure parents get to make medical decisions for their own children? This is a real problem that the legislature needs to address, and this bill is the best available solution. Thank you.
Mr. Elko-Shahiri.
Hello, good afternoon. Okay.
Medical decisions for their own children. This is a real problem that the legislature needs to.
Good afternoon. My name is JUD Committee. I am Muslim and I live in Montgomery County. I have children in Montgomery County Public Schools. My testimony, I'm going to change it a little bit. I had some prepared testimony, but from the questions, we are a parents group based in Montgomery County. Almost all Muslims who live in Montgomery County. Recently, over the last year, we have been struggling with MCPS to reinstate opt-out rules that were given to us initially that were allowed in Montgomery County Public Schools until they were abruptly removed without any type of discussion with us. So we have been going to the Montgomery County School Board. We have been testifying eloquently. There's currently a lawsuit in federal court that was recently heard in Richmond, the Fourth Circuit in Richmond, that was also brought by Muslims and Christians with regard to this issue. So this is it's not a Christian issue. It's not a Jewish issue or a Muslim issue. This is an issue of all people of religious faith. We urge you folks to give a favorable report on this bill, HB 553, because we feel that we have the right as parents to really nurture our children in the way that we feel right, and to be able to opt out and to be able to protect our kids from things that do not align with our religious beliefs, as is protected by the First Amendment of the United States Constitution. HB 553.
Questions for the panel?
Nurture our children the way that we feel right.
Seeing none, thank you all very much. That concludes the testimony in favor of the legislation. Now going to hear from Dee Blinder. Should be here in the room. There. Sharon Hill and Wendy Novak, who are virtual. We could take, there we go. That's fine. We'll get the people virtually here in a moment. Please go ahead.
Thank you so much, Chair Clippinger and esteemed committee. My name is Lee Blinder. I use they, them pronouns. I'm the executive director of Trans Maryland. I'm also the chair of the Maryland Commission on LGBTQI+ affairs. I'm here today on behalf of Trans Maryland. Trans Maryland works with young LGBTQI+ people all across the state and their families. We understand the importance of supporting parents and students. However, to be quite frank, I'm really not sure why we're here today. The Maryland Judiciary opposes HB 553. In their testimony last year, they stated that this bill will likely instigate frivolous claims and is unnecessary. The Maryland Attorney General provided unfavorable testimony last year and said that this bill would, in quotes, put children's lives at risk. For those reasons alone, it really seems absurd that we're here again. Since we are here, I'll state that our students must be taught about the existence of trans and queer people to prevent harm, discrimination, and violence, to learn about their fellow classmates, their neighboring families, faculty, historical persons of note, and legislators in service of the betterment of our society. UNICEF, the United Nations Children's Fund, states that children are individuals. Children are neither the possessions of parents nor of the state. Children are neither, nor are they mere people in the making. They have equal status as members of the human family. UNICEF also states that social research shows that children's earliest experiences significantly influence their future development. The course of their development determines their contribution or their cost to society over the course of their lives. What costs will cisgender and heterosexual youth in Maryland charge to our society if their government fails and yields to those who seek to remove trans and queer people from public life? For these reasons, we urge an unfavorable report on HB 553.
Sharon Hill, please, for 2 minutes.
Thank you. Can you hear me?
Yes, go ahead.
Hello, Chairperson and committee members and guests. My name is Sharon Blinder Hill. I am here to oppose House Bill 553. Parents do have broad rights under federal law, but they do not have absolute, unlimited rights to control young people's public education. Both common law and case law have supported the determination that education should prepare students to think for themselves, which sometimes does result in opinions that differ from parental viewpoints. In the United States of America, basic education is regulated in order to ensure the public welfare. This helps to guarantee that minimal education standards are followed by both public and private schools, including homeschooling, so that young people learn how to read, write, analyze, and evaluate for themselves. Minors have the right to due process and equal protection regardless of race, gender, disability, or religion. The Equal Protection Clause of the 14th Amendment requires that no child may be denied an equal access to schooling. On a personal level, as a parent of a trans child, and by the way, I am Jewish, I'm personally offended by the use of the term trans cult that was just used by one of the other panelists. Parents do have ample opportunity to weigh in on learning materials and review classwork. Self-proclaimed parents' rights organizations do play on fears and old harmful stereotypes. It is not fair or appropriate for some parents to attempt to impose their beliefs on public schools that serve all of our children. Parents are free to raise their children in their own belief systems and even to forego public education if they choose. But to become critical thinkers and independent adults, students need information. Please vote no to HB 553. Thank you.
Wendy Novak, please, for 2 minutes.
My name is Wendy Novak. My pronouns are she, her. I'm the mother of 3 children. I'm a Christian. I've taught Sunday school for over 20 years. In my role as a parent or as a Christian leader, it is my job to lead children, to guide children to adulthood. In my volunteering as a Girl Scout leader, we use the phrase girl-led. My role as a leader is to support the Girl Scouts, allowing them to step up as age appropriate and take ownership of their decisions, which allows them to grow into confident leaders who can make informed and empowered decisions. On the surface, fundamental parent rights sounds like a good thing, but it's the intention behind it that is troubling. Parent rights is not about a parent's right to support their child, which would include affirming their identity. It is about the opposite. The objective is to erase our LGBTQIA+ children with no recognition our LGBTQIA+ children exist. To them, their right to keep their child from knowing our children exist is more important than our children's right to exist. They want to determine what books are available for other children to read, a Christian nationalist version of schools, and keep parents from supporting their LGBTQIA+ children. Knowing that LGBTQIA+ students exist is not a burden. Parents have already the right to direct the upbringing, education, care, and welfare of their child. they do not have the right to determine what is appropriate for other children. This bill would open the possibility that a parent would have the right to opt their child out of state-required topics such as consent or uncomfortable history, could opt their child out of being taught that it is wrong to harass LGBTQIA+ students, to call them a cult or mentally ill. All of our children will do better in a supportive environment that includes all. This bill is hurtful to families and will only serve to further prevent all members of the community from being included and supported. Please vote on favorable on HB 0553. Thank you.
Other questions for this panel? Seeing none, thank you very much. That concludes the testimony on House Bill 553. Earlier this afternoon, Delegate Ivey had presented House Bill 656, but his witnesses were apparently in the Senate for some absolutely irrational reason. I don't understand it either, committee. It's really kind of quite shocking to me, but sometimes a committee of second chances and chances to fix problems. So they are here now. And so I understand that we took that bill out of order, but now we're going to wrap back and bring forward. There are 8 people who wanted to testify on House Bill 656 who were detained in the Senate. What I'm going to ask from my friends who are here all the time, that words closer to me and to would be awfully nice at this point. But we will hear the testimony now on House Bill 656. And when OIS sees this and is completely outraged by what I'm doing, yeah, that'll happen. Please begin.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. I greatly appreciate your accommodating both Delegate Ivey, who had a personal obligation, as well as all of us who are here today in support of House Bill 656. This bill, as you've already heard, is enabling language for domestic violence funding from the state of Maryland. It would go to the 19 comprehensive programs in the state. Those programs are required by statute and Family Law 4515, as well as COMAR, to provide emergency housing, abuser intervention, a 24-hour hotline, and counseling services, as well as referrals to other services. These are the programs that you call during the day when you need services and in the middle of the night when you have nowhere else to go. I'm going to turn it over to them to tell you about the amazing work that they do. The bill would also allow the Maryland Network Against Domestic Violence, the federally recognized State Domestic Violence Coalition, to certify programs as comprehensive, to identify those programs that are that point of contact for the community partners, the courts, the law enforcement, the hospitals, to know who to call when they have that victim and they need somewhere to go. We urge a favorable report on this bill. Thank you.
My name is Fawn Vasquez. I'm here to speak as a survivor of domestic violence. I was a victim of nearly a decade of abuse at the hands of my ex-husband. I met my abuser when I was very young. He was the brother of mutual friends and we played together in the neighborhood growing up. I met him again when I was a teenager. He seemed like somebody I already knew because of our childhood history, but it would turn out that I truly knew nothing about him and what he was capable of. Not long after our relationship started, I found out I was pregnant. I was scared. I had a traumatic childhood and was living in squalor with a drug-addicted mother. When he promised me we could be a family and told me he wanted me to come live with him, I agreed. Getting out of my situation was the top priority for my unborn child. I had no idea what was in store for me. A few months into the pregnancy was the first time he assaulted me. He wrapped his hands around my throat until I stopped fighting and went silent. He did this because I cried. He did not want me to wake his father. I was in such shock I couldn't believe what had happened, but I believed him when he told me that I was acting hysterical and hormonal from my pregnancy, and that of course he would never do it again. But he did. Every day after that was some level of abuse. I suffered financial, physical, verbal, and sexual abuse. I did everything I could to be good enough to make it stop, but the cycle of violence makes it too easy for victims to become trapped. Over the years, I would have 2 more children with him. With each, the violence would escalate, resulting in police arrests and charges. But he never stopped, and I was never told there was help. One day in May 2015, after a terrible verbal assault, I was left sobbing and crying on the floor, "Someone please help us." He became so enraged that I called for help that he picked me up by my hair and arms, held me like a battering ram, and slammed me headfirst into the glass storm door. By some miracle, the latch of the door broke before the glass could. I landed outside on the concrete, unconscious for an unknown period of time. When I came to, I realized I'd been locked out of the home, and fearing a hostage situation, I pleaded my way back in so I could take care of and protect my children. I remember me saying to him, "One of these days, you're going to kill me." He looked me in the eye and said, "I know I will." 3 days later, he finally left the house for the first time. After he left, my child grabbed a laundry basket to block the door. I asked what they were doing, and they said, "I have to build a wall so Daddy can't come inside and hurt you anymore." It was that day and that moment that something changed inside of me, and I realized that all those years of abuse was not just happening to me alone, but happening to my babies. They were deeply impacted and affected by this. Once I realized, I knew I had to end things. All the love I had had could never have been enough to stop the monster inside of him, so I called the domestic violence hotline. They immediately got me in contact with resources, the most important being Midshore Council on Family Violence in the Eastern Shore of Maryland. It was when my life began. The resources I was provided were more life-changing than I could have ever imagined. I found out I was pregnant just after receiving my protection order against my abuser with my 4th child. A single mom with 4 kids on their own for the first time may not sound ideal to most, but the transitional housing program that I was placed in offered me a place for the first time ever, freedom, safety, and most importantly, some hope. I am here to tell you that I am not just a statistic. My name is Fawn. I am a survivor. My precious children, Hal, May, Theo, and Charlie, they are survivors. I would not be here today to tell my story if it wasn't for programs like Midshore Council on Family Violence and its place and the place it holds in its heart for its victims. I urge a favorable report today so that my success story can be one of many for future survivors. Thank you.
Thank you, Mr. Chair and members of the committee. My name is Jean Yeager. I'm the Executive Director of the Midshore Council on Family Violence. As Fawn said, we cover Kent, Queen Anne's, Caroline, Dorchester, and Talbot counties on the Eastern Shore. I'm here to speak on behalf of the comprehensive domestic violence programs. As you've heard, that we all abide by the COMAR regulations, and we are the central point of contact for domestic violence services, victims, and also for partners who respond to domestic violence cases. I think the most important thing to understand about comprehensive programs is that we work and we know the communities in which we operate, so that our programs, although we provide shelter or transportation services, they will be different to fit the needs of the communities in which we operate. Many of our programs have bilingual staff because we work with Spanish-speaking victims and in other languages. On the Eastern Shore, we don't have a transportation system. So how we provide transportation is I have a transportation coordinator. We have 3 donated vans, so we take our clients to and from courts. We have a pet sheltering program because pets are part of the fabric of the Eastern Shore, and many victims won't leave without their pets. So we cater our pets. I want to just also talk about the fact that Midshore, along with all the other programs in the state of Maryland, has experienced a surge in clients in the last year or so. This past fiscal year, Midshore responded to 600 hotline calls, a 20% increase in calls, helped 500 adults and 826 children, which was a 29% increase. 357, 72% of all of our clients received at least one legal service. And we opened 244 legal cases, the most in the last couple of years. In the first 6 months of 2023, our caseloads averaged 20 to 30 more clients. So we are providing really genuine services that meet the needs of our communities. We're serving more people. And quite frankly, we rely on an annual budget. We don't have funding to even have stable funding. And this is why I urge your favorable support of this bill. So this will give us some dedicated funding to do the amazing work that we do. Thank you very much.
Members of the committee, my name is Luisa Chiazzo, and I have been the CEO for the Sexual Assault Spouse Abuse Resource Center, otherwise known as SARC, in Harford County for the past 18 years. This bill will establish a certification process for programs in the domestic violence field to ensure that vulnerable individuals receive the same quality services no matter where they go throughout the state of Maryland. This includes that employees have regular oversight, training, and that programs are providing the best practice initiatives as they develop in the field. As a dual program That means we serve both domestic and sexual violence victims. SARC already participates in the certification process for rape crisis centers in Maryland that was established. So we're looking to establish a similar set of standards for domestic violence programs. Shelter staff are trained and do intervene in suicide attempts, drug overdose, mental and physical health needs of both parents and children. The entire agency must react monthly to safety alerts when we see a perpetrator's vehicle where they're not supposed to be, scoping out the property. In some cases, perpetrators are harassing our staff members. For example, one abuser continued to call our 24-hour helpline for an hour straight, calling and hanging up, and then proudly was declaring that so other people can't get help. So our programs are often the only avenue for safety for victims that are fleeing life-threatening circumstances. And this is a stressful job that people are willing to do because they understand it's the right thing to do. Our shelter team members are earning $18 an hour when they can go to Burger King and also make $18 an hour with benefits. Well-meaning community members call SARC wanting to establish programs without fully understanding what needs to be done to provide safety and well-being. Not establishing certification will place domestic violence victims at risk as they desperately seek assistance. I urge you to have a favorable report. Thank you.
Good afternoon, Chairman and community members. My name is Gwen McCraw, and I am the Director of Safe Passages, Safe House that's operated by Community Crisis Services. We are the only domestic violence shelter in Prince George's County. We have been in operation for over 40 years. In 2023 calendar year, we provided safe shelter to 225 households, which consists of 219 women, 229 children, and 6 men. At the Safe House, we provide case management, counseling services for the victims there. We partner with outside legal agencies. We provide breakfast, lunch, and dinner. We are trauma informed. We provide services to our youth to make sure that I have an educational liaison and a youth specialist to make sure that children stay enrolled in their current school if it's safe, or get enrolled to another school of choice. We also assist them with obtaining a protective order. We also assist them with first month rent, security deposit, also with back rent. We also assist them where if they want to go back in their home, but they would need like ring camera or blink. We supply them with the funds for that in order to get the security system. We also operate a 24-hour hotline. We have a chat as well. We started a chat and when the pandemic, and since the pandemic, we have been harassed from a lot of the abusers where they are acting like they are law enforcement, calling the hotline, trying to locate the victim, and they also trying to track the victims through their children devices and putting air tags in their shoes.
Are there questions for this panel? Right. Thank you all very much for testifying. We're here now for Lisa Jordan, Lori Ruth, and I think Amanda Rodriguez. I think we're the other people. Okay. I think that was the group that was stuck in the Senate. All right, whoever would like to go first.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault, here in support of House Bill 656. The Maryland Coalition Against Sexual Assault already certifies the rape crisis centers in exactly the same way that this bill is asking that the network certify the domestic violence programs. I'm here to say, me too, please support this bill. I'm happy to answer questions.
Mr. Chair, Madam Vice Chair, members of the committee, my name is Amanda Rodriguez. I am the Executive Director of the Comprehensive Domestic Violence Provider in Baltimore County, and we also serve domestic violence survivors in Baltimore City. During COVID, our lethality assessment program rose by thousands of %, meaning more clients than ever were experiencing extreme levels of violence and were at high risk. Our team had to grow to be responsive to the growing need in our community, and we spent hundreds of thousands of dollars on safe shelter for families fleeing violence. Unfortunately, the numbers have not decreased, although they have stabilized for us in the last year. During the same period of time, just like everyone else, we were experiencing staffing shortages and our salaries simply could not compete with the market. Our staff serve some of the most vulnerable in our community. They showed up to the office when the world shut down so children who witnessed violence in their homes could get desperately needed trauma therapy. They showed up to cover shifts at emergency shelters and to show up to provide food and support for clients in spite of the risks of the pandemic. Our staffs are some of the most dedicated people in the community, and the inability for them to have a competitive wage is simply unconscionable. We also need to ensure that we can hire when our community need exceeds what we're currently able to provide. All of us offer these services for free, but it begs the question, what is the cost of being free? Is there enough to support the mother of 5 who's been forced not to work by an abusive husband to get a place to long-term stability? Is there enough for the strangled young man who will need ongoing therapy for years to come to cope with the trauma he experienced, or the teenager raped by an ex-boyfriend who will now have to go through a lengthy criminal and Title IX process? Who should we say, sorry, but we're unable to support you because we are simply at capacity? There is a cost for being free, and we ask for support to ensure every survivor, the 1 in 3 of us that has had some kind of power-based violence in our lifetime, so that we can have comprehensive domestic violence centers so that we are able to access them when the unspeakable happens. Thank you, and asking for a favorable report.
Good afternoon, Mr. Chair, members of the committee. My name is Laurie Ruth. I'm the Chief Programs Officer at the Women's Law Center of Maryland. I'm actually here on behalf of a non-comprehensive program. So while none of this money, if it happens, would ever come to us, we rely very strongly and partner with the comprehensive programs in all the jurisdictions where we do work. So we have a relationship with Turnaround. We have common clients. The same goes for Springboard in Carroll County, House of Ruth in Baltimore City. And, we think this is vitally important in these communities. And for those reasons, we urge a favorable report. Thank you.
Seeing none, thank you all very much. Now, that really does conclude the testimony for House Bill 656. We're going now to, I think, Delegate Shetty. Okay, for House Bill 745, please.
Thank you, Mr. Chairman. May I bring up some of our sponsor panel friends?
Yes.
Thank you. Yeah, I'm just sitting with some of your employees and then come to you, Lisa, do you want to join as well? I'm not even sure, whoever we can fit. Let's get it. Okay, thank you, Chair Clippinger, Vice Chair Bartlett, esteemed members of the Judiciary Committee. So fun to be with you twice in 1 week. Really miss this room, apparently. For the record, my name is Delegate Emily Shetty. I'm here to testify in support of HB 745, a bill that would allow victims of non-intimate partner stalking to obtain added protections from their stalker and a path towards a permanent protective order. So if you're in the 40% of stalking victims with a current or prior intimate relationship with your stalker, you are afforded a lengthier order, the ability to have firearms removed from dangerous stalkers, and a path towards a permanent protective order. But if you are in the 60% of victims without a past relationship, you don't get any of that. In fact, you have to pay $86 every 6 months, are forced to face your stalker in court, and have no way to seek the removal of firearms from a potentially violent person. What HB 745 does, as introduced, is it tries to address some of these injustices by adding stalking to the list of offenses that an individual might petition for a protective order, and also by providing a path for victims of non-intimate partner stalking to obtain a permanent protective order. So I want to share a little bit. We spoke with all of the advocates who are interested in this in the IPV community and outside of it, and lots of concerns were raised about the bill as drafted. So I'm working with the entire community, folks here at the table, and I think some others as well, on a sponsor amendment that would seek to do the same 3 goals,
but via the peace order statute. So what it would still do under the peace order is it would allow for a non-IPV victim to seek a peace order, but for a lengthier period of time, allow discretion for the removal of firearms, and allow a path towards a permanent order under certain circumstances. So, so under both bills, or both the bill and the sponsor amendment we're planning to share shortly, we would have those goals achieved. Under the bills introduced, it would be under the protective order statute, adding a class of victims that are not currently eligible. Under the sponsor amendment, it would not alter the structure we have currently in the courts of IPV and non-IPV victims, but instead allow for those longer protections, more robust protections to exist for stalking victims. So with that, I urge a favorable report of House Bill 745 and really appreciate the committee's consideration. Turquoise, why don't you go next? I'll give you the microphone. Oh, you got it. That'd be good.
Thank you. Chair Clippinger, Vice Chair Bartlett, and members of the House Judiciary Committee, thank you for the opportunity to provide testimony regarding House Bill 745 to expand protections to victims of stalking. My name is Turquoise Williams. I'm testifying in my capacity as Executive Director of Just Stalking Maryland Resources and a stalking victim for over 15 years. Peace orders don't work in my experience. Getting them served can be nearly impossible. In my case, requiring me to once use myself as bait and necessitating interventions from a friend 4 states away on another occasion. Orders were ignored, even when standing less than 3 feet from my stalker, police still did not remove or violate them. Returning their gifts or evidence, asking them to leave, saying there was nothing more they could do. This person never went to prison for their stalking or harassment. The arbitrary argument that persistent stalking victims should be bifurcated from neighborhood disputes or other types of victims, such as domestic violence or sexual assault victims, is not grounded in the research regarding this matter. I have never had a sexual relationship with my stalker. We had no intimate history, nor has this person ever attempted to sexually assault or rape me. Stalking is a more varied crime than many understand, yet not always dangerous in the classic sense such as physical violence. It affects all genders, ethnic, and racial groups. Research suggests that professional and male identifying victims are equally targeted by stalkers. I respectfully request a favorable report on HB 745. Thank you very much.
Good afternoon, Chair Clippinger, Madam Vice Chair. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. You've heard me talk about concerns around stalking before, so I just want to remind everyone about the scary statistics that are related to stalking. 1 in 3 women are victims of stalking in their lifetime, and 1 in 6 men are experience stalking in their lifetime. There's a high relationship between homicide and stalking. 76% of female homicide victims had been stalked previously. 54% of female homicide victims reported stalking to the police before they were killed. 40% of victims of stalking are victims, and I think that Delegate Shetty touched on this. 40% are victimized by current or former intimate partners, 42% by an acquaintance. So the concern here is, why are we giving different protections when the lethal behavior is the same? It is identical in stalking cases, IPV, non-IPV, in terms of the nexus to homicide, in terms of the concern about safety. And you heard what Ms. Williams testified to in terms of her own experience. Stalking has dramatic effects on the victims. They suffer much higher rates of depression, anxiety, insomnia, social dysfunction than other people in the general population. And the statistics that I'm giving you are from a 2022 national study. So why are we here? We're here to try to enhance the protections for victims of stalking. We see these cases in my office, not regularly, but often enough. And the cases that we do see come into our district court because stalking is a misdemeanor, and that's the way we see them come in. we often bring them to our circuit court to handle them with more special attention. Again, why? Because they're so serious and they can be lethal. That's why this bill is important, whether it's in the peace order or whether it's in the protective order. There should be more protections of stalking. I urge your support.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee, Melanie Shapiro with the Maryland Network Against Domestic Violence. I'd like to thank Delegate Shetty for her openness and willingness to work with us regarding the concerns with having some of this language contained in the protective order versus the peace order. Just to explain a little bit of that, the rationale behind that is that the protective order is intentionally very narrow because the protections offered are very broad. And so to put some of these protections in the protective order versus the peace order was very concerning. By some of the people that just testified before you raised those concerns. However, stalking is a tremendous issue. It's present in intimate partner situations, in dating situations, people who know each other from work, or people who have no idea who the other person even is. And so the opportunity to get the relief that this bill is proposing through a peace order is incredibly important. It also could benefit victims of dating violence who don't meet the requirements of the protective order because they don't have that relationship level yet, but the stalking might still be going on. And we see that as well. The path to a permanent protective order and peace order are both equally important. When Delegate Shetty first brought this bill, I decided to see what other states are doing. And there are 37 states that address stalking through some type of civil order. And I looked at every single one of their statutes, and Maryland is really out of step with the rest of the country in terms of the limited nature of the protections that are offered. So the discretionary removal of firearms, the additional duration, and the path to permanency are all consistent with what other states around our country are doing. And it's something that we think that Maryland should do as well. So we urge a favorable report on House Bill 745.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of House Bill 745 with amendments. You know, protective orders right now, they're the first line of defense for intimate partner violence cases, but not only for intimate partner violence cases. They're also available for non-intimate partner sexual assault cases, child abuse cases, elder abuse cases. Sexual assault, the non-intimate partner sexual assault cases moved from the peace order to the protective order several years ago because the orders are longer, they're generally taken more seriously, and there are other forms of relief that flow from the protective order, not the peace order, like the 2-year order and the permanent order. As introduced, House Bill 745 does two things. It moves stalking kind of the same way we moved sexual assault. And honestly, we viewed this as kind of reasonable. The Office of Violence Against Women at the U.S. Department of Justice kind of views sexual assault, domestic violence, stalking together. They're all power-based. So that's a reasonable option. We haven't seen the amendment. That's, I think, still in the works. We're certainly happy to look at that as well, if that is the better option. The second really important thing this bill does is it expands the availability of permanent protective orders. As introduced, I think it inadvertently referred to crimes of violence in the criminal law article. We don't want to eliminate protection for assault survivors, so we really should use the public safety article. The bill is a little bit up in the air because of these ongoing discussions. MCASA's primary concerns are increasing protection for victims of stalking, expanding the availability of permanent protective orders, and avoiding a separate process just for stalking victims. It's simply impracticable. For those reasons, we urge a favorable report of House Bill 745 with amendments.
Questions for the panel? Delegate Cardin.
Thank you, Mr. Chair. Thank you all very much for coming on this very compelling legislation. This is either, I think, for either the bookend attorneys on either side might be able to help me with this question. So I have a client who's being harassed and tormented by her neighbor, her former neighbor. She moved because she couldn't deal with it anymore. There's no sexual nature to the harassment, but every time she comes, she's trying to sell her house, happens to be in Baltimore City. And every time her husband, who also is part of this peace order that they got, goes there, he winds up being followed by this guy around. It sounds like there could be stalking. The peace order expired coincidentally on Monday, and there's now no protections. The question is, should it only be for non-intimate partner stalking, or should this potential expansion to a year, which I love, should that be for all either stalking or harassment or tormenting that could end in bodily harm?
So the protective order already includes stalking if you fall under kind of the intimate partner category. But for that, and that's really what we're looking at is what do we do with the non-intimate
But this is only for stalking. I'm saying that what about for somebody who's being harassed, tormented? Would this also include them?
So if stalking is specifically delineated as something that's going to be enhanced in the peace order, so to go to a year to allow for the discretionary removal of firearms, then technically harassment is a different definition than stalking does. Often it overlaps though. Actually, harassment's harder to prove than stalking, even though it is a 90-day offense versus a 5-year offense, which is what stalking is. So some of the conduct might be captured, but they are two different things. And this discussion contemplates stalking because we're kind of starting there because of the high nexus to lethality to say, look, some of these things that happen under peace orders are significant and require more protection. One of the other issues with peace order is that you can only get a peace order if something's happened in the last 30 days. So you're basically stuck after 6 months, and then you have to wait until something else bad happens, versus the ability to get a longer period for the peace order and have a path to a permanent peace order. And I would add, based on some of the things that we just heard in terms of needing to move, with your example, them moving from that area, I have another statistic that 1 in 7 people move as a result of stalking victimization. So it's a high cost to victims, emotionally, physically, and financially.
Way there was an ERPO to remove this person's the harasser's firearms, but then they had to give it back because there was no reason to keep them.
Yeah, that's a whole different issue for another bill someday that we've been thinking about, but I hear you.
Let's talk. Because
okay, sounds great.
But the fact was that also promoted her having to move, which cost tens of thousands of dollars, and she hasn't been able to sell her house because the interest rates. She moved right after the interest rates went up. I mean, so this is just, if they would have gotten the 1-year peace order, maybe things would have been different.
Delegate, Ms. Williams would like to offer some additional comment on your first question, I believe.
I think we should just kind of clarify, as I mentioned, for acquaintance stalking, it's actually really low probability of violence. If I remember correctly, based on the things I've been reading to brush up on this, it's about I always invert the numbers, but it's either 5.4 or 4.5% likelihood of violence. The violence for acquaintance stalking is relatively low. Right? It's the persistence that you have to be concerned about. The persistence for acquaintance stalking can go on for, I think the longest that I've ever heard is 83 or 84 years. Right? I've heard studies where it talks about 40 years. Mine so far has been 15, but I altogether expect this person to come back like he's done every time. They usually do. Acquaintance stalkers persist statistically more likely. It's about 40%, I believe. I didn't bring that data with me, but I believe it's in my written report. But the lethality it's much lower. But that's why I'm saying, in terms of this specifically, what we're talking about for this, everybody should have the same length of a peace or protective order, whatever you want to call it. I'm personally not interested in what we're calling it.
Seeing none, thank you very much. That concludes the testimony on House Bill 745. Going now to House Bill 405, Delegate Kaufman. We'll have his first panel, Katie Spearman, Paul Griffin, Hera McLeod, Annie and Nora Kenny.
We have Congressman Fire, who's on Zoom, be on the first panel.
You here?
Is this my stuff? Yeah, I'm coming. Thanks. Good afternoon, everyone. I'm here to present, Chair Clippinger, Vice Chair Bartlett, esteemed colleagues, I'm here to present, HB 405, the Child Custody Evaluators Bill. This legislation is critical to determining, to ensuring that persons determining custody outcomes in cases of abuse, domestic and physical violence are well trained in these issues. The goal is to protect the safety of children. This legislation requires custody hours to custody evaluators, sorry, a bit nervous, to complete 20 hours of initial training and 15 hours every 3 years thereafter. This aligns with the training along the same lines that judges undergo, I think, as related to Senator West's bill that passed a few years ago. But I want to speak a little bit off script if I could and say that people have been very generous today and mention my birthday. And in my 37 years on this earth, I've learned some things about human nature. The first is that people don't like to be told what to do. The second is that people are territorial. And the third is that people, change is hard for people. I didn't want to take this bill at first, Mr. Chair, because I didn't, as a non-lawyer freshman legislator, didn't want to go up against the Goliaths of the legal establishment. But one cannot listen to Ms. Spearman's testimony, which you'll hear in a minute, and feel that the system is working so beautifully. And I just became convinced that it would have been easier for me, frankly, to sit on the sidelines, but I could not, after listening to these men and women, do nothing. And so I just want to also say that that I think that the judiciary will come up and say, oh, we're already doing this, but it's clear to me that it isn't working. And I think I have a lot of support because this is about putting children first. For example, I have the support of the American Academy of Pediatrics. I have the support of the social workers and the licensed professional counselors. I also have the support of 26 co-sponsors, to use Delegate Moon's phrase, across all ideological flavors. And the cross-file of this legislation is a Republican, Senator Mary Beth Carrozza. So I urge a favorable report to protect children and families who are undergoing unspeakable trauma that they do not deserve. And the judiciary has repeated and repeated and repeated, oh, we already are doing this in the rule. Well, there's no harm. I did not get a satisfactory answer as to why it could not be in both the statute and the rule. And can I just finish the sentence? Is that okay? And I also just briefly want to touch on the custody value, on the Bar Association's testimony. They had a litany of issues with it, and that's why we have a subcommittee system. And I look forward to working with Chair Crutchfield on the bill. However, this bill is never intended to be a cure-all, but it was clear after listening to men and women that the current system is failing families, and it was important for me to take on this battle. So thank you for your time. Next person.
Good afternoon. My name is Hera McLeod. In October 2012, my 15-month-old son, Prince, was murdered by his father, Joaquin Rams. His murder came on the heels of a year-long battle in the Montgomery County, Maryland family courts. Our custody evaluator heard testimony from several witnesses, including a Virginia police officer who testified that Rams routinely abused women and children and that he was the sole suspect in 2 previous murders. Our custody evaluator understood the danger that Rams posed to Prince. However, Rams's attorney invalidated her testimony. She pointed out that the evaluator didn't have the training and credentials that qualified her to evaluate the danger Rams posed, despite that being the very thing that she was appointed to do. Having requirements and training for custody evaluators in the judicial rule is lovely, but to ensure children are protected, I urge you to vote in favor of this bill and close the existing loophole
that allows the appointment of custody evaluators without the necessary training and qualifications to cases involving child abuse allegations. Imagine for a moment being forced to send your child across a minefield each time he visits the other parent, someone you know who is dangerous. The courts will say, send him anyway. There aren't that many mines. Don't worry, he probably won't step on one. And right about now, you might be thinking, well, I'm not worried because my child isn't forced to walk across that minefield. But now I ask you to think about how you'd feel when the child who's been tortured for the last 16 years knocks on your door and wants to take your daughter to prom.
Hi, my name is Annie Kenny, and I am a protective parent from St. Mary's County. In 2017, I discovered that my husband had abused our oldest daughter. He was indicted on felony child sex abuse charges and is now a Tier 3 registered sex offender for life. It took 7 months for him to be convicted, and it took 4 years to get a no contact order in family court for my younger two daughters. The reason we have a no contact order for my younger two daughters right now is because he is incarcerated for sexually abusing more children now. At the time of his arrest on his new crimes, I had an active family court order demanding that I send my children to his mother's house every other weekend for visitation, which I was not doing. And I was fighting off contempt charges over and over again. It wasn't until our fourth hearing that the word abuse was ever spoken in the courtroom, and the word sexual abuse, or that term, to this day still has not been used. There was no discussion of grooming, of childhood trauma, the long-term effects of childhood trauma. And, you know, basically in these situations, entire childhoods are being decided, and they involve really complex issues. The people divorcing where there's two healthy parents, they have figured this out amongst themselves and come up with a plan, and they're not asking for the system to intervene and decide what's going to happen next. So in these situations, it's really vital that the people making these decisions understand what's at stake. Those of you who've heard me testify before have heard me testify about the long-term effects and the effects on my children. And my daughter, Nora, has actually come this year to testify as well.
Hi, my name is Nora Kenny. When I was around 8 years old, my family fell apart because my dad was arrested for abusing my older sister. My younger sister and I spent another year after that visiting him at my grandmother's house on certain days. However, my grandma didn't follow the given rules and allowed me and my sister to have unsupervised time with my father, and even allowed us to sleep in the same room. The following year, me and my sister spent one evening a week at Burger King with my dad, but this time it was supervised by a nice lady. When I was 10, I told my mom I did not want to keep doing that, and then I was finally free. I now know my mom spent 2 years after that battling in family court to keep me and my younger sister safe. That was until my dad was arrested for abusing other children. The court system did not protect me, my mom did. The person who knows how to deal with me best is my mom. If she is not given the responsibility to make decisions about my life, I at least want the person who is given that job to be trained specifically on these types of situations. I want them to be trained on how children's and teenagers' brains develop, the facts about child abuse, signs of trauma and behaviors, and the long-term effects of childhood trauma. It makes me so mad to even think about the fact that the adults that could have been deciding my entire childhood have no idea about how I feel, function, and what I need to heal and feel safe. I hate when people talk about what's fair to my mom or to my dad. What should matter in situations like mine is what's fair to me. My childhood is made from so many small and large decisions. It feels insulting to know a complete stranger could be the one making those decisions instead of someone close to me. But what makes me even more angry is that the person that is given the job to make my childhood decisions isn't trained on child development, child abuse, trauma, and other important topics. I hope I will be aged out of the family court system by the time my dad gets out of jail, but my little sister will not be 18 before he is out. I'm so scared for what could happen when my mom goes back to family court. The long-term effects of trauma, which happens when these decisions are made incorrectly with poor judgment, are so incredibly horrific. I have been hospitalized multiple times since everything happened with my dad, and I've struggled with mental illnesses such as anxiety and PTSD as well.
When the custody evaluator in my own case was asked under oath about her qualifications, I'm reading from her deposition. Did you take any course only focused on any type of sexual or domestic violence? No. Did you ever evaluate a child to see if he or she was a victim of any type of abuse? No. Have you ever been qualified as an expert in any type of child abuse? No. Have you ever been qualified as an expert in domestic violence or intimate partner violence? And the custody evaluator answered no. Despite this, the judge said in his oral ruling, I know there was testimony suggesting the custody evaluator did not have the requisite knowledge, training, and skills to perform this evaluation. I disagree. I do find the testimony credible and afford it great weight. The custody evaluator's fee was $25,000. With court time and deposition costing thousands of dollars more. The children's best interest attorney charged over $360,000. I should add, I was a stay-at-home mom with no income of my own at that point in my life. On the recommendation of the custody evaluator, the judge took away legal custody of my children from me. Not only that, he ordered that my children couldn't see anyone on the maternal side of their family for months, people that my children dearly love. The psychological trauma from the judge's ruling was so severe that I lost consciousness, and 911 was called and medics had to come into the courtroom to take care of me. I'd filed bankruptcy because of these legal fees. The children's best interest attorney put a lien on our house, and my children and I lost our home. And these are just a few of the many harms that we experienced because of the recommendation of an untrained custody evaluator. And this training must be in statute. The rule is not sufficient because the court can waive the training requirement. An individual judge, like the one in my case, can simply disagree. There must be accountability. I urge you to please pass this bill.
Sorry. Good afternoon. My name is Paul Griffin. I'm the legal director of Child Justice Incorporated. We are one of the few organizations in Maryland that litigates these cases on a daily basis free of charge. Some of you we didn't have enough photos to go around. A photo that was placed on your desk. It's quite graphic and shocking. I'm sharing this with you not to score any cheap points for shock value, but to demonstrate what is happening now in a current case we have here in Maryland with custody evaluations. This client, whom I will not name because, again, it's an ongoing case, was brutally beaten by her child's father. But the custody evaluator with whom we shared this very photo refused to consider the abuse because it happened prior to the current custody order and is therefore, in her mind, not relevant. This view is contrary to the law in Maryland, the science related to domestic violence and its effect on parenting, and indeed common sense. And I wish I could say this is a one-off, but it's a common problem here in Maryland. Indeed, literally just last week, before I testified on the Senate side, we received a custody evaluation from another custody evaluator who also refused to consider prior domestic violence, including strangulation to the point of passing out, because it occurred prior to the current custody order and therefore was not relevant. When the custody evaluator in this case was appointed, we objected on the basis that we don't believe custody evaluators are properly trained to handle cases involving domestic violence or child abuse. The chief judge of that jurisdiction adamantly assured us that the custody evaluators in his county were highly trained and had the requisite expertise in family violence. Unfortunately, that wasn't true. This particular custody evaluator, despite being assigned to a case with DV, admitted she was not qualified in the areas of DV, child abuse, or trauma, and did not review any of the photos or injuries or other materials. She found the dad to be a fit parent because he had a residence and there was evidence that he could support the children. He also ordered joint legal custody. So the mother in this case is now required, if the judge rules with a recommendation, to co-parent with the person who did this. So we're here today to tell you that what is happening in the field does not match what we're being told is happening within the judiciary. The training is not reaching down to the levels in the where it needs to be. And we ask that you pass
this legislation, which requires some robust training for custody evaluators. Thank you.
Hi, I'm Dr. Carly Blackstone. I'm actually here as a psychologist, but also as a mom. On the psychologist side, I actually work with families who are raising their kids in two homes, usually because of separation and divorce. And I am not qualified to do custody evaluations, and I've been doing this for close to 20 years. Simply because I don't have the extra training. I have tons of experience. What I have chosen instead to do with my career is do more reunification work. And then I go in and I help with families and children after they've had these court orders to go see their parents after they've abused them, and to try and educate the court on why and what's going on and what's really the underneath in the family, because oftentimes the custody evaluators don't have it right. And then what's presented to the court is just that this child isn't seeing their parent and nobody explains why. On the mom side of things, I will say we had the same inadequate custody evaluator who saw a ton of red flags in my situation, saw that my ex was homicidal, suicidal, didn't have the ability to tell the truth from lies. My ex promised he would change, promised he would go to therapy. I was very lucky that when he attempted suicide, my daughter was with me. And so I did have some protection for a few years after that, but she is in an outpatient. This is not my daughter, but she is 14. My daughter is 14. She is in an outpatient therapy program now. She is still having to see her father to work on it. This is a continual issue that could have been prevented a long time ago. So I care to support the bill and just ask for extra training for evaluators. Hi, I'm Susan Carrington, and I am a protective mother, a survivor of domestic violence. The Maryland courts have granted 2 final protective orders at the time it was clear and convincing evidence in order to be granted an order. I am also the victim of a severely flawed custody evaluation in which I have not seen my daughters in over 14 years. In my case, we have been through 2 custody evaluations. The first court-ordered evaluation was completed by a court employee, and she understood the dynamics of domestic violence, the issues with substance abuse, and she actually was the one who got our case right. The courts covered the cost of the evaluation, so it was free to us. My ex-husband was very furious that the evaluation was not in his favor, and he petitioned the court to have an evaluation by a private, specific outside evaluator who's also a psychologist and alleged to be an expert in domestic violence and substance abuse. However, this custody evaluator, like I said, destroyed the lives of my daughters and myself. We have not been able to have a relationship as a result of him. This evaluator went into a deposition to report his findings of his evaluation, and under oath, he testified that he administered a psychological test which revealed that I had a formal thought disorder and I could not distinguish the difference between reality and fantasy. As a result, there was a shift in custody, and he felt that it needed to be implemented despite I didn't have due process. It wasn't before the court, but I had no choice to comply. Ironically, this evaluator also gave me the final say over medical and mental health. I am here today to urge you to please support the training that is desperately needed in domestic violence. Because when we did have a custody hearing before the court, my ex-husband hired this evaluator to be his expert witness. He paid him $6,000. Our custody evaluation was $25,000. You have to have money to have these evaluations. I had no choice but to comply. So this alleged neutral evaluator is no longer neutral. When this evaluator was on the stand. He admitted that he did not handle our case as a case of domestic violence, despite even at the time there was a final protective order in place. He admitted that he did not handle the cases domestic violence, and on further questioning, he admitted that the test that he alleged that found that I had a formal.
Have you begin to wrap up, please?
Yes, sir. That I had a formal thought disorder. It was only his recollection that he thought he administered the test. However, he never did. And he admitted on the stand that he never administered the test. Therefore, the results of the formal thought disorder were not correct.
Thank you very
However,
much.
the court still put great weight to his testimony and recommendations and adhered to his evaluation.
Thank you. Thank you very much. Are there questions for the panel? I'm going to begin with Mr. Griffin. Mr. Griffin, did you distribute those pictures to the committee without any indication as to the bill number that they were related to?
I did.
And you set them on people's tables without permission of the committee?
I did.
Delegate Erican.
Thank you, Mr. Chair. Thank you guys for bringing this really important bill forward. I just have a couple questions. If you guys could touch on a little bit more about, if you know, the specific training that like right now is required and what specifically is going to change once, if this bill passes.
I think I'll take the first stab at it, Delegate Erican, and then I'll defer to Mr. Griffith. I think that the main thing is that I came to the sad conclusion that in my opinion, the judiciary cannot be left to its own devices on this matter. So that is the main thing. The bill requires that evaluators undergo training that includes early childhood brain development. Traumatic events affect the development of interpersonal dynamics that contribute to abusive behavior, validity, and training required and preventative measures to mitigate abuse. So I think that that's what it would cover. And I also just want to say, if it's all right, because I ran out of time, is that this was not my idea. This came out of a work group this idea for this bill came out of a work group in 2019 in which the judiciary was invited to participate but declined to do so.
Thank you. Does anybody else want to add any the other topics that are currently covered and what the timeframes actually look like for the education?
The timeframes, I believe they wouldn't kick into, I believe, till next year, so they would have time to set this up. Some of the topics that they would be trained on would be understanding. One of the problems we have is understanding some of the limitations of Child Protective Services investigation, realizing also some of the childhood development issues that relate to child making disclosures, how it's a process, how inconsistencies in the child's story are not necessarily indicative of a child not telling the truth. Usually peripheral topics like time of day, what they were wearing, et cetera, the child will not remember, but they will graphically remember the trauma. We've had custody evaluators say that they didn't believe abuse happened because the child said that it happened on a red couch. And there was no red couch in the house, despite the fact there was a burgundy couch. And a 5-year-old child would confuse the colors. So we have many examples like that. So I think they would have a much greater understanding of the dynamics of childhood development and the dynamics of domestic violence and its effect on the children and its effect on parenting and this deep connection of domestic violence to child abuse, to future child abuse.
No, I just wanted to thank Nora for coming down. We've heard about you for years, so we're really happy to see you down here. So thanks for coming to visit us.
Delegate Kaufman, I think you mentioned something about amendments.
Yes, I do have amendments that I've added, and also the Congressman has joined us, Mr. Chair. I've added amendments to the bill which would indicate that if a child custody evaluator is needed, that the evaluator must have the specific qualifications and the issues identified in the case and require the court to be the entity ensuring that a custody evaluator has the qualifications necessary to be the evaluator for a specific case. And yes, I did send it to the amendments office, but I haven't gotten it back.
Thank you.
Are there further questions for this panel? Seeing none, thank you very much. We'll hear from Wendy Lane, Judy Postmus, Adam Rosenberg, Allison Toyos. Danielle Pollack is going to be virtual along with the congressman. We'll deal with the people who are here in the room first, and then we'll hear from the people virtually. Are any of those people here? Wendy Lane, Judy Postmus, Adam Rosenberg, Allison Toyos. Going once. Susan Carrington, Robin Elliott, Mercedes Faust, Tina Smith. Okay. We'll hear from Ms. Pollack first, please, for 2 minutes. You have to take yourself off mute. Mercedes Faust.
Hi, can you hear me?
Tina Smith.
Sorry.
Go ahead.
Thank you very much, Chairman Clippinger and esteemed members.
Hear from Ms. Pollack first, please, for 2 minutes.
Thank you. I appreciate the opportunity to provide testimony today. I'm the policy manager for the National Family Violence Law Center.
Take yourself off mute.
I'm off mute.
Turn off the speaker
Hi,
on
can
your
you hear me?
computer.
Sorry.
Go ahead.
Thank you very much, Chairman Clippinger and esteemed members.
Hear from Ms. Pollack first, please, for 2 minutes.
Thank you. I appreciate the opportunity to provide testimony.
Pollack, please turn off the speaker on your computer or turn down the volume on the speaker on your computer.
It should be off. Can you hear me now?
Yes, go ahead.
Sorry about that. Thank you for the opportunity to provide testimony today. I'm the policy manager for the National Family Violence Law Center at GW Law in Washington, D.C., which provides pioneering empirical research, training, education, state and federal policy development, and select litigation on behalf of family violence victims, including children. I urge a favorable report for HB 405, which sets forth appropriate qualifications and training, including in family violence subject matter for child custody evaluators. HB 405 would bring Maryland into alignment with guidance from Congress on this matter, as per the 2022 Violence Against Women's Act, Title 15, also known as Cadence Law. As you've heard today in the many examples, and as research shows, when domestic abusers are litigating custody, children are at heightened risk of harm. And without appropriate mandated statewide training on family violence, it is very challenging to minimize the potential for evaluators overlooking or misunderstanding signs of abuse, which routinely rise in custody cases where children's safety is at stake. Current guidance in Maryland rules on this matter is insufficient. The rules that you have simply ask that evaluators have current knowledge of DV and child abuse and the impacts of divorce on children. There's no hourly requirement. The training that they need to have is simply on how to do evaluations. And otherwise, they just need current knowledge on DV and child abuse, and this is insufficient. Appropriate mandated training also helps guard against personal biases, such as unwitting victim blaming, which can result in harmful reports and recommendations to courts from evaluators. A 2019 NIJ funded empirical study, which looked at contested custody case outcomes in the US, which involve abuse allegations nationwide over a 10-year period, found that the presence of a court-appointed evaluator or guardian ad litem in these cases can increase bias. Specifically, it increases courts' disbelief of mother's abuse allegations and increases custody reversals from a mother alleging abuse to the allegedly abusive father. So we do urge a favorable report, and thank you for the opportunity to provide testimony today. Happy to answer questions.
Hoyer for 2 minutes.
Mr. Chairman.
Can you hear me?
Yes, go ahead.
Mr. Chairman, thank you very much for allowing me to testify. Mr. Chairman, each year in America, as many as 58,000 children are forced into unsupervised contact with abusive parents through custody or unprotected visitation. Sadly, a custody evaluator, judges and lawyers often are fail to detect and address this abuse adequately and expeditiously. We can't let that continue. That's what this bill is about. Thank you, Mr. Kaufman. This is a matter of life and death for these children. The Center for Judicial Excellence found that since 2008, 984 children have been killed by parents in situations involving divorce, separation, custody, visitation, child support, or court involvement. That's roughly one child per week. 21 of those murders occurred in Maryland, Mr. Chairman. 21 children shot, strangled, stabbed, poisoned, drowned, or beaten to death by their parent. Many more children survive, but to live with the scars of this abuse for the rest of their lives, as we've heard. These children are often too young to read, speak, or even walk, let alone comprehend why this abuse is happening to them. We each have a duty, Mr. Chairman, to stand up for the youngest and most vulnerable among us. That's why as Majority Leader last Congress in the Congress, I helped lead the effort to reauthorize the Violence Against Women Act, which included Caden's Law, as you've heard. That law was named for a 7-year-old killed by her father, whom the courts knew to be dangerous, but they nevertheless allowed him to have unsupervised visitation with Caden. I strongly support this bill. As you know, Ann Hoyer is my daughter, but I do not support it for that reason. This will help our state meet the standards that Caden's Law established. We need to ensure that well-trained, competent experts make these life or death decisions for our children. We must also do more to prevent the circumstances that require these decisions to be made in the first place, of course. This bill does not seek to undermine parental rights, but it does seek to make the safety of their children paramount. This bill is about speaking up for children who often don't have a voice, protecting those who cannot protect themselves. I urge you to advance this crucial legislation. Thank you, Mr. Kaufman, for sponsoring it. Thank you, Mr. Chairman.
Toyos, please.
Hello, thank you for the opportunity to testify today. My name is Ali Toyos, and I am a child survivor of the family court system and the founder of Center for Judicial Excellence Youth Speak. Following my parents' divorce when I was 8, my father's hate for my mother quickly transformed into physical, sexual, and emotional abuse of me and my younger sister. When I reported my father's abuse to our guardian ad litem and court-appointed therapist, I was immediately dismissed and told that, quote, "In life, sometimes we have to do things we don't want to do." When my sister and I refused to live with our father out of sheer terror of what he would do to us, our court-appointed case manager threatened us with rape as well as with being separated and sent to juvie. Instead of investigating our father's abuse, the court allowed him to defend his actions using the pseudoscience parental alienation. As a result, with the help of our case manager, the judge ordered that we be trafficked into our father's custody through a reunification camp called Family Bridges and be completely cut off from our mom. Transport agents were hired to kidnap me and my sister from a courthouse in Kansas and take us across the country to Montana, where the camp was run out of a hotel room. The camp leaders withheld food and water, relentlessly interrogating and threatening me and my sister. These camps ensured that my sister and I were forced to be perfect, silent victims for our father. It has been more than 4 years since I was able to escape my father's abuse by aging out of the family court system, but I continue to struggle with the effects of this trauma. I have been diagnosed with PTSD, which permeates every aspect of my life, including school, work, and relationships. Not only was this precipitated by the years of abuse I endured at the hands of my father, but also by the trauma of being ignored by the court professionals who were supposed to protect me. Unfortunately, our case is not unique, and children across the country are forced into their abuser's custody through reunification therapies and camps recommended by custody evaluators and ordered by courts who do not have the adequate training to protect children in abuse situations. So I support this bill to protect children in family court. Thank you.
Wendy Lane, please.
Thank you, Chairman Clippinger and members of the committee. My name is Wendy Lane. I'm a child abuse pediatrician at 2 child advocacy centers in Maryland, and I'm testifying today on behalf of the Maryland chapter of the American Academy of Pediatrics in support of House Bill 405. Part of my work as a child abuse pediatrician is performing medical evaluations of children with suspected sexual and physical abuse. And I always start by talking to the parent or caregiver prior to the child's exam. It's not uncommon for the parent to tell me about incidents of sexual abuse, domestic violence, or physical abuse by the other parent. At times, they're really desperate to protect their child from their partner or their former partner and request my help. But without a definitive determination of abuse from the investigation, the parent's only recourse is a court hearing, a custody hearing. And so it's incredibly important that at that custody hearing, there be a neutral party to evaluate the family and to make recommendations about what is best and safe for the child. We know that exposure to adverse childhood experiences, such as child abuse and domestic violence, put children at risk for long-term physical and mental health problems, but these risks can be mitigated by the presence of supportive adults. And ideally, a skilled neutral party would be able to assess the situation, and that person should have education in things like domestic and family violence, the limitations of child welfare and law enforcement investigations. They should know about child development and ways children may respond to trauma. And for all these reasons, I urge you to support House Bill 405. Thank you.
Okay, I think we'll take questions for the people who have spoken so far, and then we'll try and unravel who's actually here and who's not in the room. Are there questions for the panel? Delegate Cardin.
Mr. Chair, this is for the law professor who I think is back on from GW. Is that, yes, Ms. Pollock? Yes, okay. The General Assembly is not generally in the business of mandating curriculum, specific curriculum, just saying, yes, I mean, I can understand why you want training, but it seems to me as if whether it be the issue is not that the people who are the evaluators are not educated. It seems like they all are required to be educated to a certain extent. But the problem is that you want them to be educated in a very specific area of curriculum. Why not go towards, or are other states looking at this from let's talk to the judiciary and see if the judiciary can require the training on their own as opposed to mandating it from the state?
Thank you for your question. Other states are moving in this direction. Colorado and New York have both legislated trainings for custody evaluators because they have been found to be deficient when it's simply in the rules. As someone stated previously, a judge can overlook the rules or disregard if someone does not have what's set forth in the rules. And what's set forth in your rules currently is quite limited, as I remarked in my testimony. So it's there's many sort of systemic problems in family courts, and research shows that without requiring this kind of training, custody evaluators are just not getting the needed information. They're being misled by abusers in these cases, as many people testifying today spoke about. So, as you're well aware, if something is legislated, the evaluators will have to do it. And when it's in the rules, it is not binding. And unfortunately, many evaluators, it's just insufficient. And they're making really grave errors in many cases, and it's resulting in children getting ordered to.
I just worry that if we mandate something, and then they can't figure out a way to teach people how to be unbiased, and to follow the law, or they are focused, if their biases are turning them from looking at the law as it's specified, it would be a concern to me that should be what the judiciary is looking at, to make sure that the training is getting them to do what they're required to do. And if there are lots of mistakes going on, then they ought to be making sure that, I mean, I don't think that the courts want to make the wrong decisions.
No, I don't think so.
I'm not exactly sure why, if we're explaining to them they're making the wrong decisions, they have to figure out the training themselves. It would seem to me that they should be willing to do that. I'm not exactly sure why mandating it. It seems like you're saying, yeah, we're going to mandate it, but it's not necessarily going to change behaviors because we're mandating this 20 hours, which may already be happening. It's just that they're not able to do the proper training as is. I'm sorry, Mr. Chairman.
I'm pretty sure they are not being trained in evidence-based material for 20 hours on child abuse and domestic violence in a sort of comprehensive and rigorous way. They may have some preliminary training or maybe an hour of training here and there, but it's clearly not sufficient. And many states and work groups have been calling on courts to improve in this area. As the representative, the sponsor said earlier, these recommendations grow out of a Maryland work group, and experts, within the state and national experts looked at how courts were handling this. That work group was in 2019. We're in 2024, and these improvements have not yet been made. So we can just keep leaving it to doing it, the status quo. But as you heard from the testifiers today, many, many, many families just continue to be failed. So I would hope that you would take their testimony and the research and guidance from Congress into serious consideration. I mean, Congress, in a bipartisan fashion, which they rarely do these days, has agreed that this is a crisis and that this is necessary, and that state courts do need to have mandated training on these subject matters. It's 8 subject matters, including bias. So I would hope that you would consider that when you're thinking about your vote on this bill.
Any other questions? Seeing none, thank you very much.
Thank you.
Try this again. Judy Postmus, Adam Rosenberg, Susan Carrington. She did? All right, just making sure that the list here is all over the place. Robin Elliott. Don't think I saw her. Okay. I see Jocelyn Wolf on here, and we'll hear from you in a moment. Mercedes Faust, Tina Smith, Yakov Eichenbaum, Colleen Gizinski, Laurie Krawcheck, Jared Ross, Marissa Sanchez, right, what we'll do is we'll hear from Jocelyn Wolf because she has been on virtually, and then we'll go to the people in the room. Ms. Wolf, please, for 2 minutes.
Thank you. Good afternoon, ladies, gentlemen, and members of the committee. Thank you for the opportunity to express my enduring support of House Bill 405 for compelling reasons, of which have led to poor long-term health determinants of my daughters. One who is being trafficked and now works as an escort. The other who is struggling with dysregulation, has recently given birth to a child. and drug use despite her pleas of being coerced into using drugs in my abuser's home, something of which he admitted to in a parent-teacher conference. My support of House Bill 405 stems from my youngest daughter getting knocked out of her father's home, my abuser bearing witness and refusing to take her to be treated, accusing her of faking it, resulting in my taking her to treatment the next day, only to hear the pleas of a doctor to not return her to her father's home, and noted that Child Protective Services would be notified. My support of House Bill 405 stems from a judge making an executive decision supported by a BIA, best interest attorney, in stark contrast to the evaluation of the court evaluator who determined neglect was taking place in my abuser's home. The home was not suitable to live in, and abuse, drug and alcohol exposure to minors, along with reportedly underage sex of minors taking place in the home of my abuser. My support of House Bill 405 stems from an administrative judge knowing the specifics mentioned here in this testimony and removing it from the docket herself, further concealing it from the docket and what was transpired. My support of House Bill 405 stems from this long-moving, slow-moving tragedy that I will never know will end. Without hesitation, I support House Bill 405. Thank you, ladies and gentlemen, for your time.
I'm going to call one additional person because the name on the document we received from the sponsor is incorrect, and I think I figured it out. Tina Swithin is with us on there virtually, and we'll hear from her for 2 minutes and then go to everyone in the room.
Thank you, Chair and Committee. My name is Tina Swithin on behalf of two different organizations, One Mom's Battle and Family Court Awareness Month. I am in strong support of HB 405. My organization has an active chapter in Maryland, which gives me a front row seat to what is happening in your state. And when I think of the family court system and the reality of child custody evaluations, it is best described as the wild, wild west, which implies lawlessness, danger, and lack of regulation. This is unacceptable when we are talking about the lives and futures of children and survivors of domestic abuse. To say that we need higher standards and better training when it comes to child custody evaluators would be an understatement. Every day I hear horror stories. This is a crisis, and we need all hands on deck. You are cradling the lives of children in your hands right now, and your vote will ripple through and impact future generations. Please vote yes on HB 405.
Thank you. We'll start from my right and head over, please. Go right ahead.
Delegate Clippinger, members of the Judiciary Committee. My name is Melissa Krofchek. I am a mom of two from Hartford County. HB 405 is a well-intended and desperately needed bill. The intent to train custody evaluators to learn the signs of domestic violence with the goal of not missing legitimate cases of domestic violence. There is no disagreement that the evaluators desperately need training. However, the bill does have some critical errors. First of those errors is that the bill dictates who can testify as expert witness and who can act as trainers for the evaluators, and limit those permitted to a very narrow cohort. By limiting the breadth of permissible experts, critical expertise in personality disorders, parent-child contact problems, and unhealthy attachment are neglected. Maryland follows the Daubert standard, and that is the standard we should follow with HB 405. Also of concern is the carefully crafted wording on page 5. Bill dictates that trainers are those who have expertise in DV and child abuse. This sounds extremely common sense. However, there's implicit bias in people who have only experienced DV and child abuse. And it looks like they have a hammer, everything looks like a nail. Secondly, on page 5, the wording of evidence-based research recognized by experts. Again, this sounds so very common sense, but make no mistake. This is carefully worded to exclude claims of parental alienation and psychological abuse. I understand that parental alienation is a taboo word. I understand it's been misused to convince judges into reversing custody. However, there's a flip side to that coin. Parental alienation is also very real. Children can and are manipulated into rejecting safe and protective parents. This is devastating to the child and parent alike.
Parental alienation is not debunked. It's not junk science. It's not difficult to prove. It is severe psychological abuse, serious post-separation abuse, a form of family violence, and excessively damaging to children. I urge you to support 405 with proposed amendments.
Thank you, Mr. Chairman. I'm Yakum Akibam, representing the Parental Alienation Study Group. We favor this bill with amendments. Our amendments are in the written testimony. This bill states that belief systems and theories that are not research-based cannot be included in the training. Those familiar with the history of this bill know that this is specifically referring to parental alienation. In fact, one of the stakeholders who spoke today on her website, it's from the National Safe Parents Organization, states that parental alienation is debunked. That's interesting because the American Psychological Association in its 2022 custody evaluator guidelines mentioned at least 20 times that evaluators should be trained in parental alienation and in false abuse allegations. Parental alienation is a severe form of psychological abuse, just like domestic violence and sexual violence. It does not get better by itself. It needs the intervention of professionals and the family court system. This bill will prevent parental alienation claims from courts and also limit who could be an expert witness to a very small group. And this is also geared to eliminating parental alienation claims. I've written 3 books about the deception that's going on about parental alienation, including the Maryland Work Group in 2019, and something that the Congressman mentioned on the Zoom about the 58,000. That figure is actually in this book is absolutely ridiculous. And there's a lot of public policy deception that's going on here that's misleading well-meaning legislators like yourself. It's time to end the deception. We need evaluator training, but it has to be inclusive parental alienation also. Our amendments will accomplish this, and it will train evaluators to deal with all forms of abuse and give judges and evaluators the knowledge they need to make informed decisions in these very complicated cases. I'll be happy to answer any questions about our amendments, about the science of parental alienation, or about the public policy deception campaign that is going on concerning these issues. Thank you.
Hello, thank you. I'm Colleen Gazinski. I support this bill with amendments that include training for custody evaluators in the dynamics of parental alienation. I have 2 alienated grandkids, 12 and 14. My son is their alienated dad. Our family has been impacted by parental alienation since fall of 2020. And I can assure you that it's real. It's devastated our entire family, and most of all, my grandkids. In addition to the alienation, the 50-50 joint custody order has not been followed, resulting in my son being denied the right to parent his children and his children being denied the right to their loving, fit parent. There are no allegations of domestic violence, sexual abuse, addiction, or neglect in our case. When a parent defies a court order, there is no recourse other than to go back to family court, which in our case included multiple assessments by a custody evaluator. For 3+ years, we've navigated family court, including best interest attorneys, 2 rounds of reunification therapy, psychological evaluations, multiple individual therapists, and a custody evaluator. We've spent tens of thousands of dollars in legal and therapeutic fees. My grandkids and son are currently in therapy and will be for a long time. After 3+ years, there's finally some recognition of what is happening in our family. But 3+ years later, my grandkids are shells of the happy children they once were. In the past 3 years, one or both of my grandkids have manifested panic attacks, dysregulation, vomit phobia, obesity, adjustment disorder, school refusal, fainting, failing grades, suicidal ideation, disruptive behavior, lying, stealing, severe anxiety, including physical symptoms as a result of the psychological abuse of parental alienation. It shouldn't take 3 years to figure out what's going on. Custody evaluators need to be trained on more, not less. When a child's mental health is at risk, we should not limit the tools available to a custody evaluator. We need to equip them with as much knowledge as possible so that they can do their best job to render sound judgment and effective solution in an efficient manner for the health of our children. I recommend a favorable report
you.
with the appropriate amendments. Thank you.
Thank you. Delegate Valentine.
Thank you, Mr. Chair, and thank you, panel, for coming in today. Your testimony has spurred a few questions that I have. I'm trying to read some of the documentation and testimony that you've sent me, as well as the rest of the committee. The first I would like to talk to you, because it's the first I've heard today, is the parental alienation. This is not my expertise, so I'm trying to get a little bit more understanding under that terminology. So when you mentioned that, I'm looking in the bill and it talks about some of the training, and could that fall under one of these categories, such as coercive control, or does that fall under or similar to that? That's my question to you. Is there a difference? Is there a difference?
Thank you. That's a very good question. Yes, it could fall under coercive control. And there is actually some watershed studies that came out last year. I can send them to you. How it does manifest all the classic symptoms of coercive control. The problem is that was not the intention of putting it into the bill. And if you go back, I think this is the third or fourth year that this bill is being proposed. Originally, when it talked about belief systems, it explicitly said such as parental alienation. So we fought that then, and that language was taken out, but the intent is still there. That's why that wordage is there. So even though it could, a good lawyer might be able to get that to be under coercive control in court, but you're still fighting the rest of the legislative intent of this bill, which is precluding it.
Can I have a follow-up question? Thank you, Mr. Chair. You've mentioned in your testimony two other topics. One was a standard. I think it was the Daubert standard.
Yes.
For possibly, I guess, training. Could you elaborate just for in layman's terms what the Daubert standard is?
So my understanding is it's a judge examines the witness. I'm not a legal expert here, but
In your testimony, that's why I wanted to ask what
I
that.
did. You have two attorneys who can each examine the witness and decide, right? So why would you limit somebody outside? If there's a problem with that witness, then those attorneys should be able to distinguish that.
Okay. And last question, Mr. Chair. You mentioned, Mr. Eichenbaum, amendments, and I see you have several. Is there anyone in particular that you would like to elaborate on?
Yeah, basically, I would say there's three things that permeate the whole bill. First, that we want to have psychological abuse, including all types of child-parent contact issues explicitly mentioned in the bill. Second, we want to have this nonsense about belief systems. And this is a no-brainer. You don't put non-scientific information into training. This was put there to exclude parental alienation. So we want that clause removed. And the third thing is we don't want to limit expert witnesses to just a very small group. You could be trained and be very good in domestic violence, but there's a lot more information you need to know. If you don't know the science of suggestibility of children to be able to detect if they're telling the truth or not, then you're not going to be able to make a good determination. So we want to expand the training, as Melissa was saying, to really comply with the Daubert standard. The Daubert standard says that it's up to a judge's discretionary ruling to decide if a person has expertise in the field, and then they can be accepted as a witness in court. The way it's written now, it's saying, no, the judge does not have the discretion. We, the people who are in domestic violence community, we will decide who is an expert witness. So we just want that removed and leave it back to the Daubert standard like it should be.
Thank you, Mr. Chair. Thank you guys for being here. Could you go over what the symptoms are? How is how is the parental alienation diagnosed, or just give me some examples?
Great, good question. They've developed there's actually a number of different ways. There's no one definitive test. As in any social science, you have to look at a lot of different factors. One system they use is called the 5-factor model. And I can send you some information about that. And basically the 5 factors, I hope I may remember all of them. First of all, just is there a no contact, or is there something going on that's wrong with this relationship? Number 2, that there had to be a prior positive relationship with the parent. The only exception to that possibly being, let's say, if the parent was separated at birth, so there was no chance for a relationship to develop. The third would be that there is no history of domestic violence and abuse that would legitimize why the child doesn't want anything to do with the parent. The fourth one is that
I can't remember.
that the other parent, we call it the favorite parent or the alienating parent, is engaging in there's a list of 17 different behaviors that they're engaging in that could cause the relationship to be separated. One could be bad mouthing the other parent. In my own case, my ex-wife told my children, "You can go visit your father on Sunday if you want to. You don't have to." Now that gives a very subliminal message to the child. Oh, well, is there a reason why I shouldn't want to? Is there something wrong? Obviously, mom doesn't want me to. This was just on a very subtle level. So there's 17 different behaviors that a parent could be engaging in, all the way to the extreme. And they have I know of cases where they've literally had a picture of the parent there, and they throw darts at that picture every morning. And then what's the last one? I'm missing one. I'm blanking out now.
Yeah.
But there's another factor also.
And there's manifestations.
Oh, yeah, thank you. And the other one is that there are 8 unique characteristics that a child could be manifesting, several of these or all of these. For example, if we don't live in a black and white world, no parent is perfect. We all make mistakes, and our children can have, I don't like that because he didn't let me do this or whatever. Okay, but there's also good points. If a child only has totally bad things to say about a parent, which incidentally is usually not typical. If you have a child that was physically abused, then they still can find some redeeming merits in the parent in many cases. It manifests itself totally differently by alienated children, that they have a black and white mentality. So when you have all these 5 factors, and then you see a pattern of history over time, so that gives strong indication of what's going on. There are also some psychological tests that can be given that they don't stand alone, but in combination with other things that can point in that direction.
So who makes this determination usually? Is there an expert that the courts use, or is this part of the custody evaluator's job?
Well, a good custody evaluator should be able to do this.
Okay. And then if they wanted to do that, where do they go to learn about this stuff if it's not already being included, or is it already included? This is already being taught, isn't it?
Well, it's not taught nearly as much as it should be.
Interesting.
There are like private training experts in the field who are offering training at national conventions and different things like that. There is, forgot what it's called. It's an associate of the American Psychological Association. They have a special institute for forensic evaluations in general.
Okay.
And one of the subspecialties is for custody evaluators and family law issues. It's a very comprehensive program. It actually makes 20 hours look like a joke. I think the family law component is like 80 hours.
Okay. So you guys agree though that, so the ones you gave me, there should be no history of domestic abuse, but I assume you guys know that that was, I guess, number 3. Oftentimes in cases where there is a history of domestic abuse, parental alienation is still being used?
Okay, so that is a very good question. Thank you for asking that. People can misuse the system, just like by domestic violence. Domestic violence, we heard horrific stories today. My heart goes out for all the parents who had to suffer this. But we know that people do make false allegations as well. Parental alienation is a really real phenomenon, and people can make false allegations. It can happen, just like in a criminal case. You know, we have a defense of temporary insanity, right? Does it exist? Yes. Is it misused? Sure it is. So you don't throw out the defense because it's misused. You put in the proper diagnostic techniques and train people to know to see what's going on and what's not.
Do you have any data you can provide on how often it's being misused? Like, for example, for rape convictions, we have some data on sort of how many they're actually being prosecuted. It's like 6%. It's very small. So I'm just wondering, you know, do you guys have any data that supports the idea that it's sort of rarely being misused?
I'm not aware of any data of the misuse. It's a very hard thing to determine because you have to be looking at case studies. In America. Trial case decisions are not available to the public. There was studies done on appellate decisions. Ms. Pollack referenced a study by Joan Meyer from George Washington University, where she claims that parental alienation is being misused and it was being used as a defense against abuse allegations. That study, incidentally, was not a peer-reviewed study, and it has been subsequently refuted by a number of different studies. You know, she claims that it's used a lot, but there are no statistics that I'm aware about it.
Thank you, Mr. Chair. I'm just thinking back in my days of doing some family law and how all of this will play itself out. But on this issue of parental alienation, when I look at this bill, we're looking at 20 hours of initial training and 15 hours of training every year. The parental alienation in and of itself is a very complex matter. Wouldn't this be better as a separate discussion, perhaps even a separate bill to address this issue? Because it just doesn't seem like we've got a group of trained professionals already, and we're adding this additional to help safeguard this idea of evaluators. So I'm just concerned that we're asking too much.
I agree with you in a certain sense. I think even 20 hours for domestic violence, and I think the domestic violence group would agree that 20 hours really is not enough just for that alone. We had a meeting with the stakeholders of the bill, and they suggested the exact same thing, that parental alienation should be in a different bill. And I don't necessarily have an issue with that. The problem is that it's not just that this bill doesn't include it, but it excludes it. And it's discrediting it as a legitimate science, which it's not.
I'm not sure that it doesn't include it, but it doesn't mean that it's not something that
have you ever seen in any training bill, let's say you have a law enforcement training bill, that you should not train police officers in any belief systems or unscientific theories? I mean, that's a no-brainer. Why is that in the bill? There is an intent behind that, and we know what it is because it's said explicitly in previous sessions. That is coming to exclude parental alienation.
Further questions for this panel? Seeing none, thank you very much. That concludes the testimony of those testifying in favor of the legislation. We're going to hear now in opposition. Lindsay Parvis, Laurie Ruth, Melanie Shapiro, Mary Stengel. And whoever would like to go first.
Well, I'll jump in. Thank you, Mr. Chair, Madam Vice Chair, and members of the committee. Thank you very much. My name is Lindsay Parvis. I'm here on behalf of the Family Law Section of the Maryland State Bar Association. I'm a family attorney in private practice. I've been doing this a little over 20 years, mainly focused on high conflict custody cases. I've been a best interest attorney. I have taught at the Administrative Office of the Courts on a variety of subjects. I've been involved in the Administrative Office of the Courts work group on developing a custody evaluator training standards and putting on the custody evaluator training that occurred last year. So it's my pleasure to be here. I submitted a very long, on behalf of our section counsel, written testimony. I apologize for its length, but there's so much to be said about this bill. I think one of the two things that stand out to me most, one from the bill and then one from the discussion that's been had here today, is first from the bill, is that if you take a look at it, it mandates custody evaluations for families if certain facts are pled. And this comes up on page 3, and I realized in my written testimony, I cited it starting at line 11. In fact, it's line 22. But when you see this, you get to these categories where then you get to page 4, any other issue relevant to a custody proceeding that the court determines requires specific experience, education, training, or supervision. And as written, this is in any case in which custody or visitation is an issue. So it's not necessarily in parent-to-parent cases, if I may just finish my thought. Thank you. Not just parent-to-parent custody cases, but this could include domestic violence and Senate TPR cases. It's not a limited bill. The other, if I may, that my other thought from today's discussion is we're having a interesting and lively debate about parental alienation. Were this bill to pass, every single category of training for custody evaluators would come before you and be debated in the same vein. And custody evaluation training would grind to a halt.
Good afternoon. My name is Mary McNeish Stengel, and I'm a licensed clinical social worker who's worked as both a court employee and a contractor for the past 15 years. I'm here to speak to you today about what court-based evaluators actually do, and in opposition to House Bill 405. In many jurisdictions, evaluations are ordered in cases where the parties have no counsel and the court needs a neutral picture of what's happening in the family. The average evaluation takes 40 hours to complete. We're required to interview both parents and their partners, interview all the children, observe the parents with all the children, and observe the families in their home environments. We interview and observe family members who live in the home but are not parties to the case. We review academic and attendance records, medical and mental health records of children and adults when allowed, Child Protective Services records, and police records, as well as the entire court file. We're also required to speak to collaterals. We write a report incorporating all the information collected and have it completed, usually within 30 to 45 days of starting a case. We put our personal safety at risk by going into the homes of families who are understandably hostile about us intruding into their private matters. And in many courts, the starting salary for an evaluator is $65,000. As mental health professionals, we are ethically bound to have the required training necessary to do the work. These are forensic, not clinical evaluations. Our training, by its nature, includes maintaining a constant awareness of the interplay between clinical issues and their impact on the family in a court-related process. This work is not for the faint of heart, and it's done with a deep sense of responsibility and commitment to the welfare of the children and the families that we serve. Thank you.
Good afternoon, Mr. Chair, members of the committee. My name is Laurie Ruth. I'm the Chief Programs Officer at the Women's Law Center of Maryland. We are also here in opposition to this bill. I participated in the a work group that gave rise to this bill that they've been trying to pass for several years. And I don't think there's anybody who doesn't want the people doing these custody evaluations to be properly trained. But there are just so many flaws in the way the bill is drafted. And I commend you to the Family Law Section Council's testimony as well as the Judiciary's testimony. I concur with Ms. Parvis that I think if this were passed, it would grind custody cases to a halt. And I spoke with somebody at the AOC on a call that we had with Delegate Bartlett's Chief of Staff. And she said, and I think that this is fair, people are not screaming to come and get these jobs. They are grueling. They put people in danger, as was just testified to. It's thankless and it's a lot of hard work. And when you place so many requirements on people, you're not going to find the applicants that you want. So that's just a little tiny bit of why the Women's Law Center opposes the bill, but we certainly urge an unfavorable report. Thank you.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. Melanie Shapiro with the Maryland Network Against Domestic Violence here in opposition to this bill. I just want to reiterate a couple of points that have already been made. One is that this bill is so specific in terms of its training that any attempt to modify that training, whether it's another category, new research, new developments, new treatments, all of that will have to come before this body. Currently, this is in the Maryland rules. That is a much easier process in terms of changing it. We think that this should stay in the Maryland rules. The second is actually to Delegate Cardin, one of his questions earlier in comments is regarding the training. And the training is not necessarily going to change behavior. And so if there's concern regarding the behavior, we need to address that. But adding on specific training requirements, adding on everything that this bill is doing is not necessarily going to change a person's philosophical approach to as a custody evaluator. They are professionals, they are supposed to be unbiased, and they are in fact trained already. I would also reiterate and ask that you review, I'm on section council as well, and MSBA has gone through point by point through the bill and explained their concerns with it. And so we urge an unfavorable report at this time.
Thank you, Mr. Chair. Thank you all for being here. I have a couple questions. The first is for the second, you were custody evaluator?
Yes.
Okay. So you had mentioned that you, the list of things that you guys look at, and you had mentioned things like other people that are in the household, collaterals, but isn't it true that you guys have a pretty wide berth? So you don't have to do all those things in every case, do you?
Well, there are mandatory elements per the rule. There are mandatory elements to a custody evaluator and there are optional elements. And I think that, I mean, I have a copy of the rule. I'd have to go back and review it, but.
Me here, because the judiciary sent it over.
I mean, some of them may be optional. I can only speak for, I ran the program of custody evaluators in Baltimore County, and we would always make it a practice to speak to anyone who's potentially in a caretaking role in the family or lives with the family.
Okay, yeah, it looks like in the rule that's not required. In fact, it even only says it's only if feasible should you actually observe the children with each party. So the actual requirements look very limited, extremely limited, it looks like. And there seems to be leeway even in under the mandatory elements piece of it. So it's possible, and you tell me if this is true or not, that in some jurisdictions or even with some evaluators, people are getting a completely different quality of review. Maybe some are getting, pediatricians are talked to and family members are talked to, grandmas, whoever is, but in other cases, they're just doing the bare minimum. Is that possible?
I suppose it's possible. I have not seen that.
I can tell you for sure it is possible, because I've personally seen the bare minimum done in a case. So it's definitely happening. It's happening this year as we speak, that these even these bare minimums are not being met currently in the state of Maryland. My other question is, it was said that there's like a required education currently in the rule, but I'm looking through the rule. It says here that the court can actually waive all of the requirements. It looks like it's on page 3 of the rule. It literally says training experience unless waived by the court.
I have no knowledge of anyone who has waived those requirements. And what I would also add is that as mental health professionals, not attorneys, the last place we ever want to be is under cross-examination in a courtroom. And we make sure that we prepare ourselves with as much training as possible to be able to withstand that scrutiny in court.
Okay, that my last question for you is, how many cases have you been involved with where parental alienation was alleged, and how many have you been involved with where it was actually occurring, where you found that it was occurring?
I wouldn't be able to answer that without reviewing.
Would
my
you say it's a
cases.
significant portion where it's alleged?
I don't feel comfortable answering that.
Okay, thank you very much.
Are there other questions for this panel? Seeing none, thank you all very much. And that concludes the testimony on House Bill 405. Delegate Embry, please. House Bill 667 is next, followed by 508 from Delegate Embry. So we'll hear 607 now.
Chair, is it all right if I call the panel?
Yes.
I'm sorry, there's a gentleman who says he was.
I wasn't called for the last bill. My name was, I got an email, I was supposed to testify opposing.
You're opposing the bill?
Yeah.
Have a seat. Delegate Embry, we need a moment. We're
Yep,
gonna take
okay.
this on the last bill, House Bill 405.
Sorry, but
No, that's all right.
should I just start?
Go.
My name is Larry Heller. I'm a licensed psychologist and chief medical officer of the medical division for the Baltimore City Circuit Court, where I've worked for 27 years. Our office evaluates about 350 people a year involved in custody cases. Thank you for allowing me to speak to you in opposition of House Bill 405. The goal of every custody evaluator in Maryland is to provide recommendations that are in the best interest of the children involved and ensure their safety and the safety of their family members. This bill, as written, will increase the risk of harm to children, especially low-income families, and here's why. First, the bill will disqualify most custody evaluators throughout the state from doing evaluations. They would not have the clinical experience or training in psychological testing mandated by this bill. These requirements are unnecessary and redundant to the current standards for custody evaluators. Evaluators are already required to have significant training in domestic violence and child abuse. This will make it much more difficult to retain the evaluators we have and to hire new evaluators. There is already a shortage of qualified custody evaluators in Maryland. Second, the bill states that in cases involving substance abuse or child neglect and other issues, the court must appoint a custody evaluator or a licensed healthcare provider. Most cases in the family division courts involve these issues. This will result in an enormous increase in referrals for evaluations. My office and offices like mine would be overwhelmed to the point where it will shut down our ability to perform our services to the court. The proposal that every case involving allegations of substance abuse or neglect, as well as other factors, be referred for evaluations is frankly absurd and completely unworkable. Finally, the bill will disqualify, because the bill will disqualify the majority of evaluators and make it much more difficult to hire evaluators, there will be a huge backlog of cases. Families who cannot afford a private evaluation and who are in the most need for evaluation, which is the majority of our cases, will wait many months to be evaluated. This delay will increase the risk of danger and violence to the children involved. This bill is harmful to the children that need the most protection from the court system of Maryland.
All right. Thank you very much. Are there questions for this witness? He was on the list. I think I called out for you, may not have been right then. That's fine. You're here, you testified. Thank you very much. Now we're done with House Bill 405. Now House Bill 667. And I believe you're bringing up Robert Harvey, Jennifer Bevan Dangle, and Patty Crankshaw Quimby, correct?
Thank you. Yes, correct.
Thanks.
I'm sorry. Thank you, Chair, and all my wonderful committee colleagues. This bill is in the area of animal abuse. Specifically, it is an attempt to allow the courts, or actually restrict the courts in a way, to considering each animal as a separate, the abuse or neglect of each animal as a separate incident for purposes of sentencing. State's Attorney Harvey, who's here, who serves on the Sentencing Commission, will speak more about the impetus of this bill, which came from the sentencing guidelines. This bill does not directly speak to the guidelines, but it is an attempt to address the same issue. And so what it does is in the area of animal crimes, the entire subtitle, it says that each separate count involving separate animals shall not merge. It doesn't require that the judge sentence consecutively. All sentences can run concurrently, does not require higher sentences, but it just prevents merger. We see that, and the State's Attorney will speak more to this in cases of neglect, where the act of neglect may encompass multiple animals. But we want to allow, if a State's Attorney chooses to charge each animal victim as a separate count, we want the judge to consider each one separately. So the goal again is to treat animals, each one who is abused or neglected, as a separate criminal event. Again, it does not mandate consecutive sentencing. I think that's a really important point, but just requires a separate consideration. Another issue that has been raised that we have been talking about and thinking about is whether to be more explicit about victimhood. That is very complicated. Animals are property under Maryland law, but whether it's possible to carve out a very limited exception just for crimes involving animals. So we may present some uncodified language to you, just expressing that, but I would consult with all of you before doing so. But the bill as is prevents merger of counts. And I will now turn it over to our expert, State's Attorney Harvey.
Good afternoon, everybody. My name is Bob Harvey, and I am the state's attorney in Calvert County. I frequently remark that if Abraham Lincoln can deliver the Gettysburg Address in a minute and a half, I can say what I have to say in the same amount of time. Yay! The message is, yeah, man. Well, I'm a lawyer, you know. The message is, ladies and gentlemen, the punishment should fit the crime. It's a basic tenet of our criminal justice system. In some animal cruelty cases, I can tell you today that's not happening. The reason is that under current law, abusers of multiple animals, like people who are engaged in dogfighting rings, may receive the same sentence as persons who abuse a single animal. That is because under the Maryland sentencing guidelines, animals are not classified as victims. No matter how many animals are involved in a particular case, under the guidelines, the sentences do not stack like they do in cases involving multiple human victims. This bill will correct that problem. It makes clear that each violation of the animal cruelty law is a separate offense. Therefore, for each animal that is abused, the court must impose a separate and distinct sentence and may not merge the convictions. The court does, however, as the delegate has pointed out, still retain the discretion to run the sentences concurrently or consecutively as justice requires. This bill will help to ensure that in animal cruelty prosecutions where multiple animals have been mistreated, like dogfighting or cockfighting rings, the punishment does indeed fit the crime. Thank you. How'd I do? Yeah.
Good afternoon, Mr. Chairman, members of the committee. My name is Jennifer Bevan Dangle, and I'm the Maryland State Director for the Humane Society of the United States. We're very grateful to the delegate for bringing this bill, and we're really grateful for this committee for having this discussion. Animals exist legally in this incredibly murky area. They are legally property, and we understand that in some ways affords them some benefits and protections under the law. But in cases like this, where you do have living creatures who, in many of these cases, such as dogfighting and extreme felony abuse, you have living creatures that have suffered and oftentimes ultimately died. You have a victim, even though it is often a victim with 4 legs as opposed to 2. So we're simply trying to address this gray area for animal crimes. It is so important to note this is not an effort to, increase incarceration, simply an effort to ensure that every animal has its day in court. And as the delegate said, the judge can run these consecutively. So this isn't purely an effort to sort of
undo some of the work this committee have done to make a more restorative system. We understand that, this committee holds two goals, and you hold those goals, very importantly. One is to create a more restorative justice system. The other is to protect animals and animal welfare. And this is one of those few times where those two goals don't always live in perfect harmony. So we are very happy to work with this committee to make sure that the way the bill is drafted, the cases that fall under it, sort of strike that balance as best as possible. And as the delegate said, we want to make sure that the bill directly does speak to the commission's decision last May. So we're happy to work with her and the committee to make sure that the language is as clear as possible without necessarily changing the status of animals under the law, because I don't believe as a state we're quite ready to redefine where they fall. So we do urge a favorable report and look forward to working with this committee on some of those details.
Good afternoon, committee. Thank you for having me. I'm here today representing animal control agencies and shelters across Maryland as the president of Professional Animal Workers of Maryland. Felony cases specifically related to animals are really the most egregious we see in humane law enforcement. You've heard from my colleagues, we're talking about cruelly beating, torturing, mutilating, sexual violence, dogfighting, cockfighting. When our officers are out on these cases, we see these animals as victims. I know we're being careful with that verbiage, but they each are a separate case. As the current law stands, whether a defendant harms one animal or 100 animals, the charges and sentencing would be the same. This just is not seeking justice for these animals. When these cases occur, our officers are seeing these horrific crimes. They are out there in the field. They are out there protecting animals and protecting people. They can't do their jobs every day if we can't hold these worst abusers accountable. As was stated, animals in Maryland are in a legal dilemma. They're technically property, but they're living creatures that are victims of crimes of neglect, violence, and often die in these cases. It's insufficient to limit charges in the same manner we would a vehicle, a television, or a diamond ring. Professional Animal Workers of Maryland truly feels that this is a crucial bill in protecting people and pets of Maryland, and we hope for a favorable report.
Well, I just wanted to say, Mr. Harvey, good to see you. I know we've talked about this issue before, so good to see you. Any questions? Delegate Cardin?
Right. Thank you, Madam Chair. Thank you for bringing the bill. Delegate Embry, so if there's like a case where somebody's doing dogfighting, would there be a charge or for each dog that's involved in the matter? I guess this is for Mr. State's Attorney also. I'll let you.
Okay. Well, that's certainly within the discretion of the state's attorney. The state's attorney doesn't have to charge it that way. I know in my county we do.
Right. But if you just charged for one count of dogfighting, then you wouldn't have this issue wouldn't exist because you would only be one count. But you're saying if you did it you had 20 dogs, you could file 20 charges and you do not want them to merge. Is that
precisely correct?
Okay.
We don't want them to merge. The court, however, does still retain the authority to run the sentences concurrently,
right, or
to suspend a sentence in its entirety.
Sure.
But what it does give us, when you have 20 animals, let's say the judge decides, this person shouldn't go to jail for 20 years or 30 years for this. The judge can impose the sentence, but suspend it and place the individual on probation. So you have that sentence hanging over that individual's head to make sure it doesn't happen again.
In what other matters, Mr. State's Attorney, would you file 20 different charges on 20 different entities and somehow be able to merge them? That doesn't exist anywhere else, does it?
Well, it exists. You can file charges, and if the crimes are what they call lesser included,
right? But in this case, it would be the same charge for 20 different entities.
Right. That's correct.
So this seems to be a correction in our law as opposed to a change in the law. Wouldn't that be fair to?
I think that's a fair characterization. Yes.
Thank you.
Delegate Conaway.
Thank you, Chair. Thank you, delegate and panel members, for coming in to testify. Is beating a dog would that be considered animal abuse?
Yes, well, yes. And how severely the dog is injured.
Oh, you
would-
beating the dog, you beat the dog.
Yes, and the severity.
Maybe
would
the dog
determine
is
what type
emotionally
of-
traumatized, you beat the dog. How about that?
If the dog is injured, physically injured,
What is the meaning of physical injury?
it's, there's guidance in the statute.
Oh, it's guidance in the statute.
Yeah.
Okay, suppose a jockey is whipping a horse and the horse runs so fast it falls out dead. Is that horse abuse? Is that in the statute?
It would be fact specific.
I just gave you the fact specific.
I mean, the severity of whether it was, I have never been involved in a horse case, and I don't know if you have horse racing, but I think it would be highly unlikely that that would be viewed as a criminal prosecution. But, or I'll turn it over to my.
And, horse racing is an interesting area. There are a lot of protections under the agriculture code for sort of standard industry practices. So I think there's a case we made that, horse racing under law falls under sort of standard industry practices. So the evaluation would come down to whether that's normal use of a whip in that situation.
And that would be because the horse is not permanently injured?
It's because agriculture does have sort of its
I was
own.
hoping that you would say yes so that we could end this, but now
Sorry.
why can't a person do dog fighting with their dog? Let's say you wanted to do the dog fighting, but you muzzle the dog, so they do dog wrestling.
Dog fighting is a felony in the state of Maryland.
Yeah, well, that's
regardless.
Yes, well, I understand it. So cockfighting is a felony, but now you're infringing on other people's cultures. Would you agree with that? Oh, you don't?
I'm not going to,
I didn't think
I
so.
follow the law. That's my job. Yeah. So dog.
Law,
Yeah.
aren't you asking to change the law?
We're asking to clarify a law
Okay,
that,
you're asking to
yes.
clarify, so I'm asking you to clarify the law.
So the Humane Society of the United States does work on fighting cases, in our various state chapters across the country. And I will say that the impact of dogfighting and cockfighting, it is fairly race neutral. We see people of all backgrounds and sort of cultural habits, being found on these cases, including here in Maryland. We've seen a pretty race neutral array of accused, I'll just say.
Oh, so you're saying it's not really a racial or cultural type of event, but there is a social participation in this type of event, which means there are a certain group of people that believe in this type of event. Is that correct?
Again, looking at the cases here in Maryland and across the country, there isn't sort of a clear, oh, those people cockfight and those people don't. It is
Right.
activity
I just agreed with you
Yeah.
on that point, but there's a point that there's a certain group of people that find it valid to do or participate in dog fighting, and a certain group of people that participate in cockfighting. Isn't that correct?
certainly when we see these cases, they're often tied up with other criminal activities. So to
No, but
that extent,
that's not
yes,
what
sir.
we're talking about. That's an assumption. I don't know. I don't know. I was in Spain. I saw bullfighting, so I don't know. Okay, so thank you very much.
Thank you.
Delegate Boucher.
Thank you, Madam Vice Chair. A few years back, while Carroll County Commissioner, we had a couple that hoarded over 40 dogs in their house to the point the house needed to be bulldozed down. Would this be a useful tool to stop the animal hoarding abuse that exists out there?
I would say absolutely.
In Calvert County, we had a woman, and we have a woman, did it twice. It was a rabbit lover and hoarded rabbits, 400 rabbits. We prosecuted her. She was placed on probation. It didn't stop. She did it again. So she got prosecuted again. And nobody put her in jail. She didn't go to jail, but this would
help.
Absolutely.
Thank you.
And she would have an extended sentence hanging over her head, certainly be a deterrent. Thank you.
Thank you.
Seeing no further question, that ends the testimony on House Bill 667. We're going to move now to Delegate Embry's bill on House Bill 508. Delegate Embry, whenever you're ready.
Thank you. May the panel join me?
Of course.
Mr. Piero. Yes, here they are. Thank you.
Okay, so I have Melanie Shapiro, Andrea Carroll, Amanda Rodriguez, and Sophie Aron, Lindsay Carpenter. Is everyone present that I just called?
Thank you so much, Madam Vice Chair.
You're welcome, whenever you're ready.
Thank you, and I will try to be very brief because this bill has actually been made more simple after some conversations. So what this bill currently does, as written, it did two things. I have an amendment that I passed out to limit it to one thing. So I'll talk about the one thing that we propose that it do. Which is to add labor trafficking. Oh, thank you. I'm sorry. To add labor trafficking into the section of the law which covers the Safe Harbor Regional Navigator Grant Program. When we passed, this body passed the labor trafficking laws, which was wonderful. There are a few places where it wasn't included, and the critical one from our perspective is the Safe Harbor Program. The Safe Harbor Program allows local jurisdictions to connect victims, currently victims of sex trafficking and abuse, but now with this bill, it would allow them also to connect victims of labor trafficking to resources and other services. So this just allows, all this bill as amended does is is to specify that victims of labor trafficking are also eligible and should be included in that program. And the experts on this panel can describe that program in more detail, but I just want to clarify the initial issue with the Senate proceedings. There were some issues from the Judiciary and the Office of the Public Defender, so we have removed that section. So with that, I will turn it over. Do you want to start? That's great. Thank you.
Good afternoon again. My name is Amanda Rodriguez. I am for this committee, for this bill, the chair of the Legislative Committee of the Maryland Human Trafficking Task Force. I'm also the executive director of Turnaround, which is the regional navigator for Baltimore County and Howard County. 5 years ago, this committee took some significant steps towards ending human trafficking in our state. The General Assembly passed criminalization of labor trafficking, which was spearheaded by Delegate Winika Fisher when she was here, and the creation of the Regional Navigator Program, which was spearheaded by Delegate Brooke Learman. That Regional Navigator Program is critical, and it creates a network of service providers across the state that are ready and equipped now to provide services to child sex trafficking victims. Now, 5 years later, almost every county in the state has a Regional Navigator Program. You're going to hear from some of them today, and we've learned some lessons. One is that we were restricting housing in the original bill, and that's caused some issues, especially because our regional navigators can serve up to the age of 24. So for the adult population, they want to utilize funding to be able to support housing, which you've heard is a significant need for gender-based violence in general. The other thing that it will do is it will allow for labor trafficking victims to be served by the Regional Navigator programs. It's currently only sex trafficking victims, and the regional navigators have sufficient funding to be able to absorb that population, and they are ready and willing to do that. The last piece is that we'll require mandated report for child labor trafficking into CPS. And so that will mirror and create parity with child sex trafficking victims, which actually started in 2012, that we had mandated reports for that population. I know this is a very heavy session, but this is a very important issue, and the only bill that the Maryland Human Trafficking Task Force is spearheading this bill. So we are asking for a favorable report. Thank you so much.
Good afternoon, Madam Chair, members of the committee. My name is Lindsay Carpenter. I am the chief of the Special Victims Unit of the Frederick County State's Attorney's Office. I'm also chair of the Frederick County Human Trafficking Response Team. I'm here on behalf of those organizations as well as the Maryland State's Attorneys Association. We are urging a favorable report on HB 508. Part of this bill does make child labor trafficking a form of abuse and neglect under the family law article. This is important because it makes it a mandatory report. In Frederick County, we do have a close-knit community in terms of the human trafficking response team, and a lot of our community partners work closely together. Over the past year, we've had several incidents of labor trafficking that have been reported to our task force. It's not necessarily being reported to CPS because it has to specifically fall under abuse or neglect. By including labor trafficking, similar to sex trafficking, as a defined form of abuse or neglect, we will increase the number of victims that are being identified. We clearly are only at the tip of the iceberg, and I think by including this in there, we'll have more victims identified. In terms of referral to the Regional Navigator Program, that ensures that we are getting services for these victims. We have seen over the past several years how the services being afforded to the sex trafficking victims have greatly improved not only their lives, but their ability to participate in the criminal justice system. If we provide victims with wraparound services, that increases their ability to participate in the criminal justice system, as well as leading towards further holding of offenders accountable. So for those reasons, we urge a favorable report.
Good afternoon, Madam Chair, members of the committee. My name is Sophie Aaron. I'm a social worker at the University of Maryland Safe Center for Survivors of Human Trafficking. We serve as the regional navigator in both Prince George's and Montgomery County, and we have since 2019. During that time, in the last 5 years that we've been the regional navigator, we've served 55 clients under our regional navigator program, and we've trained just under 1,000 community members to recognize the indicators of trafficking, and it's made a huge difference in those counties. This is only, though, as you've heard, for survivors of sex trafficking, not also labor trafficking. During that same time, 2019 until now, we've seen a pretty dramatic increase in survivors of labor trafficking, both minors and young adults up to age 25, as Amanda mentioned, in our regional navigator jurisdictions. The point that I want to get across today is that this is a problem. It's happening in our communities. It's happening in every county in Maryland. So just to give a little bit of an illustration of some of the cases that we've seen at the Safe Center, we have had a young person who suffered a serious knife injury to his thigh as a result of the meat packing plant that he was working in Maryland. He ended up in the hospital for that injury, as well as a 16-year-old who was forced by his grandmother to work at a fast food restaurant in Maryland after hours and on the weekends, to the point that it prevented him from going to school. He also ended up in the hospital, resulting from the serious emotional and physical abuse that he endured during his labor trafficking at the hands of his grandmother. So this is happening in our communities, and these folks have pretty significant legal, mental health, medical, economic empowerment, case management needs kind of across the board. And if we open up the regional navigator to be able to serve these young folks, we are going to allow them access to services that could potentially change the trajectory of their lives. So for that reason, we urge a favorable report on House Bill 508. Thanks very much.
Hi, I'm Andrea Carroll, the Director of Behavioral Health Services at the Board of Child Care, which operates the Regional Navigator Program here in Anne Arundel County. We support House Bill 508, and I want to highlight three main impacts that this will have based on our experience as the Regional Navigator. First is the proposed requirement that local departments refer labor trafficking victims to regional navigators. Caseworkers have at times made referrals to our program for suspected labor trafficking in the past, but not all caseworkers do this, and this is certainly not happening in every jurisdiction. We can only be sure that all victims, minor victims of labor trafficking, are getting access to the services that they need if we require that staff are making these reports and we provide them training to help identify and refer those victims. Second, the scope of our program by current definition is sex trafficking. So determining if and how to serve these referrals that come to us for labor trafficking, and also if we can even access training and resources ourselves to information about labor trafficking has been a challenge. Our regional navigator in Anne Arundel County works with Anne Arundel County Public Schools to deliver training to high school students as part of the county's health curriculum. And that curriculum requires education on both sex and labor trafficking. We need our scope and access to labor trafficking resources to expand to fully meet the needs in our county. Finally, one small but important change is allowing regional navigators to offer housing resources. Our law enforcement partners consistently say that the biggest gap for trafficking survivors in our county is access to immediate housing. Officers are typically encountering sex trafficking victims in the middle of the night, and right now the only place that they can go is the hospital. We have some great hospital programs, but they're not what everyone wants or needs. We had one victim who was awaiting a daytime intake at a shelter and had nowhere safe to go in the interim. Most importantly, I want to be clear that the changes in this bill won't require more staff or funding. We feel confident that existing staff and funding can be reallocated. We want to be able to support all survivors of trafficking in the state.
Good afternoon, Madam Chair, members of the committee. Melanie Shapiro, Public Policy Director with the Maryland Network Against Domestic Violence. I co-chair the Human Trafficking Task Force's Legislative Subcommittee with Ms. Rodriguez, and we are here in support of this bill. And I'd like to thank Delegate Embry for her work on the bill. I think that the amendment is going to be amended
What the intention of the amendment is to do is there's on page 9 language that adds labor trafficking to a section of the code that says that the court can waive reasonable efforts to reunify a child. We're going to take that out. That was the area that we heard a lot of opposition to. It does still need to be a form of abuse or neglect. And that is the pathway to services for many of these young people. So we need to expand the regional navigator program, and we need to have the language in the abuse and neglect statute. One, because we shouldn't be treating child victims of sex trafficking differently than child victims of labor trafficking. Another concern that I have heard, and I'd like to explain, is the element of force, fraud, or coercion. So this is not for children who are being forced to violate labor laws, or an adult is having them employed and they're violating labor laws. This is when there is force, fraud, or coercion. And what does force, fraud, or coercion look like? I mean, there's legal definitions, but force, I mean, assaults, threats of harm, you don't work. Fraud, some people, this wouldn't impact children so much, but in an adult situation could be, promises of something, whether it's love or a relationship, or they think some type of emotional manipulation, and then something is what it's becomes something that it's not supposed to be. And then coercion, again, threats of violence, threats against relatives, debt bondage, like you owe a debt and you have to work it off, those kinds of things. If a parent is having a child, or any adult is having somebody work and it's violating a labor law, there are laws, there's offenses, and it's that. But if there's force, fraud, or coercion, that's the line into the labor trafficking. And those are the cases that these regional navigators are seeing and the children that need to be connected to them. So we urge a favorable report.
Thank you. Are there any questions for this panel? Delegate Taylor.
Thank you, Madam Chair. You said the navigators would be able to absorb the additional workload, so to speak. But I thought I heard you say that there's a housing shortage, or where would they go? Would we be prepared to house these folks if this bill were to pass?
Can I give one example? So in the case that I mentioned where we had the young adult who was awaiting shelter, like to get there the next day, we could reallocate some of our funds to say, like, get them a hotel stay for that night. So it bridges the gap to resources that they're sort of waiting on that might not be accessible until their intake that can only happen during business hours.
One other question, Madam Chair. This is an example. All right. Might be a little far-fetched, but not quite. I'm not going to say that. A 13-year-old boy who has younger siblings, right? And the mom makes this child babysit so he can't go to his mentoring on Saturdays because she wants to hang out or do whatever. He is made to babysit without compensation for extended periods of time, which has him not receive, some of the fun stuff he might do, or these services like a mentoring program on Saturday morning. So he tends to miss those. Like, is that, I know it's far-fetched, but
no. Well, Delegate Taylor, thank you for that question. And I think that sort of illustrates the point and the concern. I don't think that is labor trafficking. I might not agree with the parenting decisions. Now, if the parent is having the child babysit during school hours, and so the child is not attending school, one, I don't think that it's been changed. That was a crime in Maryland. It's also probably abuse or neglect. And so they could be coming into the system that way, as if they're not going to school, they're required by law to go to school, and not allowing that child to do those things. They're not allowed to go to the after school event that they want to go to. If the mentoring services, however, are court mandated or something that they need for their health or welfare, then that goes into a different area. Again, not labor trafficking, but it very well might still be neglectful behavior. And back to your first question, if I may, because if they're added into this definition of SINA, then DSS has an obligation, if there is nowhere else to go, to help them get housing. And so that is why it's so important. The regional navigators, especially with some of, can help sometimes in the short term, and even partner depending on the child's needs, finding an appropriate location for them to go. But with DSS, if a child is in their care and custody and there's nowhere safe for them to go, they have the legal obligation to find them the housing. That's why we need them to be added into the statute by definition so that they can access those services. Thank you.
Delegate Cherie Sample Hughes.
Give me whole name. I'm awake.
It's 5 o'clock.
It just has a great ring to it. I'm sorry. Delegate Sample Hughes.
Thank you, Madam Chair. Good afternoon. Thank you for the bill. And I just need a couple questions. I'm gonna ask a couple questions just to get clarity. So the bill is is saying that labor trafficking as well as sex trafficking are looked upon as the same for services, or for the requirement of information to go straight to Department of Juvenile Services or Juvenile Court and Department of Social Services?
So it would just go to Department of Social Services. So it'd be a call into CPS. We've already spoken to the folks at DHS and they've already created a protocol for response to this. We just don't have the mechanism to get the child from the community called into CPS. It would also give them access to the regional navigator programming, which is now available to sex trafficking survivors.
Okay, so they've already created that protocol.
And can I just add, there is a letter from DHS.
Yeah, I was going through
Yeah,
the
perfect.
material.
Thank you.
Thank you. The other question I had is regarding the regional navigators. So you adequately have enough of those, and are you equipped with the data already with the labor trafficking
As to
that has occurred already in certain jurisdictions?
So the unfortunate reality, I think Lindsay, Ms. Carpenter spoke about this a little bit, is that because they're not being called into CPS and they're not being referred to the regional navigators at this point, or they're not required to do so, that the data is just simply not there. I think it wouldn't be, I think all of us have seen cases where people are referring them in or trying to refer them in, but because they don't meet the qualifications for the program, I don't know that I have data on the number of labor trafficking survivors. Do either of you?
So I don't have the data with me on hand, but the Safe Center for whom I work, we serve exclusively survivors of sex and labor trafficking. So we have multiple grants. We're kind of in a unique position in that way. So we're not just constrained by the Regional Navigator Program to only serve survivors of sex trafficking. So I will say that in the jurisdictions where we serve, Prince George's and Montgomery County, about a third of our clients that we're serving right now, this is adults and minors, are victims of labor trafficking. And as I noted in my testimony, during the time where we've served as regional navigator, where we're serving these young folks, survivors of sex trafficking, we have seen an increase in survivors of labor trafficking as well. So the data consistently on human trafficking is going to be inadequate because this is such a hidden crime and it's so hard to identify and it's hard to get these folks services. But anecdotally from the organization where I work, our data will reflect a strong need for services and attention paid to this population. It's one of those things, if you're not looking for it, you won't see it. And once you start looking for it, you will see it.
Can I just add also, our program has been in operation since 2021. And in that time, we've only gotten kind of a few of those, hey, is this maybe labor trafficking? Because, that's not what we're marketed as. But what we've seen just in doing work around sex trafficking is that, like Sophie was saying, a lot of people don't know what it is, don't know what to look for. And so part of the work of the regional navigators is to do some public awareness and training, part of why we're in the schools. We do a lot of community information sessions, even not just with community members themselves, but with agencies, right? We talk with different agencies that are serving kids to say, hey, we do education. So we expect that by being able to do this work, we'll be able to do more education that's targeted around labor trafficking and hopefully help prevent it, but also have more early identification that we presume will increase the number of cases that come to us. It's not like we have floods and floods and floods of people that are experiencing trafficking in our state. There are a lot of them and it's important and significant, but we certainly think just by what we've seen happen with the sex trafficking work that we've been doing, that it won't be overwhelming and we definitely have enough capacity to manage it.
Thank you. And thank you for that awareness piece, inclusion in your response. And you don't have to answer this or answer the question, but what I just wanted to note is, like the Boys and Girls Club, the Salvation Army, after school programs and things of that nature, if awareness could be, driven down to their level as well, because they're getting, all all kids from all backgrounds at their facilities. So just wanted to highlight that. Thank you again for your responses.
Delegate, I just wanted to highlight, I'm really glad that you brought that up. So Turnaround actually has a program where we have advocates inside of every Boys and Girls Club in Baltimore. So I think you're absolutely right on that. And I appreciate you for saying it.
Delegate Cheryl Pastor.
See. Okay, thank you, Madam Vice Chair. Thank you for this bill so much. And you know, my ears perked when I heard in schools and education. I would really appreciate it if you would discuss a little bit about what that looks like, because it's such a great opportunity for children to know for what to look, and also staff, and it spreads out to parents and they can share it at PTA. So please explain a little bit what that looks like.
Yeah, this is something we're actually really proud of. And Anne Arundel County Public Schools has been a great partner. We're fortunate because not every school system in every county in the state has been as receptive to regional navigator programs coming in. I think we actually probably have the best relationship. And so we've done two different things. We have had our regional navigator go in and do in-service training. So over the summer, when the teachers come in for their professional development, you know, that week before school, we've had for the health educators some awareness training, and it covers kind of the basics, like what is trafficking, what does it look like, what is it not. Force, fraud, and coercion is discussed, although with sex trafficking and minors, that isn't required for there to be force, fraud, or coercion. And you know, those trainings, we have not yet included a lot about labor trafficking because it's just not been our focus, although we would certainly add it. But so anyways, we've been able to do the in-service training for educators. And then with the schools, it's during the high school health class that the regional navigator goes in and does a presentation. They started this when going in person wasn't possible. So I think it's mostly been virtual because that's just sort of worked and continued. But they do, again, a little bit of what is trafficking, what does it look like for kids? What do you do if you think someone is experiencing it, or you know, access to resources, information is provided. They try to make it fun and interactive by doing quizzes like, is this, you know, human trafficking or not? So the kids, they do feedback surveys, and the students, the high school students who've participated have been really engaged and also asked really good questions, and rated the program that our regional navigator is doing really well. So it's something that we've been and we're trying actually to get in more high schools, because it is the high school has to kind of accept our offers for help. So we're not yet in all the high schools, but we hope to continue working to expand to more.
Just for Anne Arundel, but you said.
Yeah, I mean, our regional navigator program works in Anne Arundel County, so that's all that I can really speak to. I mean, I think I have heard, and I don't know if any others can speak to more. I think some counties have been, just there's more red tape, I think, to get in and make the right connections. And but in Anne Arundel County, it's been really successful.
Well, I certainly would like for you to talk to folks in Baltimore County, and I'm sure that Dr. Rogers would embrace it. Okay, see, I'm throwing out names right there.
We should speak offline, Delegate. Thank you.
And I hope it's a good thing, because I would hate to think that you're going to tell me offline that didn't happen. But yeah, let's do that.
I'd be happy just to add a little bit of color for what we're doing in Montgomery County and Prince George's County. It looks different in each county. As Ms. Carroll said, there's an appetite for one thing here and an appetite for something different here. In Montgomery County, we've trained all the security personnel in Montgomery County Public Schools. We've trained all the health educators. We've trained the administrators. We've started, the buy-in that we got from MCPS was pretty high level. So we started kind of top down. Montgomery County Public Schools has also done a really good job incorporating the health education framework into what they're teaching their students, which has really kind of comprehensive and age appropriate aspects of human trafficking across all grades from pre-K to 12. So that's been great. In Prince George's County, we're in more of the schools with the students. We have a club, it's called the Blue Club. I think it's bringing love, empathy, and understanding. It's a student-run club talking about human trafficking as well as larger themes of healthy relationships. So that those have also been really high levels of engagement, really a lot of interest from both students in Prince George's County and administrators, faculty, and staff in Montgomery County. So we're excited about that. Yeah. And one more note on that, just to add, sorry, are we trying to get out of here or something? Just kidding. After the work that we've done now, and then I go on to talk more, as a result of the work that we've done, we have seen the referrals coming in from the schools increase. So that's been helpful too. Okay. Glad I said that one.
Delegate Boucher.
Thank you, Madam Vice Chair Sandy Bartlett. As a member of the Frederick County delegation, I want to direct this question to Assistant State's Attorney Carpenter. Is this issue affecting their immigrant population? And are these cases on the uptick in your office? Are you seeing more of this activity?
Yes and yes. Actually, a lot of our referrals are coming from community organizations that work closely with the immigrant population. And a lot of our cases that we've seen are involving relocated undocumented children. So I think I submitted written testimony that indicates the numbers that are associated with Maryland as a state. Certainly that population has higher vulnerabilities. Frederick County actually has been working closely with ORR to address this issue. We have also done trainings in the schools in Frederick County. We have partnered with NCMEC and we are training, or we're providing education to students. We're also meeting with teachers. We had a summit in Frederick County the end of last month. And we were specifically we had a panel on labor trafficking because we've seen such an increase in Frederick County over the last year involving children. We were speaking with staff about this, and they actually came up to us afterwards and indicated that they've seen some red flags and they didn't know that this is what it was. Unfortunately, as was indicated by Melanie, a lot of these kids aren't actually in school. So a lot of our staff in the schools aren't going to have contact with these children. But when they do, it's important to be able to report it.
So it's safe to say that immigrant children are more susceptible to the coercion that you're talking about?
Yes,
Thank
I believe
you.
so.
Delegate Valentine.
Thank you, Madam Vice Chair. And my question is, and thank you panel and thank you delegates for bringing this bill. And I'm going to follow up on Delegate Boucher's question also to ASA Carpenter, being from Frederick County. Can you tell me with data related to this, specific, and any member of the panel can have this question as well. Is there a predominant, I know we talked about meat packing as one example. Is there a particular industry or work where you're seeing these type of cases? And my second follow-up point to that is this any gender specific, or are you seeing pretty much equal either male or female?
I would say regards to gender, it's very neutral. In terms of the industries we've seen a lot of restaurants is what we've seen. We also had a youth in a factory who was injured as well. So those are what we've seen.
From the Safe Center, since we do see kind of a higher number of these folks, typically the industries that are prone to labor trafficking are those that are prone to subcontractors or those that need a high amount of work for a short amount of time, among many others. So things like contractors, seasonal agriculture. More and more we're seeing folks labor trafficked in assisted living facilities and in-home medical care. So that's been kind of interesting. I mean, horrible, but an interesting trend that we've noted. But really, like trafficking in general, the venue is undiscriminating. Anywhere where someone can be hired, someone can be labor trafficked.
And in a general age group, not age specific, but maybe just a general like 15 to 18, 14, what are you seeing predominantly?
Undiscriminating. Yeah, sorry.
Nope.
Yeah, but I mean, we are seeing a lot of minors who are trafficked for labor.
Mm-hmm.
We are seeing a lot of young folks, a lot of middle-aged folks, and a lot of older folks. Yeah.
Thank you.
Mm-hmm.
Delegate Conaway.
Thank you, Vice Chair. Thank you, delegate and panel, for coming in to testify. To the last lady that testified, what about crab pickers?
I have not seen a case of labor trafficking there, but that, as I said, I'm in Prince George's and Montgomery counties, the counties that are not doing as much crab picking as some others. But yes, that is certainly an industry that would be vulnerable to this.
The lady with the gray, I'm sorry, I didn't remember your name. So you were talking about the immigrant children. Is there a specific ethnicity of these children?
I think it can vary. We've seen Latino children, but I think it can vary.
What I'm trying to get to is, do you think that some of these children might be people that came here for sanctuary?
Yes, so the children that we've come across are the children who have been placed by ORR, the Office of Refugee Resettlement.
Were they moved here from another state, you think?
We've had both situations where they were placed in Maryland by ORR. We've had situations where they've been placed in a different state and ultimately ended up in Maryland.
And do you have a number that you think, a number that might be the total amount of these immigrant children that you're talking about?
I include-
1,000, 10,000?
So in my written testimony, I did include the number of children that have been placed in Maryland between October 2023 and December 2023. I don't recall off the top of my head.
You don't recall the number?
And I don't have my written testimony with me, but it is included in my written testimony. And I believe, Amanda, was it included in yours, the entirety of the year? I just included October to December.
That's all they have data for so far.
Is that what you had to do? Yes. I don't recall. either.
1,200. It was, I recall now, 1,207 is how many children were placed in Maryland by the Office of Refugee Resettlement from October 2023 to December of 2023. So in a 3-month period, 1,207 children were placed in Maryland.
Thank you very much.
Seeing no further questions, that concludes the testimony on House Bill 508, I believe. Let's just make sure I didn't forget anything.
Thank you.
Thank you. Yep, that's everybody. Okay. Members, we're gonna move on to House Bill 813 with delegate tolls. And delegate tolls, I see members of your panel coming up. Zane Smith,
He's there, Madam Chair.
okay. Michelle Smith, I saw you. I don't know if you're on this panel or not, but Grayson Wiggins.
Next.
I would tell you, Madam Vice Chair.
Well,
if that's
thank
okay.
you.
If that's okay, I'm sorry. If that's okay.
You
If it-
tell me who you want to come up.
Thank you, Miss Stacy Bensky, me,
No, you're not allowed.
Zane Smith, Chris Dews, and Grayson Wiggins, if that's possible. Okay. Thank you.
Okay, tell me those names just one more time. Zane Smith, Grayson Wiggins,
Chris Dews.
Christopher Dews, okay.
Yes, and Stacy Bensky.
All righty. Whenever you're ready, delegate.
Thank you so much, Madam Chair. And my colleagues on the Judiciary Committee. Thank you for the opportunity to testify. I am pleased to present legislation concerning the suspension of driver's licenses for child support and arrearages. The broad range of support from HB 13 from the Department of Human Services, as well as the consensus reached among sponsors and advocates, highlight the collaborative efforts behind this bill. Such alignment reflects the comprehensive approach to addressing the complexities of child support enforcement and licensing issues. This united front strengthens the likelihood of successful implementation. The existing provision of Maryland Family Code 10-119 mandating license suspension after 60 days of non-payment of child support raises concerns about the potentially harsh consequences for obligers. The imposition of a $500 fine and the possibility of arrest further exacerbates the punitive nature of this policy. It is crucial to acknowledge that child support debt can disproportionately impact individuals irrespective of their financial status. The Census Bureau reports that nearly 40% of Marylanders commute outside their county for employment, emphasizes the widespread mobility in the state's workforce. Notably, this trend is more pronounced in lower income communities of color. And this highlights the importance of considering regional economic disparities and transportation challenges. The aforementioned statistic gives emphasis to the broader regional impact when formulating policies, as they can affect a substantial portion of Maryland's workforce that commutes to neighboring counties. HB 813 is a crucial step in ensuring families, particularly for those with the income at or below 250% of the federal poverty level, or 37,650 annually. The exemption, well, there's no exemption, and I'll explain that. I'm sorry, the exemption provision recognizes the financial challenges faced by some obligers, while the extension to 120 days provides a reasonable time frame for compliance. It is essential to strike a balance between enforcing child support obligations and considering the economic circumstances of the obligers. If enacted, HB 813 will contribute to a more equitable approach in handling child support matters within the state. Colleagues, I kindly ask for a favorable report on HB 813. And I will note in closing that Secretary Lopez has submitted a favorable report on this. And there is an amendment, Madam Vice Chair, that will mirror the bill to our colleagues on the other side. And so you see that amendment here, and also we're adding a preamble.
Delegate, I'm sure we'll
Thank you.
we'll ask questions on the amendment.
Thank you, Madam Vice Chair.
Thank you.
You're welcome.
Whoever would like to go next.
I'll go next. Christopher Dews, representing the Center for Urban Families. Going to speak quickly here. As you all know, this bill did pass out of this committee last year. And as the good delegate already mentioned, this was a collaboration between us, the Office of the Attorney General, who has been supporting issues like this in the past, as well as DHS. Just want to quickly remind the members of the committee that this bill does not touch wage garnishments, does not touch tax intercepts. This is primarily focused to one specific tool, and that is license suspensions, so that individuals will have the opportunity to get to work and to drive. It also does not touch individuals who voluntarily impoverish themselves. So if you actively try to harm the custodial parent by not paying, you are exempted from this bill. I want to make sure that that's very clear. I also just wanted to highlight that, just so you guys know a little bit about the impact here, MVA suspended roughly over 20,000 licenses in fiscal year 23. And that's an increase of 3,000 licenses from fiscal year 22 and a 5,000 in license suspension increase from fiscal 20, with still no evidence that the suspension mechanism has sharply increased access to the arrears. And the last thing I just wanted to highlight is that this is in my written testimony as well, but California also passed similar legislation looking at area median income. This was also put in a report by the ABLE Foundation, which I'm sure has been a conversation that's been beaten nearly to death, but we love this bill. It's a good bill, and I want to thank the delegate for sponsoring it and urge a favorable report.
All right. Okay. Good evening, everyone. My name is Zane Smith. I like to support this bill because I'm a father myself, and I'm impacted by this license suspended. And you know, I'm a good father. Take care of my kids. Sorry, but it's hard to not get a job, take care of your family, especially when you always take care of your family. Not being able to go to my daughter's house and on Valentine's Day to give her flowers because my license is suspended. I know that, you know, I gotta take care of my responsibilities. And my mother, my father always told me to take care of my family no matter what. And I believe in that. I just support this bill. And, I live in District 25 and, I just want my voice to be heard because there are good fathers out here, despite of all the other bad side of fathers that don't do their job. Thank you.
Thank you, Mr. Smith. Whoever wants to go next.
Sure, I can go next. And if I can just say also on behalf of Mr. Smith, as I have talked to him at length about his situation, and I'm an attorney at Maryland Legal Aid. I know that he is a very devoted father, and he also did security right here at one of the buildings, one of the state buildings right down the street to protect you all. So he just wanted to say he's a very devoted father. I know that. Okay. Good afternoon, Chair and members of the committee. My name is Stacy, and I'm a family law attorney at Maryland Legal Aid. My name is Stacy Bensky. I guess I should say my full name. In 2020, this committee passed legislation that stopped the MVA from suspending driver's licenses for fines and fees. That was based on the common sense fact that people need driver's licenses to secure and maintain steady employment. Further, this U.S. Supreme Court has found that driver's licenses are essential in the pursuit of a livelihood. Steady employment can be garnished each month for child support. It means taxes for the state of Maryland and tax refund checks that can be garnished for child support arrears. The answer is not placing barriers in the way of employment, but making employment accessible. Controlling federal law says license suspensions for child support should only be used when appropriate to improve the effectiveness of the child support program. License suspension is not appropriate for those who do not have the ability to pay. It is simply punishment for being poor, and it hurts the entire family, including children. It is not effective, and in fact, it is counterproductive. It really only works for those with higher incomes who have the ability to pay but are choosing to withhold payments. So adding this exception would mitigate harm to our clients who are low-income families. So we at Maryland Legal Aid urge the committee for a favorable report. However, we also urge this committee to address the automated system. I've sat before this committee many times and told you of the harms of the automated system, that even though there are exceptions currently in the bill, even parents who fall into those exceptions still have their licenses suspended. If I could finish my last thought, thank you. Is the automated system suspended over 20,000 licenses for child support in 2023. It presents serious constitutional concerns that should worry lawmakers of all stripes. So we urge a favorable report for this bill, and we urge you to address the automated system, which would get at the heart of this pervasive systemic problem. Thank you.
Thank you. Mr. Wiggins.
Good afternoon, Madam Chair, members of the committee. Grayson Wiggins here on behalf of my client, Employ Prince George's, which is the fiscal and operational agent for the local Workforce Development Board in Prince George's County. My client specializes in providing critical workforce services and employment opportunities, and workforce is certainly a large component of this bill, and we are here in full support. We thank Delegate Tolles for bringing the legislation. Look, public transit is not what it should be. And people need to access our services and our employment opportunities. And a large component of that is the ability to travel. And the driver's license is a large component of that. And so late on a Friday, Madam Chair, I'm going to say the magic words, us too.
Move favorable. Oh, no. Okay. Okay. Sorry. Okay. Any questions? Delegate Valentine.
Thank you, Madam Vice Chair. And thank you, panel, and thank you, Delegate. And I believe you touched on what was going to be my question on the young lady at the end. And that was, if I remember correctly, when we heard House Bill 311 earlier in the session, which was very similar, it had to do with the automated system from the Bureau of Support Enforcement. I believe that's the entity where that bill talked about, and this bill as well goes from 60 days to 120 days. But if it's still an automated system and it will still generate the same data out, won't we still be here in 120 days if we don't correct the problem of the automated system?
So what, yeah, is it okay if I answer the?
Let me just say that this bill is not about the automated system. This bill is only about this 250% federal poverty guidelines.
But I wanted to talk about the 60 to, does it include the 60 to 120 days?
Yes, that is in both pieces of legislation. And just so you know, the reason why we specifically, yeah, to your point, we that's in there, you know, because obviously if you're having a lengthier time for commercial driver's licenses, then it just makes sense that you're doing that because they need the license for employment. So we're just trying to equal that out. And that's something that the department has agreed to. That's why that piece of language.
That's why it's in this.
Yes.
Yeah, but
yes, it's in both, yes.
Yeah, it will. I mean, yes, it just gives people at least a little bit of extra time, I guess, before this would kick in. What this, the really positive thing about this bill, though, is that essentially what we do at Maryland Legal Aid is we help parents with getting their licenses reinstated. So it would be a reason for a lot more people who are lower income, and our clients at Legal Aid are all low income in order to qualify for free legal services, to at least get their driver's licenses reinstated based on their income level. Just like right now, there are other exceptions that we use to help people get their licenses reinstated. But yes, you are correct that the automated system is still going to suspend people's licenses.
How we could fix that part so we didn't get to this part is, I guess, what I'm trying to. I know this bill does not specifically address that. I just know that it had come up in both hearings.
Well, you could pass both bills. You could pass both bills or merge them. I think they could very easily be merged. I think Maryland Legal Aid would be happy to help with that.
So I would say that again, this is separate bill. And so I know I would encourage you to look at the letter from Secretary Lopez. It's something that we talked about. So their process, and maybe something we need to follow up with that agency on, because they will be the one that have to do the implementation. So I would just say that it's a separate bill. So we have to talk with them about what that looks like and merging and all of that, but currently it's just without the automation in there. Thank you.
Delegate Taylor and then Delegate Conaway.
Thank you, and I think Delegate Valentine kind of queued up my comment and question, because we know it's the automated system that creates the errors. So HB 311 sort of serves as a filter before we even get to this bill. So, but I guess that was part of my question, and maybe one of you can answer this, is like, if they were both to pass, how would they work together?
That would be a question that I would defer to the agency on to be able to ask. So I think that's, yeah.
I think they work very well together, though. I can speak to that. I've read them both in depth, and I've been working on this issue for quite a few years. And they actually, they don't conflict at all in terms of how, like, the language and how they would be implemented. Essentially, the exception for 250% of the poverty level would mean that those people should not have their license suspended at all. And then for the rest of the people who are not 250%, who are above 200, who are below that, I guess, 37,000 income level, for those people, because there are still other factors like people who have custody of their kids, but their license are still being suspended because their custody case takes a long time to work its way through the circuit court, just for example. Or people who are paying and their license is still suspended because they still do have arrearages to pay off. Those people, they would, that would be, speaking to Bill 311, would have the due process that's afforded by Bill 311 going through the court process, where a judge would have, basically the agency, the child support agency, would have to petition the court, and a court would have to make a determination, is it appropriate in this particular case for this family? So it just accepts out those who are 250% from that whole process, but they very much work together.
So again, since we're on HB 813, I want to stick to HB 813 because I'm not sure how all of that merges. I can only talk about the bill that I am sponsoring.
Mr. Chair, one more question. Really, I just wanted to thank the team for, sticking to addressing this issue. This is a great team. It's a great subject to address, and, I commend all of you for just sticking to it and finally getting something passed to help these dads like you, Mr. Zane,
Absolutely.
who, have had your license suspended, but clearly are supporting your kids. So thank you for being here today.
Thank you.
Thank you. And can I add, if possible, Mr. Chair, that I would be remiss if I did not thank publicly Delegate Shanika Henson, who has put in substantial work on this issue over the years and have asked me to, as a member of Judiciary, kind of has been working with the Secretary and to kind of try to move the ball forward on where we are with this bill. It's always work to be done with, with topics like this, but I do appreciate her allowing me to step in and take over this bill for her and to move. This committee put a lot of work in last year around this particular bill, which is why I want to kind of make sure that we can move this ball forward in working with the Secretary and other advocates, because we did talk about it so much last year. Thank you.
Thank you, Mr. Chairman. Thank you, delegate and panel, for coming in to testify. To the lady that talked about the license being reinstated, what has to be done for the license to be reinstated?
Sure. So Maryland Legal Aid will request license reinstatements if once our clients' licenses are suspended, which sometimes they'll find out if they get a notice in the mail, but a lot of times they don't get the notice. So a lot of times they find out because they were pulled over and they got a criminal citation for driving a suspended license. So for reinstatements, we request it through the agency. It is and when I say the agency, I say the child support agency. A lot of times clients will say, and they go to the MVA to ask for it. The MVA will just send them to child support because MVA doesn't have the authority to reinstate. The child support agency does. In 10-119 though, you will see, and also in COMAR, you will see that the agency is supposed to investigate once someone requests their license to be reinstated and they request an investigation. And also they're supposed to give something in writing, a decision letter in writing. And then along with that decision letter, it's supposed to have that they have the right to appeal that decision to OAH, but that's not done. So I can tell you what Mr. Smith, I don't want to speak on your behalf, but I know that this has been your experience and most of my clients' experience is that when they contact the child support agency and request their license to be reinstated for one reason or another, they're simply told, pay X amount of money. I think, Mr. Smith, you were told it was about $2,000. And is that correct?
Yeah, I went directly to him and told him that I had an interview to go to. Can you please unsuspend my license? And they told me that I had to pay $2,000 just to get my license unsuspended. So, and I didn't have any money. So,
right.
So I wasn't able to go to the interview.
That was a wonderful speech, but I was wondering how much money you had to pay, or did they work out a payment program? So in Maryland, as I understand it, driving is a privilege. Mr. Dews, you said this bill is in the same posture as it was last year. Is that correct?
Yes, primarily.
No, what's the difference? Is it yes or is it primarily?
Well, yes.
No, it's not.
Because the difference is that I know last year when this bill was passed out of the committee, there was a sunset provision that was added in. I want to say a day before, like we're talking the night before the vote. Is that what you're?
You're a very
referring to?
intelligent person. Is this
Yes,
bill
sir.
in the same exact posture presented and passed out last year as it's presented today?
Because sorry, by all means, though.
Delegate Conaway, the bill that you have in front of you is in the same posture that it was passed out of this committee last year. However, I will be offering an amendment to remove a sunset that was on the bill that you have in front of you. So hopefully when we get to voting and it passes out, it will no longer be in the same posture, but what you're looking at this moment is the exact same posture in which it was passed out of committee.
Do we have the amendment?
Yes, we do.
Okay, thank you very much.
You're welcome.
Thank you, Chairman. I'm curious, is there a process or procedure for someone to go in front of a judge and get a restrictive license? Like say you can drive going to and from work? Does that happen? Is that?
I'm not sure if that's the answer for that.
Yeah, it is in the bill that, I'm sorry, not in the bill. I apologize. Sorry, it's in the current law, but much like same within the current law is the right to get a decision letter in writing about the child support agency's investigation and appeal that to OAH. It doesn't really happen. I've never seen it happen. That's not to say that it has never happened, but I have been doing this since 2018 and like running the program at Maryland Legal Aid to assist non-custodial parents with the driver's license suspensions for child support. And I've never seen it happen.
Well, thanks for the reply. Appreciate it.
Mhm.
Thank you, Mr. Chair, and thank you, Delegate, for the bill. Delegate Boucher kind of brought up my question and as well regarding restrictive license. And the reason I'm asking is because not only Mr. Smith brought up specifics about trying to get to his child, but also in the written testimony, it talks about, you know, not only trying to get to a job, but also their children's doctor's appointments and grocery store runs, things of that nature, and they're having to constantly ask other family members who also have, you know, jobs and responsibilities. So what do we have to do to move the needle on that restrictive license piece that's in place but not being utilized?
Well, and the reason why this piece of legislation was necessary was because, and at least in our conversations, was because those restrictions weren't in effect, like, as in it's in law, but it's not being used. There's supposed to be a provision in there, I want to say, and Stacey will correct me if I'm wrong, but so if this impacts your access to employment, if you can get a work restricted, if there's a lot of other things that are supposed to be in use, and the reason why the language is drafted as it is, which is before you even see those exceptions in there, is to say that we're going to just shift away from even considering this section of law for people who make less than this amount of money. So that was our methodology of using that, because what we would always hear is, oh, well, people can just get a restricted license. And people like Mr. Zane and other clients that I've worked with at the Center for Urban Families, at my former employer at the Job Opportunities Task Force, we're on calls for a very long time trying to negotiate with the Child Support Administration, and they were not given these things, even though they made the case specifically. I know Stacey can talk more to that as well. So that's the reason why we have the language as it is now. So we can just go ahead.
Yeah, I agree with everything Chris said. And I guess the MVA would be the ones that they technically have the authority to do that, but they don't, because anytime, and you talk to the MVA about a driver's license suspension, if it's for child support, they will say you have to talk to the child support agency. So there's no real method to actually get that work restricted license. And then the agency will just say, oh, pay an amount of money that it's different amounts of money for every person. It depends. And I do appreciate your point that it really does stop people from being involved parents. Like Mr. Smith told me his daughter asked him, you know, to help her to learn how to drive. She's 17 years old. And he said, I can't because my license is suspended right now. And anyone who has children knows that there's a lot of other ways to be an involved parent. Like, of course, finances is a big part of it, but there's a lot of other ways to be involved if unfortunately your circumstances are that you cannot contribute financially at that time.
Okay, thank you. To the delegate, the bill drafter indicated that there will be 29 jobs needed. Is that correct? 29 additional employees to take under this legislation. It's in the fiscal note.
I don't have an opinion about the fiscal note one way or the other. I don't see how 29 new jobs are necessary when I believe they can work within the amount of employees that they have. But again, that's something for them to work out within that agency.
Okay, the only reason I brought it up is because the agency's letter didn't speak to positions at all. That was really why I was trying to get a little bit more information on that side of it. And then the last item, just wanted to say to Mr. Smith, thank you for coming. And I say that because, you know, being in the trenches and in the community with our constituents, you know, a lot of people say a lot of things like, you need to fix this, you need to fix that, but they don't always take the next step and come to the table and be a part of that decision-making process. So just know that your voice is important. And then the only thing I'll ask you to do is once this bill, if the bill passed, to go out into the community and educate others, to let them know what we have done a state law change if, you know, if in fact it passes, okay?
Thank you. I definitely will.
You're welcome.
Thank you, Mr. Chairman. Thank you, delegate and panel for coming in. So the bill, as I'm looking at it here, is 2 years. Is that correct? On line 25, I think it is on page 5. And we're striking that with the amendment on page 5, strike beginning with it in line 25 down through the period in line 27, according to the amendment. Is that correct?
That's correct.
So
Yes,
this
sir.
does change the posture of this bill.
Yes.
You wait, just, that's fine. Yes, it's fine. Yes, it's fine.
I don't
Can you
understand your
speak to-
question.
That's okay. Can you
Okay.
speak to the fiscal note that says it'll be approximately $2 million to do this?
And no, I cannot speak to the fiscal note.
Okay.
But just to acknowledge that to exactly what Delegate Sample Hughes said, just to, when we were having our meetings with DHS, these conversations did not emerge. And unless you see that in their letter,
I'm looking at this right here.
the fiscal note.
It's a state fiscal note.
I'm
I'm
yes.
in favor of this bill.
Oh, yeah, no, I know. Yes,
Okay,
yes.
so you should
yes.
leave it alone. Thank you.
Yes, sir. Thank you, Delegate.
Thank you.
Seeing no further questions for this panel, thank you very much.
Thank you, Mr.
I'm going to
Chair.
go to Michelle Smith now.
Thank you all so much.
Thank you. Michelle Smith on the next panel, Cam Bridges, Zachary Alberts, Trayvon Jackson, April Hamilton. Corrine Berry. Those are all the people who are signed up to
Yes,
testify.
Miss Berry, I think it's Miss Berry, a lady named April, and Trayvon are not available to testify.
All right, that's fine. We'll start with Ms. Smith and go from there.
Thank you so much, Mr. Chairman and Madam Vice Chair. I am here on behalf of the Maryland State Bar Association Family Law Section Council. My name is Michelle Smith, but my name could be Delegate Conway because I also am in favor of this bill. We urge a favorable report for all of the good reasons that have already been stated. Thank you.
Good afternoon. My name is Zach Alberts. I'm a resident of District 46 and the Senior Manager of Strategic Initiatives at the Center for Urban Families, a workforce and family strengthening program in Baltimore City. We urge you to support House Bill 813, which repeals the punitive and self-defeating practice of suspending driver's license for obligors making less than 250% of the federal poverty guidelines. At the Center for Urban Families, we help individuals that live in the most underserved, underrepresented, and disconnected areas in Baltimore City. As you have heard in previous testimonies for both this bill and others, 92% of jobs in the Baltimore metro area take an hour or more to get to on public transportation. That's if the buses come on time. As our clients climb their way up the economic ladder, a car is more often than not the first significant purchase as it opens up a world of economic and parenting possibilities. Jobs that require driver's license, like qualifying for your CDL and operating an 18-wheeler, are some of the most popular paths out of poverty for our members because they have relatively low barriers to entry and pay upwards of $80,000 a year. These license suspensions unnecessarily and unproductively block access to high wage earning employment and parental involvement. A 2020 study by the Baltimore Sun found that the average child support arrearages of 1,700 non-custodial parents in CFUF's 21217 zip code was $16,500. That is 45% of that zip code's annual median income. For CFUF clients, those average arrearages are closer to $24,000, and those same parents reported being out of work 18 of the previous 24 months. Our clients are doing the right things. They're striving to be better parents, better community members, and better citizens. Suspending their license because they cannot keep up with a debt that is almost half their income doesn't make it more likely that they'll pay it off, it makes it less. The purpose of child support laws is to help Maryland families and children. This practice only hurts them. I urge a favorable report for Bill 813. Thank you.
Good afternoon, Mr. Chair, Madam Vice Chair, and members of the committee. For the record, my name is Cam Bridges, and I'm the Senior Public Policy Advocate for Job Opportunities Task Force. And I just want to take this opportunity to illustrate, for the sake of discussion, exactly how much 250% of the federal poverty level is, or rather how much it isn't. According to MIT's living wage calculator, a living wage for one single adult in Maryland with no children is $51,000 rounded down to the nearest thousand. Again, 51,000 is what you need just to get by as a single person with no children. 250% of the federal poverty level is 37,000, which is only 72% of a living wage, again, for a single person with no children or dependents. For $37,000, you cannot meet the income requirements for a $1,400 a month Baltimore City apartment. Not a safe apartment, not a clean apartment, just the median apartment in Baltimore City. And Baltimore City is a low cost of living area, 12% lower than the state average. If you live elsewhere, obviously on average, the cost of living will only be higher. The Marylanders that find themselves in these situations need all the help that they can get, and they certainly cannot afford any financial setbacks. An estimated 80+% of Marylanders drive to get to work. A lost license for these people is a lost job. And at its core, this bill is really quite simple. It's let's let poor Marylanders continue working. And if they're already drowning, let's not confiscate their life jackets. We appreciate the opportunity to speak and urge a favorable report. Thank you.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. To the last gentleman that testified, we're brainstorming on this $2 million. Do you think it's reasonable for the state to ask for $50 or $100 to have your case individually reviewed as a fee when you apply?
I would defer to the expertise.
No, you have no personal feeling about it?
I don't necessarily want to speak out of turn, but we can definitely connect.
No, it
later
wouldn't be
to
a
have
speech
further
out of turn.
discussion.
We're talking on the bill. Go ahead. Anybody want to speak on it?
My personal feeling is that our clients, $50 to $100 is a week's worth of groceries, and that to give them the ability to, continue to earn a living, you don't want to add additional costs there.
Yeah, I understand. Would you agree that driving is a privilege?
I think that for the Baltimore metro area, driving is a prerequisite to be able to maintain and secure steady employment.
Okay, well, in my contact with police, law enforcement, they always told me driving was a privilege. So I thank you very much.
I support this bill, but I do have a question for any of you to answer. But just one of you for time's sake. I agree that suspending people's license is not the option, not an option, not a good option, because it suspends their ability also, in addition to suspending their license, it suspends their ability to make a living. But at the same time, they do need to be making payments because children need to be clothed and fed and other basic needs like that. So while I support this bill, do you have better alternatives that you think would be better, because like payment plans or wage garnishments, or what are some less punitive ways that child support in your view can be paid? Because it does need to be paid.
I can take that. This is just one of many enforcement tools that folks have for individuals that are behind on their arrearages and intentionally not paying it. We just don't think this one is appropriate in the case that a person is making less than $30,000 a year. There are other options like wage garnishment that allow both the state and the families to catch up on the arrearages and get the monthly owed.
To clarify, I do support this bill, but I wanted an alternative which you provided, and that's wage garnishment. Thank you.
Vice Chair. This is for Ms. Smith. Hi.
Hi.
Wouldn't it be helpful if when we got a fiscal note with this high of a price, that we also got some indication of what the revenue could be to offset the fiscal note?
Yes, in theory. I'm not intimately familiar with how the fiscal note was prepared for this particular bill. What information was factored in either to come up with the $2 million, the 29 positions, whether the enforcement agency was consulted as to whether they would need 29 positions. But absolutely, if none of that happened, then obviously the support enforcement agency should be consulted to redo the fiscal note. But yes, I think that if we are going to be
coupling this bill with HB 311 so that there is a much better way
Well,
to
hold on, before we go
enforce.
there, we've already been advised not to
Okay.
confuse the two. But what I want to know is, I guess what I'm getting at is, isn't there a revenue component to allowing people to drive and go to work?
Absolutely. So just the basic philosophy of this bill would put people back to work. Instead of having their licenses suspended, they could make their wage payments, whether, if they're working at a place where they can have garnishment, that's even better because they don't have to do anything to make a payment. They don't have to write a check. It's literally taken from their check. So if they're able, if Mr. Smith or Mr. Zane, I'm not sure what his proper name is, but if the witness that testified was able to go to that interview and get that job and have the possibility for wage garnishment, there wouldn't be a problem. He would be back on track. Whereas through his testimony, you heard that he couldn't do that. So he's continues to be below the poverty level. Therefore, he's in the lane of this bill. So
Right.
it's a tragedy. Yes, they should be
Right.
allowed to work.
Thank you.
The vice chair opened up a Pandora's box for me. I'm sorry. My undergraduate degree is in accounting and finance. And as an accounting and finance major, I find the way we do fiscal notes really, they do not inform. Because, Madam Vice Chair, almost every bill that we come through and we bring, there's a fiscal note that says I need X number of people, but it takes into no consideration the potential for revenue or the potential for offset. None of them do. But now, having said that, I'll get off of my soapbox on that one, and I will ask a question. Yes, Mr. Chair. I don't usually go off on a rant, Mr. Chair. I'm sorry. I know. But I will say this. My sense with the child support enforcement is that it is a broken system. It is a system that says you have a certain amount to pay every month, whether you have a job or not, whether there was a change in circumstance. And once you share the change in circumstance, it could be months before there is any adjustment to your child support payment. It could be years before there is an adjustment. And then therefore, you are building up these arrearages. And so the system in and of itself, in my estimation, is broken. Isn't that so? Thank you, Mr. Chair.
Thank you.
He gave you the look.
Other questions for this panel? Seeing none, thank you very much. That concludes the testimony on House Bill 813. Delegate Crutchfield, two bills. 644 and 648. Nope. It is in Atlantic, Canada, I guess, but it's not here.
Natasha, sit next to me and then.
Okay, and a panel, and let's go.
All right.
Rebecca Bevins is coming on virtually.
Okay.
If possible.
Okay, great.
Thanks.
All right. So we're towards the end of the day, so bear with me. Colleagues, Mr. Chair. For the record, I'm Delegate Charlotte Crutchfield. I represent Montgomery County's District 19. And I'm here to support HB 644, which is really called the Caretaker's Bill of Rights. So I want you guys to just imagine yourselves being subject to an alleged neglect or child abuse situation and what happens next. Usually a caseworker comes to your house, usually unannounced, knocks on your door, you open the door up, you're getting your family ready for the day, and suddenly they're walking in on you. They're just kind of bombarding you and coming in your door. You have no idea what's going on. They may have
introduced themselves and may not have, but nonetheless, they're coming in. And they want to do several things. They want to start an investigation, but you don't know what your rights are. So you let them in because you don't want any consequences with this. And what happens next? Well, your house could be ransacked. Your child could be almost strip searched, and in some cases, possibly strip searched to see what abuse, what bruises, what is going on. But you have no other alternative here but to let this happen. And so what this bill does is it is trying to empower people to understand what their rights are in these situations. That they actually have a right to tell somebody they can't enter their house. They have a right to actually have an attorney present or at least review anything with an attorney. That they can stop this at that point and say, no, I will not be subject to this anymore. And so that's what this bill is really all about. It's some enumerated rights. And as you read the bill, you will see those rights. And I will also let the panel, discuss some of those rights as well. But I am here to say this is all about empowerment for people who are under these kinds of investigations. And again, you will hear more detail about investigations, what usually happens. A lot of times, families are really not determined to have committed any kind of abuse or neglect, but yet they are subject to this kind of investigation and this kind of, interrogation and invasiveness. So I hope that you will find a favorable report for this bill, and I'm going to turn it over to my panel.
Thank you. Good afternoon, Chair and members of the committee. My name is Natasha Calfany. I am an attorney at the Office of the Public Defender. I am asking for a favorable report on HB 644. I did submit written testimony, and so I really just want to highlight a couple of things from my testimony. And most importantly, I just want you all to understand that this bill does not put children at risk of harm. If you look at the bill, page 2, line 10 says DSS has 24 hours to respond to physical or sexual abuse and 5 days to respond to allegations of neglect. So these are not issues of emergent circumstances. As you look further down on page 3, line 15, it requires workers or law enforcement to provide parents their rights except as otherwise provided by law. So I wanted to highlight what those other laws are. Courts and Judicial Proceedings 3-814 says a child can be taken into custody if there is a reasonable ground to believe the child is in immediate danger. This bill would not change that. Family Law 5-709 also gives DSS the permission to enter a household, even if they have been denied access or entry, if they have probable cause to believe a child is in serious immediate danger. So again, this bill does not change when the Department of Social Services and or law enforcement believes that a child is in danger. Typically, the investigations of the department are non-emergent situations. DSS has 60 days to complete an investigation. The vast majority of their investigations are not emergencies. They can provide parents their rights without jeopardizing the safety of the child. And lastly, I just want to let the committee know that the Office of the Public Defender is already doing this type of work, and I would welcome any questions regarding the impact that we're having. Thank you.
Good evening, Delegate Clippinger and members of the committee. My name is Shanta Trevetti. I'm a parent and an assistant professor at the University of Baltimore School of Law. I teach, research, and write about the child welfare system. I'm also the faculty director of the Meyerhoff Center for Families, Children, and the Courts, and we urge you to support HB 644. I think it is crucial to understand how an investigation may begin and what happens once commenced. Anyone can call a hotline and accuse you of abuse or neglect. Your neighbor with whom you've had an argument, your ex whom you're battling for custody, or your abusive ex-partner who wants to use Child Protective Services as a way to continue to control you. Once the call is made, CPS can knock on your door at any time. Delegate Crutchfield already shared what it is like from a parent's perspective, but I want to share from a child's. Imagine you're a child and in the middle of the night, someone bangs on your door. You are awakened and you hear your mother speaking in a frightened tone. A stranger comes to your bedroom and says they want to ask you a few questions. You want your mother. They tell you your mother has to stay away. They ask you if your mother has a boyfriend. They ask you if your mother has a lot of boyfriends. They ask if you've ever seen them engage in sexual activity. They ask if your mother drinks alcohol. They ask if your mother uses drugs, if you go to school regularly. They ask if your mother has ever hurt you. They ask if you always have enough food to eat. What does your mother feed you? Is it always fast food like the empty Happy Meal sitting on the counter? They ask to look under your shirt. You don't want them to. You're embarrassed. They say they have to make sure you have no bruises. You tell them that your mother has never hurt you. They leave and your mother is sobbing. The next day they come to school and pull you out of class. Everyone whispers about you and jokes that you'll be a foster child because your mother beats you. Your mother has never beat you. Certainly many calls deal with physical or sexual abuse, but this is the minority. Most deal with neglect, a vague concept that can include things like mental health disorder or substance use, but it can also include not having adequate food, shelter, or childcare. Crucially, as Ms. Company already explained, I'm done. The law already has provisions that allow for emergencies. The vast majority of cases where there is no emergency, it allows parents to understand their rights and to protect their children from this harmful experience and to consult with an attorney before deciding how to proceed. Because HB 644 would increase child safety, I urge you to issue a favorable report.
Thank you, Mr. Chairman and members of the committee. My name is Baylul Golthan, and I'm both a mother and an attorney at Maryland Legal Aid, the largest provider of free legal services in the state of Maryland. And I am here to urge a favorable report on HB 644, which, if enacted, will ensure that parents and caretakers are aware of their rights during these important but invasive investigations. Maryland Legal Aid represents some of the most vulnerable people in our state. Our clients are almost entirely low income, they are often non-English speakers, and they are often survivors of domestic violence. They are also children who have been declared by the state to be children in need of assistance following findings of abuse or neglect. As such, we are uniquely situated to appreciate the need to balance the state's undoubtedly important role in protecting children with protecting the fundamental privacy and due process rights that we all enjoy. And we believe that HB 644 does balance those important interests appropriately. The main purpose of this bill is to put people on notice of rights that, as my colleague said, they already have. Currently, many are too scared to do anything but comply when faced with CPS agents. One client told me, when you hear CPS, you hear that someone is coming to take your children. It's like what people say when police hold them at gunpoint. I just did whatever they said because I was terrified and didn't want my baby in foster care. I won't repeat the statistics from my written testimony, but we know that the vast majority of investigations initiated by CPS here in Maryland are closed without a finding of abuse, but that does not mean that these investigations are closed without causing harm. Currently, our clients and their families are brought in for interviews, their homes are entered, their children may be interviewed, photographed, and examined by strangers, as Professor Trivedi said. One client's 6-year-old was removed from her home for a month after the child's father, during a contentious custody case, falsely reported that the child was being raped by her older half-siblings, our client's other children. Our client did not know that she had the right to refuse to sign the safety plan she was presented with by DSS agents, which mandated that she stay away from her child. After multiple invasive genital exams of this 6-year-old, interviews with the rest of the family, several days of missed work to cooperate with the investigation, allegations were not only unsubstantiated, but the abuse was ruled out. Still, over a year after that investigation was closed, that little girl's siblings would not speak to or be alone in a room with her after what they had been accused of. These are just some of the lasting effects of an investigation that their mother had no idea she could protect her family from, and we urge a favorable report.
Questions, Delegate Erican.
Thank you so much, Mr. Chair. Thank you guys so much for being here. This is really great testimony to hear. And I guess my question is sort of how do we balance? So I know I guess when they show up, what happens now? If this bill passes, how do we balance like the risk? Where's the line for imminent danger? Where does that line, what does that look like? Is it not sex abuse or, like her story? I'm wondering, so what happens in that scenario if this bill passes, essentially?
So if this bill passes, the only thing that changes is before that investigation starts, the CPS worker would have to advise the parent of their rights. If the parent refuses entry into the home or refuses to cooperate, that doesn't necessarily stop the investigation. That just gives the parent time to talk to an attorney and be further advised of what their options are. Right now, the Office of the Public Defender has what we call a pre-petition program where people who are at risk of having a CPS investigation or are in a CPS investigation can call our hotline, get advice from an attorney, as well as services from a social worker. In those instances, when people call us, they have questions. Do I have to do this? Do I have to do that? And we advise them of the things that they do have to do and things that they don't. And usually that calms their nerves enough to have those conversations with CPS. And they do cooperate, but it also protects them from sending their kids to live somewhere for an indiscriminate amount of time and not knowing how to get them back and things of that nature. But the investigation goes on. The CPS worker can contact the school, contact other family members, talk to the child at school, all of those things.
And then, so this is OPD that provides this?
Yes.
Okay, and is the idea that when they show up, they sort of would make sure that the, I don't even know what you call them, client, patient, citizen, that knows that OPD is providing this to them? Would you have them tell the person?
Are you thinking of the actual written notice that would be mandated?
Yeah, like how will they know where to go to get the help if they don't have a private, I mean, it's very hard to find private attorneys to do this work, period. It's almost impossible, actually. So the option is, OPD or bust, I think, in many cases.
It really kind of is at this point.
Right.
But with providing the notice, and the Office of the Public Defender will work with DSS to provide, the appropriate type of notice and how to get in contact with us, as we are the agency that represents these parents in the majority of the cases anyway. And we're kind of out in the community already, letting people know that we're out there and this is what we're doing. So we have tried to establish a partnership with DSS. DSS knows that we're out there and they too can refer, clients as they have contact. That's the goal. Read them their rights, refer them to us.
Perfect.
And then we'll walk the parent through the investigation.
Okay. All right. Thank you, guys. Thanks for working on this.
Further questions? Seeing none, thank you very much. Is there anyone else to testify on the House bills? Yeah, okay. I thought there was one more. I should have included you the first time, but we'll have you come on up right now. What's your name again?
Christina Hawkins.
All right, there we go. Thank you very much. I don't believe there's anyone else who's signed up. Is there? Okay, go ahead for 2 minutes.
Okay. So my name is Christina Hawkins. I am the statewide peer support manager for the Office of the Public Defender. I supervise parent advocates in our parental defense division. Parent advocates are people with lived experience who assist mothers and fathers involved with the child welfare system, and they help them navigate. On February 23rd, 2018, a woman who identified herself as a CPS worker and a police officer knocked on my door. I answered the door and I allowed these strangers into my home because I had no reason not to. I had been taught that police were here to protect and serve. I had never been in trouble with the law and had never had any contact with Child Protective Services in the past. The CPS worker said they were at my house because they had a report for suspicion of use. They did not ask me to take a drug test, nor had I taken one before. They looked around my house and found no risk of harm. My 3-year-old daughter was laying on a made bed in her own room in a home that I owned. The caseworker then walked outside and made a call. When she came back in, she said I had to sign a safety plan and agree to give custody of my child to someone else, or they were taking her to foster care. I began to panic. I didn't know that I was entitled to representation or that I had options and rights. I signed a 60-day safety plan that ended up with my being separated from my child for 3.5 years. Parents are entitled to know that they have the right to get advice from an attorney before signing away custody, so they understand the risks involved in a life-changing legal matter. The department abuses their power by not informing parents of their rights and takes advantage of individuals who wouldn't know any better. If HB 644 was in place on February 23rd, 2018, I would have been able to plan accordingly for my child in a way that didn't traumatize us. I would have been able to consult someone to find out exactly what was about to happen to my life. Today, I stand before you with 5 years clean, 2.5 years reunified, a milestone I was told I would never achieve. And I can tell you with certainty that the day my daughter was tragically pulled from my arms was the most confusing, emotional, and traumatic day of both of our lives. Today, I work to ensure that others don't face the same trauma that I once had to.
None, thank you. Thank you very much. That concludes the testimony for House Bill 644. Now 648. Michelle Smith and Charlotte Delegate Crutchfield. Oh, boy. Delegate Crutchfield.
It's definitely towards the end of the
Yep.
evening.
Slipping.
All right, once again, colleagues, thank you for bearing with me on this. Chairman Clippinger. So we have the final bill that I present this evening, and that's HB 648. And that is dealing with the actual income for child support determinations. So this bill is a little interesting because this is really all about equity. There are instances where in the child support well, first of all, let's go back to this. The child support determinations are based on actual income. And what the judges must use for that is your gross up income. But there are instances where people actually only get paid a net amount. For example, if you work for the World Bank or IMF, that's what you get. And so the courts do not have discretion to gross that up. So this bill is about giving courts discretion to do that so that there is now an even playing field when it comes to child support. Both parties' earned income will be viewed the same way. And that's what this is all about. And I forgot, I should add, for the record, I'm Delegate Charlotte Crutchfield from District 19, Montgomery County, and I am looking for a favorable report on HB 648. Thank you.
Thank you, Mr. Chair, Madam Vice Chair, wherever she may be, and Delegate Chair Crutchfield. My name is Michelle Smith. I'm here on behalf of the Maryland State Bar Association Family Law Section Council. I represent the attorneys that are members of the section that practice in this area every day. We do divorce, we do custody, we do child support issues. This bill is a legislative fix, and the courts have indicated that you guys need to fix this problem. The problem is that in certain as the delegate explained, in certain circumstances, parent A makes W-2 income. And so therefore that parent is paying taxes, federal, local, state, FICA taxes, as most of us do, on that W-2 income. So when we put that parent's income into the child support guidelines, the guidelines algorithm, which you all are familiar with because you recently passed a renewal of that and a revision of that, that algorithm assumes that you make W-2 income that you're going to pay taxes on, okay? The other parent, however, works for the World Bank. And those of you that represent people from Montgomery County and PG County, which is a lot of you here, the World Bank is in DC. So our citizens in Montgomery County and PG County who work for the World Bank, their income is not W-2 income. They do not pay taxes, federal, local, state, county, FICA taxes on that. So when you're comparing the two, they're not the same. The person who works for World Bank, their income is much lower because they're not paying taxes on it. So what we need to do is we need to allow the courts to gross up the parent's income that is earned income that is not taxed. Therefore, we urge a favorable report to HB 648, and I will take any questions because that's complicated. Even though you're tired.
That's why she's sitting here.
Ms. Smith, I think we all are sometimes make mistakes, and so just to be clear, when you were saying PG County, you meant to say Prince George's.
I did.
All right.
Forever. I'm forever apologetic about that.
You're welcome. Okay, thank you very much. All right.
Yeah.
All right.
In the interest of time, I used a shorthand I should not have.
How dare you? Are there any questions? Seeing none, thank you very much.
Thank you.
That concludes the testimony on that
HB
bill, House Bill 648. I don't see Delegate Williams. Uh-oh. But that's okay because I think we'll go to Delegate Simpson. Simpson is here and there are people waiting for that and there are fewer of them. So we're going to get them out of here. Sorry. So Delegate Simpson, Melanie Shapiro, Lisa Jordan, Brett Engler, Debbie Feinstein, and Michelle Smith. We'll just take everybody. I believe Ms. Smith is favorable with amendment. Everybody else is listed as favorable. This is House Bill 406.
Once again, good afternoon doesn't make sense, so I'll make that good evening instead, Chair Clippinger and Vice Chair and fellow members of the Judiciary. I am here to ask for a yay vote on House Bill 406, Marriage Confidential Communications Criminal Charge. Let's be clear, we are trying to make sure that we have the same protections for married individuals and not married couples. The current Maryland code states that a spouse is not competent. I would love to change that part, but that's not what we're doing. To disclose any confidential communication that occurred during their marriage, including disclosures of a crime against the other. Also, this law has remained unchanged since 1973. So if anyone here thinks that we already changed this, we didn't change this section of the law. Yes, last year, this body made a commitment to empower victims, especially those victimized in their own marriage, by repealing the spousal defense. However, this little piece of legislation of making them not competent to disclose that makes that kind of difficult. So House Bill 406 addresses this by saying that an alleged victim of a crime perpetrated by their spouse is considered competent to disclose the confidential communications that happened during their marriage if it is relevant to the criminal charges. And to be clear, it doesn't require it, it allows it. So if I want to make sure that I report that and I can testify to that, it is up to me. It does not require it, which it may for the non-married folks. Abusers often do communicate their intentions to inflict harm, or they will express their remorse after they've choked them to near not life. And Maryland is among the minority of states that do not have this exception in statute related to the spousal confidentiality privilege. And with that, I would be so happy at this late hour if you all would love to do a yay vote for House Bill 406. And I will allow my panel to give you the examples of why it's important.
I can go. I'm Brett Engler. I'm Chief of the Domestic Violence Unit with the Frederick County State's Attorney's Office. I'm here on behalf of the DVCC of Frederick County and MSAA, State's Attorneys Association. And we're firmly in support of this bill. As Delegate Simpson said, and I thank her for bringing the bill, we're only one of 5 states that does not have an exception for the confidential communications privilege between a husband and wife. So for the attorneys in the room, there are 2 privileges. There's a testimonial privilege. So I, as a wife, can testify against my husband if I choose to, no problem, as to what I saw, what happened to me. But so let's say it's a marital rape. I can testify as to what happened. He raped me. We were in this room. This is what happened. Oh, but then he apologized to me and gave me a letter saying, I'm sorry I raped you, but you deserved it. I go to trial. I say that this was forcible. Husband gets on the stand and says that it was consensual. She's a liar. I cannot bring this apology letter into court unless my husband agrees. How is that fair? Because I'm not competent to do that. We have to change this law. 1974, almost every other state has changed it, and we urge a favorable report. Thank you.
Good evening, Mr. Chair, members of the committee. Melanie Shapiro with Maryland Network Against Domestic Violence, here in support of House Bill 406. I think it's late, and I don't want to reiterate what anybody else said. I think the importance of this bill is the autonomy that it empowers a victim to decide what it is that they want to share or not to share. It should be their decision. So we urge a favorable report.
Good evening, Mr. Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. Debbie Feinstein asked me to also convey that I could express her support for House Bill 406 and the support of the Montgomery County State's Attorney's Office. She apologized. She had a meeting that she had to attend. But last year, after 5 years, you all finally said that marriage is not a defense to sex crimes. In order to prosecute it, we really need to pass House Bill 406. Everything else I was going to say has already been said, so I will simply ask for a favorable report on House Bill 406.
Thank you, Mr. Chair, members of the committee. I'm here on behalf of the Maryland State Bar Association Family Law Section Council. We urge a favorable report. We did indicate in my written testimony some concern that was raised to me. Some of you may know I was a prosecutor for 20 years before I delved into the family law pool. And I am firmly in support of this bill. Some concerns that were raised were just the relevancy that the testimony would be related to the crime. So for example, when I was a prosecutor, I prosecuted a woman who ran over her husband with a car, and then there was some other criminal activity that she was involved in, and he wanted to testify about that. I'm not so sure, Maryland tax fraud is related to the terrible assault that this husband underwent when he was ran over by a car. And I'm sure that's not what we're trying to do, and that it wouldn't even be relevant or admissible testimony in court. But those were the concerns that were raised. So if there was some word smithing that needed to happen, I'd be happy to work with a sponsor on that. But we're favorable for House Bill 406.
Thank you, Mr. Chairman. Thank you, delegate and panel, for coming in. To good delegate. Is there a grandfather clause to this bill?
No grandfathers are in here.
Oh, yeah, they are. I'm in here.
October 1st.
So, my reason for, okay, but the reason I'm asking you this, because if you marry someone on a contract, let's say you're religious and you proclaim to be a Christian, and you say the two of us become as one, then I wouldn't testify on myself. So if I already married you and this law becomes, well, this concept becomes a law, that changes the nature of our agreement.
Well, just like any other, it's going to go
asking.
into effect.
I'm answering your cynicism, I believe.
Okay, it's going into effect in October, I believe. It's not retroactive. And also as a preacher's wife, well, let's separate church and state from this. We want to make sure that everyone is equally protected.
Okay, so what I'm asking you, if you're married before this bill is enacted, if it passes, and you are the type of Christian that believes that the two bodies are one, then anything that happened before this bill becomes active, would that be exempt?
I would be happy to take this offline about what the Bible says, because,
To do that.
okay, because they're not supposed to beat you either.
No, we're not talking about beating you. We're talking about, see, you want to go to an extreme. We're talking about marital rape and unauthorized sex and unauthorized touching. I'm just trying to be mature and adult about this conversation. So I'm not talking about harming your wife. I'm not talking about that. I was just asking the question. So because I believe if you're going to take a vow, you should have a clear understanding what that vow means. That's all I'm saying. Yeah, so thank you very much.
Further questions? Seeing none, thank you all very much. That concludes the testimony on House Bill 406.
Thank you.
Now we'll go to the final bill for the evening, House Bill 813. Nope. 833. All right. Can't read anything now either. Right. There are many witnesses. I'm not sure how many are still here, so let's find out. Ms. Trivedi, Ms. Richardson, Mr. Kane, Ms. Kalfani. Okay, that's fine for the table. We're supposed to have two virtual, Mast and Jackson. All right, well, if we could bring in Carolyn Mast, that'd be fine. All right. Delegate Williams, please.
Okay, good evening, everyone. Chair Clippinger,
Vice Chair Bartlett, members of the best committee in the House. I am Delegate Nicole Williams testifying in favor of House Bill 833, known as the Child in Need of Assistance, Parents and Substance Use Disorder Treatment. This bill would allow children, create a presumption that children are placed with their parents or guardians while the guardian is receiving specific substance use disorder treatment. Proper placement will be done when the child's parents demonstrates that this is in the best interest of the child, and the child will still receive proper care and attention, and that this is not an emergency situation. And so I know that there are a couple of testimonies that you probably see there in your floor system unfavorable. You should have at your desk at least one amendment that kind of deals with a number of the concerns that have been raised. There's also a second amendment that's in your email, but we didn't have time to print it out for you this evening. And we believe with both of those amendments that it does resolve some of the concerns, actually resolves all the concerns that were raised by Maryland Legal Aid, that was raised by the Maryland chapter of the National Association of Social Workers. And so we believe that we have resolved all of those concerns by removing the outpatient treatment portion there in the bill and just adding a couple of additional guardrails that you will see here in the amendment with regards to compliance and releases signed by the parent. So I will let my experts really kind of go into this a little bit more in depth, but I believe that this is a great bill because we do want to make sure that that we're keeping the family unit intact as much as we possibly can. You know, life happens to everyone, and there are situations where someone does start to become dependent on some type of substance for whatever reason that is going on in their life. But because of that, we don't want to punish that individual for getting the treatment that they need to be able to kick that addiction. And we want to try to keep that family unit in place as much as possible, so long that it is in the child's best interest and the child's safety is intact. So that's pretty much all that I have, and I will let my experts take it from here.
Good evening. My name is Natasha Kaufney from the Office of the Public Defender. I'm asking for a favorable report on HB 833. This bill builds on or reinforces on law that already exists. Courts and Judicial Proceedings 3-818 states that a child is presumed sinner only if the child is substance exposed and the parent tests positive and the parent refuses the recommended level of treatment. 3-818 gives parents, specifically mothers, the opportunity to engage in and successfully complete treatment before their child could be considered a child in need of assistance. That law is already on the books. Even so, parents who give birth to substance exposed newborns are oftentimes and always referred to social services. Their children are removed, even when the parent has documentation that they are in treatment, and the only drugs in their system are methadone or Suboxone, which are drugs used to treat substance use disorder. HB 833 reinforces the law by making it a presumption that children are safe when their parent is enrolled in treatment. It is key that this bill addresses women who are currently enrolled in treatment. This bill will encourage more parents, specifically mothers, to obtain the necessary treatment to address their disorders when they know they will not continue to be penalized by having their child removed if they are already in treatment. There are residential mother-baby treatment programs designed specifically for this purpose, to allow mothers to get treatment while residing with their baby under the watchful eye of the program that often works in conjunction with DSS. For those reasons, we ask for a favorable report.
Thank you, Mr. Chairman, members of the committee. I'm Alexa Richardson, and I'm an attorney at in the Parental Defense Division of the Office of the Public Defender. I'm urging a favorable report on HB 833. In Maryland, new parents with substance use disorders are having their newborn babies taken from them even when they enter the recommended treatment programs. I work in Baltimore where I practice. I've had 2 such cases come in just in the last few weeks. It's happening routinely. Parents whose children are removed and then enter an appropriate treatment program are experiencing many months or years of painful separation before regaining their children. Keeping babies and children away from parents that are engaged in an appropriate substance use treatment program is harmful to mothers and children and totally unnecessary. I want to talk about the programs that are considered appropriate under this bill. These are mother-baby substance use treatment programs that are designed specifically to treat a mother while their child resides with them at the program. I'm not aware of any father-baby treatment programs in Maryland, so I'm focusing on the mother-baby programs. The kinds of protections in place at these programs, they're locked down facilities with staff at the entrance. Everyone coming or going must sign in or sign out. There's staff on site 24 hours a day. Staff make rounds every hour through the night to check on children in their rooms. There are daycares on site to care for the children while the mothers are in their treatment. The staff include mandated reporters who will call and report if there's a suspicion of abuse or neglect. And residents are routinely urine drug tested and will be discharged from the programs if they test positive. In other words, these are safe, protected environments designed for children to remain with their parents who are courageously focusing on their recovery. There's no reason to remove a child from a parent who's chosen to be in such an environment. When I discuss treatment with clients, their first question is, if I go to that program, can I get my baby back? This law would create a massive incentive for those mothers who so desperately want their children and send a clear message to them. If you enter treatment, stay in treatment, your baby will stay with you. Thank you.
Delegate Clevenger and members of the committee. I'm Shanta Trivedi, a professor of law and faculty director of the Center for Children, Families, and the Courts at the University of Baltimore, and I urge you to issue a favorable report on HB 833. I said that I research and write on the child welfare system, but one of my particular areas of focus is the harm of separating children and parents from each other. This is a bill that is based on data. During the family separation crisis at the southern border, we learned the profoundly harmful effect that separating a child from their parent has on the children, literally altering their brains for the rest of their lives. For newborn, studies show that the period after birth is crucial for them to bond with their parents and form initial attachments. It affects their emotional and cognitive development. Studies show that newborns prefer the sounds of their mother's voices over those of other women. If a mother is suffering from substance use disorder and her newborn is born with neonatal abstinence syndrome, research is clear that separating the baby from their mother makes things worse, not better. Babies who are placed in the same room as their mothers recover faster than babies who are placed in the NICU and treated with medication. Literally, the love and care of their mothers is the best medicine that they can get. This is not some emotionally charged narrative. It is a fact. Further, it is best for the mother as well. Punitive approaches such as removal discourage mothers from seeking prenatal care and substance use treatment out of fear. Further, when a child is removed, parents suffer from deep depression, which can exacerbate substance use disorder. When parents miss their children, they may turn to the very substances they are trying to avoid in order to cope. Supportive approaches where the child can be safely cared for and the parent can also get the health care that they need helps the child, the parent, and ultimately our entire community. HB 833 is a scientifically backed response to an unfortunate but real health crisis in our community. There is no question it is best for kids, particularly newborns, to be with their parents. We therefore ask that you issue a favorable report.
Good evening, Chair Clippinger, members of the committee. Thanks so much for speaking and listening to us tonight about House Bill 833. My name is Dr. Stephen Kane. I'm a family medicine and preventive medicine physician practicing in Baltimore, Maryland. I have thousands of hours of clinical care taking care of pregnant patients, patients laboring, newborns in the nursery, and folks with substance use disorder. House Bill 833 is simple. It's destigmatizing parents with substance use disorder. That's what the bill aims to do. Substance use disorder is a disease. It's not a choice or a moral failing. We have extensive studies, as already spoken about, that show substances change brain chemistry. It's remarkably different from other activities. And when someone's in active substance use, it's not as simple as just saying no. For those that don't know, the standard of care for substance use disorder treatment can be medications, can be hospitalization, maybe even intensive outpatient programs. It's no joke. But here's what I think is important. It's not unsimilar to other diseases. For example, diabetes, something that maybe arises during pregnancy, changes body chemistry and hormone levels, possibly leads to need for medications, hospitalizations, intensive outpatient programs prior to and after birth. It's a really hard to control disease. But I ask you, why does the code provide punitive actions for those with substance use disorder? who may be in a treatment program, but not diabetes? The answer is simple. It's stigma. This bill aims to remove the stigma and gives parents with substance use disorder the same dignity that we give parents with other chronic diseases. The first year of life is incredibly important. The American Academy of Pediatrics, the American Medical Association, other medical bodies have written extensively on the harms of separating children during this vital period. It increases the risk of mental health, developmental, and chronic health conditions that affect the entirety of the rest of the child's life. The action of separating children within the first year of life in the name of stigma is not a risk that we can afford. And I appreciate your listening, and I hope you take a favorable report on 833. Thank you for your time.
Ms. Mast, please, for 2 minutes.
Hi, good evening. Thank you, members of the committee. My name is Carlin Mast. I'm a licensed clinical social worker and social work supervisor at the Maryland Office of the Public Defender. Prior to my position with this agency, I've worked with pregnant and parenting people who use drugs in a variety of clinical settings. Pregnancy is a unique window of change for individuals who use drugs. Empirical research shows that people who use drugs and become pregnant, sorry, my son is being feral. Empirical research shows that people who use drugs and become pregnant overwhelmingly reduce use or stop use during pregnancy, either on their own or with the assistance of treatment. The American College of Obstetrics and Gynecology, American Society of Addiction Medicine, and Center for Disease Control and Prevention all agree that the gold standard of treatment for substance use disorders in pregnancy, specifically opioid use disorder, is opioid agonist therapy, also known as medication-assisted treatment. Pregnant and newly parenting people are encouraged to engage in residential drug treatment, which provides a safe and structured environment, ideally consisting of medication management and therapeutic intervention when entering recovery or abstinence. If the war on drugs has taught us anything, it's that criminalizing drug use is not conducive to overall public health and healthy families. When a pregnant or newly parenting person desires to engage in drug treatment, it's a positive parenting decision. It signifies that a parent is putting the needs of their family unit first. This decision should be applauded and supported by our institution. The reality is that it's often criminalized by child welfare officials under the guise of a benevolent concern for the child. Residential treatment facilities provide an extra layer of support for both the parenting person and the child. Residential treatment centers are full of other mothers and children, supportive staff, and clinicians who can provide support to the family unit. In almost no other situation is this level of support during the postpartum period accessible. Instead of viewing this as a strength, child welfare officials often overlook this and separate the family anyway. I can't count the number of parents that I've worked with who went through the lengthy hoops of accessing treatment only to be separated from their infants for very vague or unclear reasons. What message are we sending to people? To support recovery in the families impacted by drug use, we need to incentivize treatment, not further criminalize it. There's no better motivator for a new parent than their child.
Thank you. Questions now, Delegate Simmons, then Erican, then Connolly.
Thank you, panel. I wanted to speak to the doctor, if you don't mind. Just had some questions. So I spent a little time in law enforcement as well as working in the hospitals. And one of the things, obviously, I've seen cases where mothers have been going through the detox phase where they have to be separated from their kids while a lot of times in the emergency departments and things of that nature. What's the consideration to the mental health effects of what we're talking about here? Can you talk a little bit about that space?
I just want to clarify mental health effects for the mother.
Mothers that are going through these substance abuse withdrawals. And what are you seeing when it comes to mental health, and how do we factor that into the rehab phase of it?
Oh, certainly. Well, separation, with their child during the newborn period can be very stressful for them, and, can even set off any mental health, history that they may have. We're talking about things like postpartum depression in this time as well, which also plays in the substance use disorder, making it harder to sort of even recover as well. So making sure that we're staying with the child during that period is incredibly important.
But is that known to trigger more violence or violence towards the child with the fact that they're coming off certain narcotics?
Oh, I don't think there's any studies that have shown specific violence towards the children in the, period in which they're like detoxification or something like that. Yeah.
Also, if I might we're talking about situations where the mother is safely in the type of facilities that we've described. So we couldn't possibly envision a better scenario for the mother to go through any effects that she might suffer from withdrawal, and ensure that the child is absolutely safe, because there are other people there to assist with caregiving. So the mother can go through what she needs to go through to heal, and the child will be safely cared for by the people in charge of taking care of the child while the mother can heal.
Right. And so, and that's one of the amendments to the bill is removing the outpatient treatment. And this would only focus solely on the inpatient treatment.
Thank you, Mr. Chair. Thank you guys for being here. So you mentioned that so this bill's not going to include any outpatient options. It'll just be inpatient.
Correct.
How many beds do we have and do we need more? What are we looking at?
And so I don't know the exact number of beds that we have statewide, but I believe it's around 100. I think it's an issue for another day in a way, if those facilities become inaccessible after this law were to go into effect. At the moment, anecdotally in Baltimore, I can usually find a bed for someone that is ready to go into a mother-baby treatment program. They may need to travel a little ways, but there are beds available.
For the doctor. A couple of years ago, I was contacted by two people who had tested positive for using marijuana, but had never used marijuana. But it came out that they were actually using CBD oil and they had their babies taken from them. Have you guys addressed this at all in the hospital systems? I had a bill to try and fix it. Nobody wanted to do anything with it. But I feel like if we're not testing for THC, we're just doing cannabinoids. People that literally are not using drugs are losing their children. That's a little scary.
Yeah, actually, if you do look at a lot of the CBD products out there, some of them do actually have very, very low concentrations of THC, which is likely why they screen positive under that situation.
Okay, and so we're still doing that essentially. There's still a risk essentially for a mother who's quite literally doesn't even need a drug treatment program, just needs the proper test to be
That
done.
could screen positive. There are definitely false positives in other situations as well that happen clinically, and we have to sort of elucidate and figure out the cause of that.
So
Yeah.
can you figure it out? Because these two women literally had their babies taken for weeks because of this.
Unfortunately, there's a lot of bias that can go into that sort of conversation. And I'll let sort of other folks chime in if they have any other thoughts.
Yeah, like how do you prove that?
Well, if you recall last year, Delegate Williams sponsored a bill that made it remove the presumption that marijuana use is neglect. So in that way, cases like that shouldn't rise to the level of neglect the way that it would before that bill. So hopefully that's not happening anymore, but you should definitely let OPD know if it is.
Yeah. Yeah, absolutely. And
It's
also
happening.
It's still, even though we passed the law that went into effect in October, okay, well, we got to deal with that offline. But, and I also just want to reiterate the Department of Human Services, they did submit testimony favorable to this bill. And so they feel like they have the resources and the ability to be able to provide this care.
It really is an issue of education though at this point.
Thank you, Mr. Chairman. Thank you, delegate and panel for coming in. Just to be clear, high levels of THC in the system would not be considered in this bill. Is that correct?
No, I think what was referenced was the bill from last year where high
Okay.
levels of THC.
Then I'll go to my regular question. I noticed that alcohol is in this bill under the substance page 4, line 13. So what about THC positive?
THC by itself is not deemed neglect. If there's THC coupled with other factors, that could be found as neglect. But just the presence of it in and of itself is not considered neglect.
So the presence of alcohol would be considered neglect, but THC would not. That's what you're saying?
Whereas alcohol is, I mean, people can abuse alcohol
No,
just
it's
like
in
they
this-
can
it's-
abuse cocaine or anything else.
They scratched out alcohol and used the term substance.
Right, because we're trying to be more inclusive in our drafting of legislation and including all substances. So
All
we're
right.
we're categorizing as substance abuse disorder.
Thank you, delegate. To the lady next to the doctor, you said separating the mother from the baby makes a change in the structure of the baby's brain. Is that
Yeah.
correct?
Yes, there's a statement from the American Association of Pediatrics that came out after the immigration crisis at the southern border that talked about the long-term effects of family separation on a child's brain. And the kind of the level of stress called toxic stress literally changes their brains for the rest of their lives because the stress is so enormous.
What's your name?
Shanta Trivedi. I teach at the University of Baltimore School of Law.
Now, that comment, you didn't put that in your testimony, right? Is that right?
I didn't put in my written testimony, I don't think, but I'm happy to share it.
Send it to me. Thank
I
you very
will.
much.
Thank you, Chairman. Is it correct of me to understand that it's legal for the court to take a newborn child away from a mother, but it's illegal to take a puppy away from a mother's dog within 8 weeks?
I'm not certain about the puppy dog.
Well, I just read it
thing.
in one of the earlier things about.
Oh, I had went to the
Yeah.
little girl's room at that point.
I don't know about the puppy, but yes, the court separates infants from their mothers
Oh,
all
you
the time.
can't separate a puppy from the mother because it's damaged into a puppy. So the court is saying you can separate a child from its mother and it's not going to damage him or her. This is absurd.
We agree, Delegate.
Thank you.
Seeing no further questions, thank you all very much. I believe that's the last people to testify on the last bill of the night on House Bill 833. Thank you very much. We have a hearing tomorrow at 1 o'clock. It is virtual, so we'll be online tomorrow with the Health and Government Operations Committee for the End of Life Options Act. And then we will be back again on Tuesday next week with more hearings. That also at 1 o'clock. We are adjourned.
Oh, thank you. Appreciate it.